totally comfortable. I'm totally comfortable confirming what I've already said, Mr. Deputy Speaker. It provides Rwanda, as I say, will introduce an even stronger. She's got the chance to make a speech in just a few moments. She has got the chance to make a speech in just a few moments. It will have one Rwandan. The system of specialist asylum tribunals to consider individual appeals against any refused claim within Rwanda. It will have one Rwandan and one other Commonwealth co-president, and will be made up of judges from a mix of nationalities selected by the co-presidents. We have been working, and this comes to the point she's making about the money that has been spent by the British government. As is the case with many countries around the world, the government spends money capacity building with our international partners. And we have been working extensively with, I'm going to make progress, we have been working extensively with Rwanda to build capacity too. The treaty makes clear that anyone we locate to Rwanda cannot be removed from Rwanda to another country except back to the United Kingdom. It is binding in international law, and it enhances the role of the Independent Monitoring Committee, which will have the power to set its own priority areas for monitoring. The committee will have unfettered access to monitor the entire relocation process, from initial screening to relocation and settlement in Rwanda. Relocated individuals and legal representatives will be able to lodge confidential complaints directly with that committee. It is this treaty and the accompanying evidence pack that enables the government to conclude with confidence that Rwanda is safe. We will need to be certain that domestic and foreign courts will also respect the treaty. And that is why we have introduced the bill. And
I'm grateful to my right honourable friend. On that point on foreign courts, 5.2 of the bill says that it's for a Minister of the Crown to decide whether the United Kingdom will comply with the interim measure. Is the advice from the Attorney-General that it will be compatible with international law for a minister to refuse to comply with such an indication? Secretary.
Well, my right honourable friend, who is an expert proceduralist in this House, will know that advice from the AG to government is privileged, and I am not going to be sharing it at the dispatch box. But he will also know that the government's position is clear and unambiguous, that this is in accordance with international law. So he can rest assured on that. And I will give way briefly and then to the...
I'm grateful for giving way. Will he confirm that, in fact, as a matter of law, an interim measure under Rule 35 is directed not to the courts of the United Kingdom, but to the governments of the member states? So, therefore, what the bill says simply restates what is the position anyway. It's the member state that it applies to, not the courts.
Secretary.
My honourable learned friend is absolutely right. I will give way one more time, and then I will make more progress.
Thank you, Mr. Speaker. I thank the Home Secretary for giving way. He says he won't reveal the Attorney General's advice to the House. That's fine. But on the issue of the money, his permanent secretary was in front of the Public Accounts Committee yesterday and told us that, as well as the payment due of £50 million next year, there are payments planned for years 4 and 5. Is he willing to share with the House how much payment will be made to Rwandans in years 4 and 5 of this programme?
Secretary.
The honourable lady will know that we have committed to a reporting schedule which is completely consistent with other government departments, completely consistent with the reporting schedule of the Home Office in other files, and we absolutely intend to commit to doing that. So the reason we have introduced this bill, it builds on the Illegal Migration Act and complements all other measures that this government is employing to end illegal migration. The Safety of Rwanda Asylum and Immigration Bill makes it unambiguous and clear that Rwanda is safe and will prevent the courts from second-guessing the will of this sovereign parliament. It gives, I've got to make progress, it gives effect to the judgment of Parliament that Rwanda is a safe country, notwithstanding UK law or any interpretation of international law. For the purposes of the bill, a safe country is one to which people may be removed from the United Kingdom in compliance with all of the UK's obligations under international law. And I hope that will, reassure my right honourable and learned friend, and that are relevant to the treatment in that country of people who are removed there. It means that someone removed to that country will not be removed or sent to another country in contravention of any international law. And anyone who seeks asylum or who has had an asylum determination will have their claim determined and be treated in accordance with that country's obligations under international law. I'm going to make progress. I've been generous, but I want others to have the chance to speak. Anyone removed to Rwanda under the provisions of this treaty will not be removed from Rwanda, except to the United Kingdom, in a very small number of limited and exceptional circumstances. Should the UK request the return of any relocated person, Rwanda will return them. Decision makers, and that includes both myself or the holder of the post of Home Secretary, an immigration officer, or the courts, must all treat Rwanda as a safe country, and they must do so notwithstanding all relevant UK law or any interpretation of international law by courts or tribunals. And that includes the European Convention on Human Rights, the Refugee Convention, the International Convention on Civil and Political Rights, the UN Convention Against Torture and Other Cruel, Inhumane or Degrading Treatments or Punishment, the European Convention on Actions Against Trafficking in Human Beings done at Warsaw, 16th of May 2005, customary international law, and any other international law or convention or rule of international law whatsoever, including order, judgment, decision or measure of the European Court of Human Rights. The Prime Minister has been crystal clear that he and the government that he leads will not let foreign courts destroy this Rwanda plan and curtail our efforts to break the business model, of those evil people smuggling gangs.
I'm very grateful to my right honourable friend. He makes the point about foreign courts. But what about domestic courts? Is there not a danger that in pursuing quite stringent measures in this bill, that we are really testing the principle of comity to breaking point? This House and this Parliament is sovereign, but we also have the independence of the courts and the rule of law to bear in mind, and restraint on both sides by the judiciary and by this place is essential if we are to maintain the balance of our constitution.
Secretary.
My right honourable and learned friend, who knows I have a huge amount of respect for him, not just as a friend, as an individual, but also his experience at the bar, at a very high level within the bar. He raises an important point, and I want to give him complete reassurance that we have looked very, very carefully at the balance that he speaks about. We absolutely respect the importance of that. We genuinely believe this does get the balance right, although because of the growing nature of this extreme and perverse trade in human misery, we have to take firm action, and we are therefore acting in a way that maintains that balance. But it is novel. He says it's contentious. It is true. But we are doing it because we have to break this business model. We have to do this. We have to do this. When the European Court of Human Rights indicates, and this speaks to the point my right honourable friend made just a few moments ago, where the European Court of Human Rights indicates an interim measure relating to the intended removal of someone to Rwanda under, or purportedly under, a provision of the Immigration Act, a Minister of the Crown, not a court or a tribunal, a Minister of the Crown alone will decide whether the UK will comply with that interim measure. And in order to further prevent individual claims to prevent removal, the bill disapplies certain relevant provisions from the Human Rights Act 1998, in particular circumstances, including sections 2, 3, 6, 7, 8 and 9. This is lawful. This is fair. This is necessary, because we have now addressed every reason that has been used to prevent their removal to Rwanda. We have prevented asylum claims from being admitted with legislation that has... we have blocked asylum claims from being admitted with legislation that has already passed through this House. When the Illegal Migration Act is enforced, modern slavery disqualification provisions will assist with speedy removal. The only possible blocking of removal is if an individual can demonstrate with compelling evidence that there is an immediate risk of serious and irreversible harm to them in particular under their individual circumstances. This sets the bar, rightly, very high, so that the chances of that happening are, rightly, extremely small. Mr. Speaker, the only way to deter people from coming here illegally is to convince them that if they do, they will be unable to stay. Instead, they will be detained and swiftly removed to a safe third country or their home country if it is safe to do so. I'm going to conclude. I've been at my feet for a while. I'm going to conclude. This is how we will save lives at sea. This is how we will deter illegal migration. And this, Mr. Speaker, and the House should take note of this, this is how we will break the business model of the most evil and perverse trade that we currently can see, and that is the trade in vulnerable people. The people smugglers, they are not humanitarians, Mr. Speaker. They are vicious criminals, and we must take action to prevent them. This is how we restore confidence in our immigration system and assert full control over our borders. Let me conclude. I'm nearly done. Let me conclude. This is how we will overcome the intolerable pressure on taxpayers, on public services, and on local communities that illegal immigration creates. That's how we will make sure that the system is fair. Fair to those who play by the rules, and fair to the British people who are rightly sick of people arriving here from France in small boats. From France, a safe and wonderful country. Rwanda stands ready to welcome those new arrivals. They stand ready to find a solution, to work with us to find a solution on this global issue, rather than being part of a problem. And for that, I believe they should get our thanks and admiration. This is an innovative and humane solution to a growing global problem. Other countries are looking at what we are doing and are making similar plans of their own. A new treaty and this bill make clear in law that Rwanda is a safe country in which to relocate illegal migrants. And I want to extend an offer to the whole House. Colleagues across this House must know how much this matters to our constituents. Our voters, for whatever party they vote for, are warm and welcoming people to those in genuine need. And we've seen this, Mr. Speaker, we've seen this in the way that people across this country have opened their homes to many of the 500,000 people who have come here via safe and legal routes in the last decade. But the British people rightly expect everyone to play by the rules, and they expect us in this House to do what it takes to stop the boats. That is what voting for this legislation means. Our voters are horrified when they see images of people drowning in the Channel. They are horrified when they see those people smugglers taking advantage of people. They want an end to illegal migration. This government has a plan that will provide an alternative home for illegal arrivals to the UK and to deter others from coming here illegally, and I commend this bill to the House.
The question is that the bill now be read a second time. I now call the Shadow Home Secretary, Yvette Cooper.
Thank you, Mr. Speaker. Can I join with the Home Secretary in expressing our sympathy with the family and friends of the asylum seeker who has apparently died on the Bibi Stockholm, and I understand he cannot say more about that at this moment. But this should be a debate about how we prevent lives being lost, about how we strengthen our border security, about how we stop dangerous boat crossings, and how we fix the broken asylum system. Instead, we've just got total Tory chaos. What a fine mess this week Prime Minister has got them all into, and got the country into as well. Tearing lumps out of each other over a failing policy while they let the country down. We've had a Home Secretary sacked, an Immigration Minister resigning, and they've spent almost £300 million of taxpayers' money on Rwanda without sending a single person, and the Home Secretary seemed to confirm today that in fact that is £400 million without a single person being sent. More Home Secretaries sent to Rwanda than asylum seekers. It's about £100 million per trip. The Climate Minister called back from the Dubai COP for the vote. Well, I guess they can say at least one flight has taken off as a result of this legislation. The third Tory Home Secretary sent to Rwanda in 2 years, the third bilateral agreement with Rwanda in 2 years, and now the third Tory law on asylum and Rwanda in 2 years. And they're about to write their fourth cheque to Rwanda. Turns out they set out a direct debit. Hundreds of millions of pounds for a failing scheme that's only ever likely to cover a few hundred people. Less than 1% of those claiming asylum last year. For a failing scheme that's actually become a proxy for the deep civil wars in the Tory party, this carousel of Conservative chaos. We've got the European Research Group, the Northern Research Group, the New Conservatives, the Old Conservatives, the One Nation Group, the implausibly named Conservative Growth Group, and if you thought that was an oxymoron, we've also got the Conservatives' Common Sense Group too. I mean, seriously, so many fighting factions, but all with one thing in common: they don't believe in this bill. And the Prime Minister forced into an emergency breakfast meeting this morning less a smoked salmon offensive and more buttering them up with butties and bacon and a side briefing and backstabbing, promising them amendments and then rowing back, telling them he really wants to break international law, but the Rwandan government won't let him, hiding behind the Kigali administration because he is too weak to even defend his plan. Weak. The Prime Minister says his patience is wearing thin. Well, how do they think the country feels watching this chaos? He's hoping his party's going to calm down over Christmas, but they all know who the Christmas turkey is, and he's sitting in number 10. I will give way to the honourable member first.
John Barron.
I thank the right honourable lady for giving way, but the Prime Minister has come up with a plan. He's committed to it. We've had assurances from the dispatch box that all steps will be taken to stay within international law. Can I ask the right honourable lady, what is the official opposition's plan?
Yvette Cooper.
Well, I'd say he hopes that his Prime Minister has a plan, but in fact nobody on the backbenches from any side seems to actually agree with it at all. We're clear what we should be doing is using the hundreds of millions of pounds that the government is wasting in cheques written to Rwanda for nothing, for a scheme that at best will only send a few hundred people. Instead, we should be using that money to strengthen our border security, to go after the criminal gangs and to make sure that we clear the asylum backlog and save the taxpayer billions of pounds. Well, actually, he hasn't. The Home Secretary likes to claim that he's doing this, and he likes to claim that he's bringing down the number of people in hotels. But in fact, they've gone up to a record high, 56,000, since the Prime Minister said he was going to end asylum hotel use. In fact, they've gone up by a further 10,000 because he is failing. Now, let me welcome the new immigration ministers to their posts. One of them who's obviously been an immigration minister before. I think during the time he was immigration minister before, net migration trebled and the number of boat crossings also trebled, but I'm sure nobody will hold that against them. They've obviously appointed 2 immigration ministers, this time in case another one resigns, because he thinks that their policy is totally failing and is too weak. And I think, in the words of the ex-immigration minister, this new law won't work, doesn't do the job, and is both legally and operationally fundamentally flawed. I'll give way to the honourable member if he can say whether he agrees with the previous immigration minister or the current immigration.
Well, I'm grateful the Shadow Home Secretary is asking me questions. She's overestimating my ability. But this morning, talking of Christmas turkeys, the Leader of the Opposition gave a typical interview on Radio 4 this morning, which contained no government no policy whatsoever. Can she outline how she would reduce immigration and tackle the problems that she's castigating this government for, when everything that she says she would do, this government's already doing?
Yeah, the trouble is, except that they're not. They're just not. The scale of the government's operations around going after the criminal gangs is tiny. You know, the £300 million that the government has already committed to Rwanda, that is a third of the budget of the National Crime Agency. So that is the scale. They're prepared to put that investment into Rwanda, into this tiny scheme, to affect only a couple of hundred people, and instead they are totally failing to have a sufficient scale of investment in tackling the criminal gangs, in working with Europol, in going after the supply chains. There are warehouses of boats across Europe that the government, that the Europol, that the European police forces are totally failing to go after, that our party has said we would go after. We would work with Europol and we would get new security arrangements in place that, again, the government is failing to do. So instead we've got former Home Secretary who signed the last agreement and brought forward the last piece of legislation, saying it's fatally flawed and won't stop the boats. The backbenchers saying yesterday that the bill should have been pulled because it's partial and incomplete, and the Home Secretary, who privately called this whole thing batshit, is out to bat for it today, even though he knows it won't work. This is the Tories' asylum crisis. 5 years ago, we didn't have a major problem with dangerous boat crossings, but they let criminal gangs take hold along the channel. They failed to work with France at the beginning when they had the chance. They let smugglers spread their tentacles along the coast, organising dangerous boats that undermine border security and put lives at risk. And at the same time, they let Home Office decision-making collapse. They decided to downgrade the skills and experience of caseworkers, then shrugged their shoulders when productivity dropped. They failed to return people. They've let returns collapse, down by 50% compared to the last Labour government. What the next Labour government would do if we're elected is set up a new major returns unit with 1,000 additional staff to increase the returns, to actually make sure, rather than the total returns collapsing and their failure to actually return people who have no right to be here, our party would introduce a new returns unit to make sure that we have proper enforcement.
Order. Just shouting at the Shadow Home Secretary is not a good look. You should be listening to what she has to say. Yvette Cooper.
I will give way to
Voltaire giving way on her last point. Isn't this not just a fig leaf for a completely incompetent Home Office? I have a constituent who's exhausted his leave to remain. He wants to go back to Fiji. He applied to the Return Service in September. He gave his passport to the Home Office in December 2022. The local church is going to pay for his ticket, and yet he still can't return. If they can't deal with cases like that, how can we trust them with anything else?
The Honourable Member is totally right. There are failed asylum cases, and I have now heard of a series of these failed cases where people now want to return to their home countries. They have applied to the Home Office to be able to do so, and the Home Office has told them they're going to have to wait for 6 months because the Home Office is so incapable of getting a grip. And the case that the Honourable Member, you've got somebody waiting for, 12 months, even to be able to return to their home country, a 50% drop in returns compared to the last Labour government, because they always go after gimmicks and they never get a grip. 40,000 people whose asylum applications have failed and haven't been returned. 17,000 people who they've just lost. Altogether, they don't even know where they are. And it was their policy to let the backlog soar and to put 56,000 people in hotels. This is the Tories' asylum crisis, and they are failing to fix it. So the Prime Minister has made this legislation, this policy, their flagship. Extortionately expensive and failing. The ministers have repeatedly tried to hide the cost. Just 10 days ago, the Home Secretary was trying to suggest it was only £140 million. It's already twice that, not for anyone to be sent, for a scheme, by the way, that the Home Office officials have described as unenforceable and at high risk of fraud. Hundreds of millions of pounds could now be £400 million. And I would like the Immigration Minister, whichever of the Immigration Ministers is winding up today, to explain whether in fact this is now a £400 million plan. Hundreds of millions of pounds that could be spent on thousands more police to boost our border security and to smash the criminal gangs. Hundreds of millions of pounds that could have been used to clear the backlog entirely, end hotel use and save us a further couple of £1 billion, or could have trained 1,000 doctors or 4,500 nurses. And of course, they'll have to spend further money if they manage to send people there, probably around £200,000 per person. Perhaps they can confirm that figure, more than twice as much as it costs here in the UK. So can they confirm this scheme in total is going to look like it's going to be closer to £500 million for Rwanda by the time they finished, just for a few hundred people, just for around 1% of those arriving in the country. Because the Court of Appeal have said there's only capacity in Rwanda for around 100 people. Even the judge who agreed with the government said talk of thousands is political hyperbole. The asylum system in Rwanda, we know, is also limited. They've only processed an average of 100 people a year for the last 3 years. So at most, a few hundred people. 56,000 people are in hotels. 100,000 applied for asylum last year. 160,000 people waiting in the backlog. Potentially, this is less than 0.1% of those who will be covered. It is no wonder that the Permanent Secretary said yesterday, we have no evidence of a deterrent effect. So now they're on their third new law in 2 years. Home Secretary said the bill means if you enter Britain illegally, you'll be detained and swiftly removed to a safe country such as Rwanda, except that that wasn't him, that was his predecessor. Talking about the last bill, the Illegal Migration Act, passed 4 months ago, the main section of which hasn't actually been enacted because they know it won't work. Home Secretary has also said the bill will deter illegal entry into the UK. Anyone who arrives illegally will be sent to the country they've arrived from or a safe third country. But that also wasn't this Home Secretary or this bill. That was his predecessor, but for when she introduced the main provisions of the Nationalities and Borders Act, which was passed 18 months ago. And the main section of that one has been revoked because it made things worse. So the first one largely revoked because it made things worse. The second one not yet enforced because they know it won't work. So forgive us for not believing a single word about the bill that is being brought forward today, because we've heard it all before. And the Immigration Minister should respond about what is going to happen about Clause 2 of the Illegal Migration Act, which requires the Home Secretary to remove everyone to Rwanda or elsewhere if they arrived after July. They've put it on hold, apparently, until Rwanda gets off the ground. But even if they do manage to do that quickly, more than 15,000 people will have arrived in the country on small boats since then. all of whom they've now promised to send to Rwanda. So if Rwanda's only going to take a few hundred people a year, it's going to take them over 100 years to send the 15,000 people who have arrived since they passed the last law. It'll take them 10 years to send everyone who's arrived in the last fortnight alone. And in the meantime, while they focus on this gimmick, they're failing to get a grip and they're failing to bring down the backlog. And instead, we've got people in asylum hotels at taxpayers' expense at the astronomical cost of £8 million a day. I will give way to the member.
And I've listened with interest for almost 15 minutes to hear what her solution to this incredibly difficult problem is. She refers to the fact rightly that we have asylum seekers in hotels at considerable cost and at considerable difficulty when it comes to the disbursement to our local authorities and to all of us as constituency MPs. But I do not hear a single word of recognising that what the government is coming up with is a solution which may not work completely, but which may have a deterrent effect and which may be a welcome step in a series of steps to help reduce illegal immigrants into our country. Does she not recognise that?
Cooper. Well, £400 million for a failing plan is a hell of a lot of money. What we need to do is clear the backlog, and Labour has set out a proposal for 1,000 new caseworkers to clear the backlog, a new returns unit to make sure instead of this 50% collapse in returns, we actually return people who have no right to be here. Do that, clear the asylum and end the asylum hotels, and that will save the taxpayer £2 billion. Instead of throwing hundreds of millions of pounds, this will save the taxpayer billions of pounds. I'll give way to the honourable member, former colleague on the Home Affairs Select Committee on the back row.
To the right honourable lady who's given way, and absolutely we work together on the Home Affairs Select Committee. I'm a Kent Member of Parliament, and we need to make sure we take firm, decisive action to deal with illegal migration. I'm open-minded to looking at this bill to see if it delivers that. But does she agree with me when I try to intervene on the Home Secretary? The point is this: the number of people in the UK who've lost their asylum claims, but yet they are still in the UK. What are we going to do, and what is the government plan to ensure that those people are removed? Because that is a deterrent. And I haven't been given the numbers of how many of those who've lost all their claims have been removed in the last year, for the last 2 years, or the last 3 years. Because if we want deterrent, we need to look at that as well as this.
Cooper. So I totally agree with the honourable member. And that is why I hope there should be cross-party support for a plan to have a major new returns unit to actually turn that round. You've got 40,000 people who are here, who've had their claim rejected, who should be being returned, and they're not being. A 50% drop in returns under the Conservatives over 13 years of the Conservatives. Actually, a further 17,000 who've just disappeared into the system altogether, where there should be proper enforcement as well. But the government's not taking action on any of those things. There's no grip in the system. So actually, Labour would do that. We would set up a new major returns unit with 1,000 staff to make sure that we have proper enforcement in place. And the combination of that and the caseworkers will save the taxpayer £2 billion as well. But this treaty and the legislation before us, Mr. Progress first, the treaty and the law before us, we've got the treaty says that numbers are limited by Rwandan capacity. The number of vulnerable refugees sent here, of course, is not limited. The treaty says Rwanda can terminate the deal at any time, doesn't have to take anybody. The treaty also says the UK will fund the support of asylum seekers and people granted refugee status for 5 years. That includes accommodation and 3 meals a day for 5 years. Well, that's more than here in the UK. It says that people can't be sent anywhere else, but can be sent back to the UK, and the Immigration Minister, well, at least one of them, has confirmed that if someone commits a terrible crime in Rwanda, actually, the Rwandan justice system doesn't have to deal with them. They can just send those criminals back to the UK, so you couldn't make it up. You've got trafficking and torture victims, and Afghans who help our armed forces and have fled the Taliban sent to Rwanda, but convicted criminals sent back here. The law before us is a total mess, which is why all sides of the Conservative Party don't like it, even though most of them will still vote for it because they are in such a mess. Some of them want to stop all court challenges. Actually, I think probably some of them want to stop all courts because they've long ripped up being the party of law and order or the rule of law. Some of them want the UK to pull out of the ECHR, no matter the consequences for the Good Friday Agreement, the Windsor Agreement, the prospect of any future security or return agreements with other countries. And then this really astonishing scene of the British Prime Minister claiming that somehow it's the Rwandan government's commitment to the ECHR is the reason why he can't possibly breach it, that they are keeping the British Prime Minister on the straight and narrow, even though it's the Rwandan government who was found by the British Supreme Court to be in breach of international law. So this is kind of through the looking glass now. Does the Rwandan government really suddenly care about the European Convention on Human Rights, or did the Prime Minister ask them to say that they wanted the European Convention on Human Rights to be complied with because he was too weak to tell his backbenchers that actually he thinks our great country should abide by international laws that we helped write and that we currently urge everyone else to follow? I will give way to the member.
I'm grateful to the Shadow Home Secretary for giving way. She will understand the passion and anger that many of our constituents feel. In my own Bournemouth West constituency, we have 4 hotels full of people waiting for their asylum determination. They want this sorted out. The government has come forward with a plan. She is eloquently explaining her reservations about that plan and committing to cancel it. She is also explaining what she would do if she were charged with responsibility for this policy in the Home Office. Can I ask her, in the 12 months we have until the country has to go to face a general election, what is the timeline that the Right Honourable Lady would put on ending the boats if her policy was enacted? And will she, from that dispatch box today, give that date to the British people?
Well, I think the honourable member is just highlighting, actually, the failure of his front bench. All of us should want to stop these dangerous boat crossings. They are undermining border security and they are putting lives at risk. We should be seeking to smash the criminal gangs. We should be seeking to strengthen our border security. We should be seeking to return people who have no right to be here. We should be seeking to fix the chaos in the asylum system, because most people want to see both strong border security and also a fair and effective, properly controlled and managed asylum system, which we haven't got at the moment. That means clearing the backlog. It means setting up a new returns unit. It means seeking to work with France, with Albania, where we agree that actually we agree with the government on this. We support the work the government's done, but actually it should be going much further. It should be much further, the work with France, with Albania and with other countries as well. So we have that European cooperation in place. And all of us should be seeking to do that instead of the total chaos that we've got now on a gimmick that isn't about getting a grip. And the problem as well is, I will make some progress and then I will give way to the honourable member. The problem is that even if it stands, this law risks breaking international law, and that actually makes it harder to get further returns agreements and also to get further security cooperation that we need with our nearest neighbours. It's also why for the One Nation group to support this puts them in a pretty impossible position as well. The bill says in Clause 1.5, a safe country is a country to which persons may be removed in compliance with international law. In Clause 2.1, it says decision makers must treat Rwanda as safe, even if it isn't. So even if Rwanda does what it did over the Israel-Rwanda deal and breaches international law and does send people back for refoulement, even if Rwanda introduces new policies to send people abroad, even if there is a coup in Rwanda, even if Rwanda fails to stop organised gangs moving people to the border, even if asylum seekers are shot at in Rwanda, all things that the Supreme Court found had happened in the past. Even if the treaty is designed in good faith, if it fails, the government is still saying that British courts cannot consider the facts. I will give way to the honourable member. Oh, I did promise to give way to the other honourable member. I will come back to him in a second. I'll give way to the honourable member.
Fundamental difference in the government deeming Rwanda safe to what the Labour government did in 2004 in deeming a whole list of countries safe in precisely the same way, in precisely the same legislative technique.
Yeah, well, he knows that that's actually not the case, because what the government has done is to both deem and to remove any capacity for the courts to consider the facts. And it shows how absurd that even the government figures this is. A second. The Home Office's own legal guidance, published yesterday, quotes legal judgments, and it says, the court should not shrink from applying the fiction created by the deeming provision. And then it says, the statute says that you must imagine a state of affairs. It does not say, having done so, you must cause or permit your imagination to boggle when it comes to the corollaries. Well, the mind does indeed boggle. And here is the problem actually for the Foreign Secretary and for the One Nation group, because even as it stands, the government is effectively admitting that it is creating legal fictions, and it is saying that rather than following the facts, the courts will actually have to follow those fictions instead, and for the sake of a tiny scheme that costs not just 300 million, but possibly 400 million, and sets a precedent too. I will give way to the honourable member, and then I will come back, because I did say I would give way to the honourable member.
Honourable Lady for giving way. There are really 2 points to correct her narrative about what Labour would do, which the government is not doing. The first is which the government is already doing much of what she lists, and I can attest to that, having obviously in various different capacities having funded that. But also, she misses the point, as my honourable friend, the member for Gloucester, made a moment ago, that we are dealing in this instance with the consequences of large numbers of people coming to this country, not with the cause of it. That Rwanda seeks to address the incentives that are driving this evil play. It's only by getting Rwanda to work that we change the calculus, both for the people who are making this crossing, but also the people who are expediting that, i.e. the criminal gangs. Does she not recognise that that is why this scheme is so important?
Order. Before I call the Right Honourable Lady, could I just stress that when people make interventions, not only should they be fairly short, but after having done so, it is important to stay for the rest of the speech. Some people have been sort of wandering out, having made an intervention. So anyone who's thinking of making an intervention, please do bear in mind you have to stay then for the entirety of the speech. Yvette Cooper.
Well, just say to the honourable member that the problem for him is that he has got a scheme that's likely to be costing now £400 million, that is only likely to cover less than 1% and perhaps even 0.1% of the people arriving in this country. And that's why the Permanent Secretary has said there's no evidence of a deterrent. What we need is the practical measures to actually take action, to go after the criminal gangs, to work with our neighbours. And when he says that the government is doing this already, how come there's been a drop of 30% in the number of people convicted for people smuggling? If they are really going after the criminal gangs at a time when we know that the people smuggling across the Channel has rocketed, how come convictions for people smuggling have plummeted by 30%? And that is the evidence that the government is actually failing to do the basics to tackle those practical things. I will give way.
I'm grateful to her for giving way. She's making a really powerful case that seeking to legislate by assertion that Rwanda is safe is as dangerous as it is ridiculous. But does she agree that those who claim that this is about parliamentary sovereignty and that's why this sinister attack is justified are wrong, because Parliament can only be meaningfully sovereign within a functioning legal and constitutional system, which this bill totally undermines? Without the courts being able to interpret law, then the legal system doesn't work and it undermines this place as well.
So we do have a sort of constitutional roles for Parliament, for the courts. Actually, it is right for Parliament to respond to court judgments, to respond, to adapt, to change policy. But what this bill is doing instead is actually putting at risk the international law, the compliance with international law that we actually need in place in order to be able to actually make further agreements instead. And the problem in the end, I actually don't think, in the end, all of this is about Rwanda. I think it is about the deep divides in the Conservative Party. It's about their chaos. It's about the Prime Minister's inability to show leadership. It's about the fact that they just want to tear lumps out of each other, and they are creating chaos while they are letting the country down. The former Immigration Minister has said that what the government is now aiming for is just 1 or 2 symbolic flights off before the next election with a handful of illegal migrants on them. That is not the same as stopping boats. That is not the same as strengthening border security or fixing the asylum chaos. I will give way because I know the honourable member likes to think of himself as the leader of the Common Sense Conservatives group.
Well, the right honourable lady is right. I am the very personification of common sense, as she's just acknowledged. So the real divide here is between those people on that side of the chamber, very largely, who believe that international law trumps the supremacy of this place, and those who believe that the reason this place is supreme is because our legitimacy is derived from the people. Only a polity can make law. Only a polity can make law for that reason. And so international treaties matter, but they don't matter as much when it comes to this kind of legislation as the people expressing their will through those they elect to speak for them.
Well, I would say to the honourable member that it's actually that we are discussing this legislation not actually because of the European Court, but because of a decision by a British court, by the Supreme Court, and made a decision based on British laws as well. So I know that there are members on the backbenches who actually want to make everything about the European courts, and that actually is the heart of their dilemma. They do want to get rid of the ACHR. The Foreign Secretary, the Home Secretary and the Prime Minister have all said they don't, and they won't. And that is at the heart of their divides and their chaos. This is what actually their row is all about. It's not actually about having a workable solution to the serious problem of our border security being undermined, of dangerous boat crossings that are putting lives at risk, of criminal gangs whose profits have soared as a result of effectively being allowed to let rip along the Channel because the UK and France have failed to work together sufficiently to stop them. I'll give way to the honourable member, and then I'm going to have to conclude my remarks.
Thank you. I'd just like to quote Article 21 of the ECHR, which clearly she likes to support in so many ways, that the will of the people shall be the basis of the authority of government. I don't understand how the will of the British people is being expressed within the European Convention of Human Rights and through their courts. Perhaps she can explain.
So I would just say that his problem, I think, with his own front bench. His problem is with his own Home Secretary and his own Foreign Secretary and his own Prime Minister. That's his problem. He wants to make all of this about Europe rather than us having a proper border security plan, having a proper plan to clear the backlog, a proper plan to fix the Tories' asylum chaos that they have created. Madam Deputy Speaker, instead of wasting taxpayers' money, instead of these performative rituals, instead of all the deeming and the boggling and the scheming, what we should be trying to do is build cross-party consensus on what really needs. They can't even build consensus within their own party. So I do accept this is particularly hard for them at the moment. But we should be trying to build a cross-party consensus on what really needs to be done to stop the boat crossings that are undermining border security and putting lives at risk, strengthening border security, smashing the criminal gangs that have spread their tentacles, going after the supply chains instead of ignoring these warehouses and lorry loads of boats crossing Europe unchallenged, getting real-time security information instead of carrying on with this ludicrous situation where we don't even know when suspected smuggler operatives are flying into our country, getting prosecutions and convictions for for the smuggler gangs and their vile trade, clearing the backlog, not making it bigger, ending asylum hotel use, doing more of the things that we support, the cooperation with France, the deal with Albania, getting more workable deals in place, and working together across this country and with other countries to stop dangerous boats, to smash the gangs, to strengthen our border security and ultimately to save lives. It is time to end all of this chaos. Time to ditch the gimmicks. Time for the government to get a grip.
The original question was that the bill be now read a second time, since when an amendment has been proposed as on the order paper. The question is that the amendment be made. It will be very obvious that there are a large number of honourable and right honourable members wishing to speak in this debate, and I would therefore ask that to start with, members speak for a maximum of 8 minutes. I won't put a time limit on, but I'm relying on colleagues to stick to that. Robert Jenrick.
Thank you, Madam Deputy Speaker. The decision to leave office is always a difficult one. The decision to disagree with the Prime Minister, someone who I want to support in good times and bad, is always a difficult one. But politicians are sent here to make difficult decisions. No one's forced to be a minister. And with high office comes responsibility. And no responsibility is greater than that to protect our borders and to secure us from untold damage as a result of mass illegal migration. We've made huge progress as a country over the last year as a result of the work that the former Home Secretary, the Prime Minister and I have done, and I wish my right honourable friend, the new Home Secretary and his ministers all the very best to take that work forwards. Our record stands amongst the best of any European country. We have, as my right honourable friend said, reduced the number of small boat arrivals to our country by a third. That compares to a third increase across Europe. And on Europe's southern border in Italy, an almost 100% increase. So the plan that the Prime Minister set out a year ago is working. It is the most comprehensive plan of any European country. And we've just heard from the opposition that they have no plan at all. They said that even if the Rwanda scheme was working, even if it was having the deterrent effect that we all want, they would still scrap it. Because ultimately, they don't believe in border security. And they cannot be trusted to protect our borders. But this problem isn't going away. This is going to be one of the defining issues of the 21st century. There are millions of people on the move, some fleeing climate change and persecution, others economic migrants, understandably in search of a better life. And it's a great compliment to our country that so many want to come here. But it isn't sustainable. I'll give way to the right honourable lady in a moment. It isn't sustainable. We have to secure our borders. And that means that all the good work that we've done over the course of the last year, the Albania deal, the asylum backlog work, the deals with Bulgaria and France and Italy and others, that isn't enough. We're not going to stop the boat purely on that work. You have to interject the strongest possible deterrent and the best deterrent, the only deterrent that we can use in the course of the next 12 months is the Rwanda deal. And that is why it is so critical that we get that up and running. I genuinely believe, having immersed myself in this issue for 14 months, that this is a good policy, that it can work, and that it will help our country to fight back against this great scourge. And in my job, I have seen the consequences of that every day. I've been with my honourable friend, the member for Dover, to meet her constituents, whose homes have been broken into and whose lives have been ruined by illegal migrants. I've been with my right honourable friend, the member for Bournemouth, and I've read about his constituent who was murdered by an asylum seeker who posed as a child and then killed somebody on the streets of Bournemouth. I've worked with almost every member in this House on their determinations to close asylum hotels. Even the greatest advocates for open borders change their minds when there's an asylum hotel in their constituents. Hypocrisy is all over this issue. This is why we've got to fix this problem. And that's why I say, when I said whatever it takes, I meant it. And I honestly believe that that is shared by all of us on this side of the House and many good colleagues on the other side as well. To do that, we have to make sure this policy works. And this is a good faith disagreement. There are good people on both sides of this House, and certainly within my party, who have disagreements about how we can make this policy work. But my point of view is this. When untold damage is being done to our country, when this issue will be with us for years, if not decades to come, where if we do not operationalise this policy correctly, we will see the numbers rise, and we'll see them rise for many years to come. If, God forbid, there was a Labour government, there would be a decade of small boat arrivals. I want to stop that. There are two big flaws with this bill to my mind. The first one, as I've said to many people who've asked me, and I've said on the media, is that it doesn't address the question of individual claims. If I've learned anything in this job, it is this, that those seeking to frustrate their removal from our country will stop at nothing. The small boat chasing law firms and legal representatives will help them to find each and every way. Give them an inch, they'll take a mile. Even the best meant things that we've done as a country in recent years, like our world-leading modern slavery laws, are abused. 70% of those people who are seeking to remove put in a modern slavery claim at the 11th hour. I won't give way at the moment. Every time this is proven to be correct. So why would we not put into this bill a provision that says that those people cannot bring forward individual claims? I'll give way in a moment. And this means two things. Firstly, it means legal certainty. But secondly, it is for operational reasons. And I have not met anyone who really understands the operationalisation of this policy who does not believe it is critical to do this. Those advisers have told me time and again that this scheme will be seriously impeded. People will put in those claims. They will go to court. The upper-tier tribunal, which is already under pressure, will be overwhelmed. Our detention capacity, just a few thousand spaces, will be full. In a single week in August, 2,000 beds in our detention capacity could be filled. Those arrivals will go onto our streets. They'll abscond, as they always do, never to be seen again, and the scheme will be brought into quick disrepute. I don't want to see that happen. I'll give way to the Right Honourable Lady.
Thank you, Madam Deputy Speaker. Though I have to say I'm not a Right Honourable, but thank you, Madam Deputy Speaker. I thank the Right Honourable for giving way. He casts aspersions on Labour's approach to this. He is in the presence of two former immigration ministers, myself and the Right Honourable member for Birmingham Hodge Hill. And when my Right Honourable friend was the member in charge of this, there was one person being returned every 8 minutes at the end of the last Labour government. I know from my own caseload that people who have reached the end of the line are still dribbling around the system, as others have raised, they want to actually leave the country. What was his record after 14 months as an immigration minister in returns?
Tenfold increase in the pace of asylum decision-making. So we have absolutely transformed the decision-making system. We've massively increased the number of returns. The Honourable Lady is on rocky ground, I'm afraid, on this one, and 22,000 people have been returned. But the difference between this side of the House and hers is that we have the guts and the determination to fix this problem once and for all. And that means interjecting the strongest possible deterrent. And I worry what would happen. I worry for this country if there was a Labour government, because I think we would see a massive increase in the number of small boat arrivals. The people smugglers would be celebrating if there was a Labour government. That is why it is so important to us on this side of the House that we use, I won't give way with all due respect, because I only have a few minutes left. We need to use the time that we have left in government before the general election. Of course, I hope we win the next general election, but the public are watching us. They expect us to fix this problem. So why would we not put into this bill all of the strongest protections that are at our disposal? The second important thing that needs to change in this bill is this. It is inevitable, in light of the Supreme Court's judgment, that the Strasbourg Court will impose further Rule 39 interim measures. That is, after all, what bedevilled my right honourable friend, the member for Whittam's, flight a year or so ago. We have to stop that. It is a matter of sovereignty for our country that ministers acting on the instructions of Parliament do not allow those flights to be delayed. The provision in the bill today is sophistry. It is the express policy of the government that Rule 39 injunctions are binding, and to ignore them would be a breach of international law. So we are being asked to vote for a provision which it would be illegal to use. I do not want to be in the position that my right honourable friend, the member for Whittam, whose determination I do not doubt, was in. I don't want my right honourable friend, the Home Secretary, or my successors as Immigration Minister to be in that position. We as a House are giving them a hard deal. We're doing them a disservice if we allow the bill to continue in that way. They must have the full power of Parliament to ignore those Rule 39 injunctions and to get those flights in the air. There are other things I know that others will contribute, not least my honourable friend, the member for Stone, and the work that he's done, drawing out some of the other challenges with this bill. But I'll close with this. This is not a bad bill, but it is not the best bill. I want this bill to work. The test of this policy is not, is it the strongest bill we've done? It's not, is it a good compromise? It's, will it work? That is all the public care about. They don't care about Rwanda as a scheme. They care about stopping the boats. And we are sent here to do that for them. I will never elevate contested notions of international law over the interests of my constituents, over vital national interests, like national security, like border security. This bill could be so much better. Let's make it better. Let's make it work.
SNP spokesperson Alison Thulis.
Thank you very much, Madam Deputy Speaker, and I move the reasoned amendment that stands in my name and that of my honourable friends. Madam Deputy Speaker, before I start, I just want to remark on the tragic news that emerged that an asylum seeker aboard the Bibi Stockholm was found dead this morning. Now, we don't know yet what the cause is, and we sympathise for that person and everybody who loved them. But what I do know is that our words and our policies in this place have consequences, and we should all reflect on that in the debate this afternoon. The UK's approach to migration, both legal and illegal, has been nothing short of chaotic. Poisonous rhetoric swirling around the plight of the world's most vulnerable at the Channel on a stormy night. I'd like to take a moment to reflect upon how the Tories have taken us to this parlous state. A former Home Secretary, the Honourable Member for Maidenhead, doubled down on Labour's hostile environment policy in a speech 11 long years ago. She promised to make life really difficult for those who came to our shores, to deport first and hear appeals later. The Immigration Acts of 2014 and 2016 fostered a toxic culture of suspicion and disbelief in the Home Office, turning health staff, employers and landlords into border guards. This led to the Windrush scandal, to the TOEIC scandal, to lives fractured and still not put back together, to go-home vans and the highly skilled migrants 3225 scandal. People being forcibly removed despite having done nothing wrong. Directly to the dehumanisation found by the Brook House inquiry and to the rampant spread of COVID in scabies in Napier Barracks. They tightened up on the lorries, and then we had small boats, and the talk got ever tougher. The cry of stop the boats went out, the Nationality and Borders Act came and went, the boats kept coming. The Illegal Migration Act was passed, and oddly enough, this didn't prove to be much of a deterrent either. And today we have the Safety of Rwanda Asylum and Immigration
bill before us, which the Tories will claim will be the one to do it. Well, they think third time's the charm. Maybe it will, maybe it won't. I'm not terribly convinced. But the Permanent Secretary told a committee yesterday that there is no evidence that it will be a deterrent either. This is policy in a death spiral. Tougher and tougher and tougher. Turn the screw, threaten people with rendition flights to Rwanda. It won't work because nothing they have done before has worked. Why? Because it doesn't deal with the reason why people are coming here. Exactly. People will continue to put themselves in small boats because they feel there is no alternative. They come to reunite with family because of historic ties and because of the English language. It's all too easy to dehumanise, to speak of scourges and swarms and hordes, to speak of those who try and come here with no papers, those who somehow want to cheat the system and skip the queue. As the MP with the highest immigration caseload in Scotland, I see many of those people that ministers refer to at my surgeries week in, week out. I have to look them in the eye, as so many I know over the other side don't have to. I have 138 outstanding immigration cases if the Home Secretary would care to look at his inbox once in a while. So I will speak instead briefly about some of my constituents. I will call the first constituent Mohammed to protect his anonymity. He came here from Sudan and got refugee status. He applied for his wife to come, and after 9 months waiting for that application, he came to my surgery in March this year. In April, conflict broke out in Sudan. His wife's family fled to Egypt, but because her paperwork was in the closed visa application centre, she couldn't go. In May, I was told the case was allocated to a decision maker, but that the visa application centre in Khartoum was still closed. By October, the case was still with a decision maker, but there was no timescale for a decision, I was told. On Friday, Mohammed came to my advice surgery to show me pictures of the gunshot wound to his wife's leg and the video footage of those that had been killed in the same incident. So I asked members opposite, what would they do if it was their wife? There is no safe and legal route from Sudan, and the family reunion route is demonstrably not working in the face of an ongoing conflict. Would they advise her to sit tight and wait for 1.5 years for the appropriate paperwork? Or should she try and cross international borders by whichever means she could to get to her husband and to safety in Glasgow? She's not wanting to skip the queue. She just wants the paperwork done by the Home Office. Or how about the constituents? I will call Mr and Mrs R. They were unlucky enough to be visiting family in Afghanistan with their 5 children when it fell. With significant difficulty and scant assistance from UK officials, they were eventually able to return to Glasgow several months later. Yet they contact me regularly about the family members that they had had to leave behind. Despite the much-touted Afghan schemes, there is no route for them. Their relatives fled to Pakistan and had to leave everything behind, including their paperwork. The government of Pakistan is now sending people back to Afghanistan into the hands of the very Taliban they fled from. So I asked members opposite again, what would they advise Mr and Mrs R's family to do? Ask the Taliban for a passport? Wait for the Taliban to come and shut their door? Wait for the Pakistani government to arrest them? Or should they try another route? It's no accident that Afghans make up the greatest number of people in small boats. As Safe Passage have pointed out, in the first 9 months of this year, just 279 Afghans came through official routes. For every person arriving through the Afghan seams, 17 Afghans are crossing the channel in a small boat. And we've heard this week about how Arab is leaving those who served with our armed forces at risk of execution. I travelled recently with the Home Affairs Select Committee to hear more about what's happening in France and Belgium and their response to small boat crossings. The French Red Cross said that they have worked with young unaccompanied asylum seekers that they find who are trying to cross the channel to reach family members in the UK. They try to convince them of the merits of a family reunion application, but the backlog is so long, the casework is so slow, that they will inevitably wait for many months. Members in this place tend to forget that the channel isn't the beginning of somebody's journey, it's the end. It's the last leg. The channel holds little fear, given the dangerous journeys some have already made to be here. It could not be more tempting to know that they are so nearly to safety. If a humanitarian travel document existed, those same young people could avoid the perilous journey in a leaky rubber dinghy. They could get the same train or ferry as many millions of travellers do every year. They would not need to pay people smugglers at all. That would kill the business model at a stroke. It's the denial of this logical option that is placing people in danger. So what's the government offering instead? If you make that long and dangerous journey to our shores, your case will not be heard at all, and you may be sent to Rwanda. I will.
I thank the member for giving way, and she's making an excellent speech and bringing real humanity to this debate. Is she aware that those people in Calais that are trying to cross the Channel are homeless, poor, desperate, and often victims of war and human rights abuses, and that walking away from international law and international conventions won't offer them any protection, won't offer protection for any other desperate people in the world, and will be a terrible message to the rest of the world that this country is turning its back on international law that we established in 1948.
He makes an excellent point, and this country is turning its back on its international obligations with this bill here today. It is a pathetic excuse for a policy, a foghorn signalling to the far right. It's too weak for some of the Home Secretary's colleagues, too harsh for a few exceptional others. For all the talk of full-fat versus semi-skimmed, it's more akin to milk which has gone stagnant and sour, utterly repellent to decent people and best to be binned altogether for everybody's safety. For the SNP benches, it's an absolute abhorrence which undermines the UK's international obligations, the principles of human rights. It costs a fortune and it's highly unlikely even to achieve its tawdry aims, and we should be lodging a prayer against the Rwanda Treaty. The legal experts that I've heard from are appalled at the implications of proceeding with a bill which, by the Home Secretary's own frontispiece to the bill, cannot be declared as compliant with the ECHR. The Home Secretary claims he respects the decisions of the Supreme Court, but he comes here today with the sole purpose of overturning them and to prevent them ruling on anything ever again. A government disapplying human rights when it suits them and instructing courts and public bodies to do likewise is a deeply troubling place. Liberty have stated that this bill will tie the hands of every court in the UK while also abandoning the UK's international commitments. Now, far be it from me to be concerned about the UK Constitution or standing in the world, but I note that the Law Society of Scotland have questioned the UK's rationale in disapplying a range of human rights agreements dating back 70 years and the global implications from this departure to the international rights order. ILPA, Justice and Freedom from Torture, say that this bill sends a devastating signal to the world about the UK's reliability as an international partner. It also begs the question of whether the breaking of international law is something the Rwandan government would actually accept. The Minister Vincent Biruta has reportedly said without lawful behaviour by the UK, Rwanda would not be able to continue with the Migration and Economic Development Partnership. It's beneath contempt for the UK government to say on the one hand, we're presenting a treaty with Rwanda, marvel at how solid and unbreakable this treaty is, while telling us that they want to breach the Human Rights Convention, the Refugee Convention, the International Covenant on Rights, Civil and Political Rights of 1966, the United Nations Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment of 1984, the Council of Europe Convention on Action Against Trafficking in Human Rights done at Warsaw, 16th of May 2005, as well as customary international law, any other laws that might get in their way, including from the European Courts of Human Rights. International law is binding. No welching, no backseas, no keys up. They're supposed to adhere to it. That's why they signed up to it in the first place. It is abject nonsense. The Law Society of England and Wales go yet further. They state quite clearly that domestic legislation cannot immunise the government from the enforcement of international law. To claim it can is disingenuous. They also state that refusing to comply with an interim measure would be a clear and serious breach of international law. They accuse the UK government further of using law to manufacture a reality. Madam Deputy Speaker, it's the time of year we all indulge in some Christmas magic and imagine reindeers on the roof, but this UK Tory government has asked the entire legal system of the United Kingdom to engage in a far more dangerous pretence. The UK Supreme Court sought out the facts for itself, and upon that clear and substantial evidence found Rwanda to be unsafe. And this seems most likely why the government wants to ban courts from doing this again via this legislation. They speak of the risk of refoulement and sending people back into harm's way. And indeed, if Rwanda was safe, why would it be the case that they're also able to send asylum seekers to the UK as part of this deal? The Rwandan opposition leader, Victoire Ingabire Umuhoza, was sentenced to 15 years in jail for speaking out against the Rwandan government. Despite being released in 2018, he still to this day, cannot exercise his political rights. His criticism of this deal has had to be done in the international media because he says the local media dared not give him a platform. If the Honourable Member can explain to me why Rwanda is safe, I'll certainly take his intervention.
The key thing about this whole debate is the tension that she's described, actually. Is she familiar with the rulings of Judge Denning, of Lord Hoffman, of Bingham, and more recently, of Reid, all of which directly contradict what she said about the balance between international law and laws passed by this Parliament? All of those very distinguished jurors say that the opposite of what she said. And does she at least acknowledge that truth?
I acknowledge that different lawyers will have different opinions, and the Law Society of England and Wales in their briefing says that the government is being disingenuous in what it is claiming here, and I will take their word for that, and my honourable friends, I'm sure, got a point on this too.
Picking up on the honourable gentleman's point, he cites various judges, but of course the most Supreme Court in the United Kingdom is the UK Supreme Court, and they were very clear in the Miller 1 case that while parliamentary sovereignty might mean that the law can be changed internally, this Parliament cannot legislate its way out of its international obligations. Now, does the honourable lady, my honourable friend, agree with me that no matter what various judges may have said at various times, it's a recent massive constitutional case of the UK Supreme Court we should look to on this issue?
She is absolutely correct, as her learned knowledge comes in many of these issues. And I think it is important that we reflect on these cases and what that actually means, rather than what members opposite wish that those cases mean. This legislation before us today declares Rwanda safe in all circumstances. In so doing, they are undermining the rule of law and the separation of powers, preventing the courts from establishing their own facts and driving a sleigh and a squad of reindeer through the principle of restraint. My torture metaphor ends here because far from being Santa, the Home Secretary makes the Grinch look generous, and he truly does have a heart that is 2 sizes too small. This treaty creates new rules for Rwanda, but in reality nothing has changed in the weeks since the judgment. Lords Reid and Lloyd Jones said that intentions and aspirations do not necessarily correspond to reality. The question is whether they are achievable in practice. The Supreme Court found that Rwanda had thus failed to meet international obligation and is unlikely to meet additional ones. And there is no evidence that the long-term culture shift required is likely to happen quickly. Rwanda processed, I understand, only 228 decisions on asylum claims in 2020 and rejected claims from countries such as Afghanistan, Syria, Yemen, Iran and Eritrea. I don't want to get dragged into the merits or otherwise of Rwanda as a nation, as there is a far broader principle in play here. If we start to offload our international responsibilities to a third country, any third country, we're effectively surrendering our influence over what then happens next. This government themselves have become the people traffickers, sending human beings offshore against their will as if they were some kind of waste to be processed rather than human beings alike in dignity. There are also real concerns about the impact that this flagrant disregard for international cooperation could have on trade policy, on the Good Friday Agreement, the Windsor Framework. The implications of what is happening here today could be far-reaching and long-lasting across many aspects of all our lives. And then we move, Madam Deputy Speaker, to cost. And quite typical of the way this Tory government runs its business, there has been secrecy over the cost, with the Permanent Secretary finally forced to reveal yesterday the additional £100 million payment to Rwanda after the figures showed up in some International Monetary Fund paperwork. This on top of £140 million the previous year and £50 million years to come next year. This for a scheme that has thus far seen more Home Secretaries flown to Rwanda than asylum seekers. It will cost £169,000 per asylum seeker, significantly more than if they were processed in the UK and allowed to rebuild their lives here and to contribute to society as so many dearly wish to do. And we'd all know that the capacity of this deal makes it practically impossible. The estimated capacity of around 200 would mean the probability of being renditioned to Rwanda is 1 in 230. If the UK government were to remove everyone who did cross in a small boat last year, it would cost £7.7 billion. This would be an obscene use of public funds at any time, but particularly in a cost of living crisis. And then there's the ongoing problem, which the government is failing to address, of those people who have arrived and won't be removed, forever stuck in an immigration limbo with their cases deemed inadmissible. At what cost? Where will they stay? What will they do in the rest of their lives? The further danger of this bill is it will force people into even more risky behaviour. The Refugee Council has stated that almost everybody who does arrive in the UK does so after being intercepted by the UK Coast Guard, the RLNI or the Border Force, and many actively contact those agencies asking to be rescued. This bill makes it far less likely that they will do so. They will take more dangerous routes, they won't seek assistance, and the inevitable result of this is that many more will die in the Channel or in the back of refrigerated lorries as a result of this legislation. It will also leave people at the mercy of exploitative people traffickers. And the Home Affairs Select Committee have already found that, and I quote, "The fight against human trafficking is in practice no longer a priority for the UK government. This bill and the Illegal Migration Act which came before makes this worse." The treaty also says there's nothing to stop people leaving Rwanda once they're removed there, regardless of anything ministers may claim. And the BBC, in their visit to the Gashora refugee camp in Rwanda, found that those that had been removed there under other schemes didn't actually wish to stay either. They could say, and I quote, "Almost 2,000 people who have been relocated to the transit camp in Gashora since it was set up in 2019, none opted to stay in Rwanda when given the option, preferring instead to move to another country." So what do we have? We have the endless failed policies, we have the ramping up of tensions through rhetoric, we have ineffective legislation, we have overruling judges, we have abolishing the asylum system altogether, we have undermining human rights. It's like the TV series Years and Years on steroids. Deputy Speaker, it doesn't have to be this way. Together for Refugees published this week a clear alternative to fixing this broken system and keeping people safe. Ministers couldn't be less interested. The response from the right wing to pillory Gary Lineker for having the temerity to speak his mind. The Scottish Government has recently published a paper setting out an alternative to this ineffective and failing system. In Scotland, ending the hostile environment and ensuring humane, fair and compassionate refugee and asylum policies would be a priority. We should never forget the traumas, the unimaginable suffering that leads people to flee their homes. They are people just like us. Were it happening to us, we would all hope to be treated far better than those in the government benches would have it, to find safety and sanctuary when we needed it the most. It was on this principle that the Refugee Convention was created. We should stand up for that principle today and reject this cruel, unworkable and illegal bill.
Just to clarify, the reasoned amendment that's been selected is the one in the name of the Leader of the Opposition. I know that the Honourable Lady referred to that to start with. If I have got any chance of getting everybody in, I do need to put a time limit on, which I will do now. It's 8 minutes for the moment, but it will go down, I'm sure. But I have been able to notify the next speaker of that time limit. Sir William Cash.
Mr. Speaker, in the recent Rwanda case, which is the most recent case on matters relating to parliamentary intentions and the supremacy of law and the rule of law, and the proper application of the rule of law, it is quite clear that one claimant, and it only requires one claimant, because his claim was dismissed by the court on the grounds that parliamentary sovereignty had already undermined his case. The case was about retained EU law, but it actually undermined the case of that claimant. This was a clear indication that the court was going to take the sovereignty of Parliament first, and that is the key issue in front of this debate. It has been said by the courts that sovereignty trumps international law. It is absolutely clear that that is the case. And could I add that the House of Lords Constitution Committee only this year said, Article 58 of their report on the rule of law, etc., said, parliamentary sovereignty means that Parliament can legislate contrary to the UK's obligations under international law. Indeed, that was a reinforcement of the cases I've already mentioned in an intervention, including that of Lord Hoffman, as well as Lord Bingham, Lord Denning. Our greatest jurists have all come to exactly the same conclusion, including the President of the current court, which dealt with the Rwanda case. where he said the same thing in paragraph 144 of their report, in which he says, the principle of legality does not permit a court to disregard an unambiguous expression of Parliament's intention, such as that with which we are concerned. So the position is completely clear, and those cases, if I may say, before the Honourable Lady seeks to intervene, I want to get this quite clear. The Miller case was on a different set of circumstances, and not only that, it's actually been overtaken by subsequent constitutional judgments by the Supreme Court itself. So I just want to quote now from I will give way. She can say what she likes.
It's refreshing to know that my Article 10 rights haven't been withdrawn yet. But the point is this: he may be right as a matter of the domestic law of England, that the sovereignty of Parliament. He may be right. It's in dispute, as we know. He may be right that the sovereignty of the English Parliament allows England to change its domestic law internally. He may be right. What he is definitely not right about is this Parliament cannot domestically legislate to take us out of our international legal obligations without doing so clearly. The Supreme Court have been crystal clear about that. There's two separate matters here. There's the domestic law and then there's international law. If the government wants to breach its international legal obligations, then am I not right, based on Supreme Court authority, that they will actually have to withdraw from the treaties to which they're committed?
I absolutely, I'm glad that she mentioned the fact that an unambiguous statement, an explicit statement, as Lord Sumption puts it, as to what the position is in interpreting the intentions of Parliament does carry enormous weight and in fact overrides international law obligations. I'm going to read out from Lord. I will not give way. I will not give way. I'm going to quote directly from Lord Hoffman himself in relation to an ECHR case itself. He says this is the case of R versus Lyons, 2003. The Convention, he says, is an international treaty, and the ECHR is an international court with jurisdiction under international law to interpret and apply it. But the question is a matter of English law, and it is firmly established that international treaties do not form part of English law, and the English courts have no jurisdiction to interpret or apply them. Parliament may pass a law which mirrors the terms of the treaty and in that sense incorporates the treaty into English law. But even then, the metaphor of incorporation may be misleading. It is not the treaty, but the statute which forms part of English law. And English laws will not, unless the statute expressly provides, be bound to give effect to the interpretations of the treaty by an international court, even though the United Kingdom is bound by international law to do so. Of course, there is a presumption, a strong presumption, in favour of interpreting English law in a way which doesn't place the United Kingdom in breach of international law. But, and this is what he says, this is absolutely crucial here, but the sovereign legislator in the United Kingdom is Parliament. If Parliament has plainly laid down the law, it is the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. That is what the law is. And that is a straightforward interpretation and statement of what has been said. Now, there is an issue which I want to come on to, because my honourable friend, who I praise for his courage, actually, and also for a brilliant speech, I would simply say, I would endorse every word he said. I also would just simply like to say this. We want the government to succeed in its legislation, but it has to be legislation that works. And as I've explained, in relation to the Supreme Court, the whole question turns on the intention of Parliament and the sovereignty of Parliament. It's a question of justiciability as well. If there are to be amendments, and I put this to my right honourable friend, my honourable friend at the moment, I'm sure he'll be right honourable very soon. The fact is that when it comes to it, in this bill, we can make changes. It is possible to extend the scope of the bill, And it is possible, and I hope he will have discussions with the Clerk of Public Bills, who I've had discussions with already. The point is this, that it is absolutely clear that the scope of the bill will determine amendments, whether they're from the government or from backbenchers. And it does matter that we're entitled to have a proper debate about this fundamental question about international law and its relationship to sovereignty. Only one case taken to the courts on this bill, if enacted after royal assent, could be scuppered by a claimant and by the courts if the words of the Act were not clear, express and explicit in ruling out any such claim, for example, under Clause 4 or any other heading such as Rule 39 and all these other things which we will trot out, no doubt, when it comes to committee stage, if we get there. What I can say, however, is that you have to address the question of the scope of the bill, because that's the way Parliament functions. That is the way the Speaker has to decide about the selection of amendments. So this is crucially important. I would also just like to conclude by saying, because I've got much more I could say, but I want to just draw attention to this global issue. The fact is that in the whole of the European Union, there is a real problem. They are tearing their hair out because they have got the Charter of Fundamental Rights on the one hand, and they are bound by qualified majority voting to comply with a situation which is actually not the same as us, because we have a unique opportunity in our parliamentary system with the sovereignty of Parliament to be able to make amendments and to provide domestic law that will satisfy the voters of this country.
Chair of the Home Affairs Select Committee, Dame Diana Johnson.
Deputy Speaker, and can I first start by expressing my condolences on the news of the death of an asylum seeker on the Bibby Stockholm barge this morning. It's now almost 1 year since the Prime Minister pledged to stop the boats. No one here is arguing against that goal. We all want to see an end to people risking their lives by getting in small boats and crossing the Channel. However, the Home Affairs Select Committee stated very clearly in our report on Channel crossings last year that there was no silver bullet to end small boat crossings. We said it would take a variety of policies to be adopted, including safe and legal routes, additional cross-border policing to go after the criminal gangs, and many more recommendations. We even suggested the innovative idea of piloting asylum claims being piloted in reception centres in France in a similar way to the juxtaposed border controls that we already have with France. In April 2022, the then Home Secretary, the Right Honourable Member for Whittam, announced the Rwanda scheme, and since then, an extraordinary amount of financial and political capital has been poured into this policy. Whilst we accept progress has been made on some of the recommendations that we made in committee, including clearing the legacy backlog and developing work with France and Belgium, the eyes of the government have been locked on the Rwanda policy and its implementation. However, the underlying assumption of this policy is that the prospect of being sent to Rwanda will act as a deterrent for those thinking of crossing the Channel. Let's not forget that the Rwanda policy required a ministerial direction to the Permanent Secretary to get the scheme underway. Why? Because the Permanent Secretary wasn't convinced the scheme constituted value for money. In this case, there was and remains no clear evidence base that the deterrent effect would actually work, casting doubt on the scheme's value for money. Likewise, the Home Affairs Committee was concerned that the policy was good at generating headlines, but lacked a clear evidence base and full costings. And the Home Affairs Committee has been attempting to scrutinise the policy ever since. What has been really striking about this is, though, how difficult it has been to get facts and information from the Home Office on the details of the Rwanda scheme. And this has undermined the committee's ability to perform our scrutiny function. For example, we know that an initial £120 million has been paid at the start of the agreement, and that there would be a payment for each individual sent to Rwanda on top to process their claim, and for successful claimants to receive up to 5 years of support from the United Kingdom. We've subsequently learned that a further £20 million has been paid as a down payment on the initial costs for processing asylum seekers. So we know a total of £140 million had been paid. We'd repeatedly sought information but we're always met with claims of commercial confidentiality whenever we ask those questions about additional funding. So it was with some surprise, therefore, that I and the Honourable Member for Hackney South and Shoreditch received a letter from the Home Office Permanent Secretary last Thursday evening informing us that an additional £100 million had already been paid to the Rwandan government in April 2023 and a further £50 million will be sent in 2024. Just want to turn to the issue of the payment for each person that will be sent to Rwanda. At the Home Affairs Select Committee on the 29th of November, we couldn't bottom out with the Permanent Secretary what the actual cost per person of being sent to Rwanda would be either. The impact assessment to the illegal migration bill had estimated £169,000 per person, but the Home Office officials couldn't actually confirm that in November. So in asking Parliament to support this bill today, it is essential that we know the costings, whether this is actually value for money, and whether it will actually work. Parliament is being asked to assess whether the bill before us today will deliver a scheme that is an appropriate use of public money, without the government actually telling us exactly how much public money is due to be spent. So I hope the Minister will be able to confirm today exactly how much money has been spent, has been pledged, and budgeted for each year of the UK-Rwandan memorandum and now the treaty, and that he will commit to providing quarterly financial updates to Parliament. And I want to turn to the specific provisions in the bill. Under this bill, we all know the aim will be for irregular migrants arriving in the UK to quickly be sent to Rwanda, with very few legal opportunities for appeal, and with Clause 3 expressly disapplying several parts of the Human Rights Act. The Home Affairs Committee noted in our report last year that the government risks undermining its own ambitions and the UK's international standing if it cannot demonstrate that proposed policies such as the Rwanda Partnership, now being legally challenged at that time, are compatible with international law and conventions. As we know, Clause 2 of this bill would require all decision makers to accept Rwanda as a safe country for removals, despite the ruling of the Supreme Court. As a very distinguished former Solicitor General, Sir Edward Garnier KC, has said, it's rather like a bill that has decided that all dogs are cats. Indeed, the bill does not resolve any of the issues raised by the Supreme Court. The Supreme Court decision was based on evidence that Rwanda had previously violated international human rights treaties. This bill is not a magic wand that suddenly makes that evidence disappear. And I would question, why is the need to legislate that Rwanda is a safe country in this bill? If the treaty says Rwanda is safe, shouldn't the government be confident that the courts will now come to a different view and conclude themselves that it is safe? The bill will prevent the courts carrying out independent and rigorous scrutiny of any claim that there are substantial grounds for fearing a real risk of refoulement or treatment contrary to Article 3 of the European Court of Human Rights. However, I understand that this would be incompatible with the UK's international obligations under the Refugee Convention and ECHR. So is the Minister concerned about the impact of the bill on the UK's international standing, particularly given the absence of an evidence base for its deterrent approach? And is the Minister also concerned by effectively reversing by statute a Supreme Court judgment on the facts that this bill could undermine the constitutional role of the judiciary? Just turning now to some very practical questions. Within the treaty, it talks about the seconded independent experts who will be supporting asylum decision-making for the first 6 months. It talks about asylum appeals made by a new appeal body. It also talks about free legal advice and representation from legal professional members of the Rwandan Bar Association. All of these things will take time to develop and will need investment. And I wondered whether there is an additional cost there that the Minister might like to tell us about. I have no doubt that the Rwandan government have entered into this treaty in good faith, but whether this treaty has been entered into in good faith or not by both parties is beside the point. What matters is whether Rwandan officials will recognise and comply with their obligations and whether there are sufficient resources and adequate capacity on the group to enable this, neither of which can be guaranteed by the treaty or this bill. So I hope that the Minister will provide that evidence today, that capacity building and attitude change has taken place, therefore addressing the Supreme Court's concerns. The challenge of stopping dangerous small boat crossings is real. But so is the challenge of clearing the backlog, ending the use of expensive hotels and delivering an asylum system that works. They all warrant serious evidence-based solutions with full costings.
Cox.
Speaker, in defending this bill, which I will attempt, one has to reckon with those who think that it goes too far or may go too far, and those who think it goes not far enough. So let me, Madam Deputy Speaker, first address those who think it goes too far, of which the Honourable Lady who has just spoken is an example. This bill is criticised on the basis that it deems Rwanda to be safe. It is said that is an illegitimate legal technique. It is said it perpetuates or perpetrates a fiction in law. That is precisely the same fiction which the Labour government adopted in 2004 in the Immigration Treatment of Claimants Act, 2004. Yes, it is. It was changed 2 or 3 years later, but in a case before the Appellate Committee of the House of Lords, Nasseri, their lordships upheld as a matter of law the deeming of countries to be safe and within the law. And indeed, they went on to say, Lord Hoffman, I think, being one of them, that while Parliament deemed it such, there was plainly risks if the Home Office did not keep an eye on the state and conditions in the nations and the countries that were thus deemed, but otherwise it complied with the law, and the courts would respect Parliament's decision. Now, what is said in this case is that, but there is a Supreme Court decision which has already held Rwanda not to be a country for the to be safe for the purposes of the guarantee against refoulement. And it is said that for this House to overrule the decision of the Supreme Court in such an individual case is constitutionally undesirable and contrary to fundamental constitutional principle. Mr. Deputy Speaker, I do not agree with that analysis. First, it is open to this Parliament at any point to take steps to reverse the effect of a judicial ruling. That is the consequence of parliamentary supremacy. It is clear that Parliament should be restrained in doing so in cases, for example, where individual rights, in an individual case, to reverse a determination which has been made in favour of an individual plainly would be contrary to fundamental constitutional principle. But that is not what we are doing here. We are seeking to do precisely what the Labour government did in 2004 by saying that Parliament, legitimately weighing the evidence, has concluded that Rwanda will not engage in the refoulement of those sent to it. That is something that the courts have already accepted. It is something that it is open to this House to do, and it is something, in my judgment, which is perfectly legitimate for Parliament to undertake. It would be different if it was to reverse a decision against an individual. But even if I am wrong about that, even if, as a matter of constitutional convention, it were undesirable for this House to reverse the effect on a question of principle, namely whether Rwanda is safe for the purposes of refoulement, the facts have changed. There is now a binding treaty, which is not only binding in international law, but is binding in domestic Rwandan law. Because Rwanda has a system, my right honourable friend, the member for Stone, has rightly analysed the situation of international law. In this country, we have a dualist jurisdiction where treaties are not self-executing. But in Rwanda, the treaty is self-executing. So the treaty will be binding not only as a matter of international law on the Rwandan government, but on the Rwandan government as a matter of its own law. And that treaty contains a range of important safeguards, including as a long stop the fact that no individual removed to Rwanda from this country can be removed to a third country without the consent of the United Kingdom. If that long stop is in place, if it is binding in Rwanda law, if it is binding as it is in international law, I would suggest there is simply no credible risk if treaties and legal rules mean anything in the countries, both in the United Kingdom and in Rwanda, of refoulement. If the risk of refoulement has been removed, then there is nothing inappropriate with this House determining, as the Labour government did in 2004, that this country, Rwanda, for the purposes of refoulement, is safe. So I say to the House, it is appropriate, it is a judgment that we can make as the House to take the step that we are now doing. Now let me move to the third question, because the third question to me about, I can't give way, don't have time. The third question is the most important. The exclusion of access to courts. This bill carefully preserves the right of individuals to come to court in extreme cases of individual justice. I would submit to those who think this bill goes far enough, and I listened impressed by my right honourable friend, the member for Newark, that we cannot sacrifice the principle of access to a court. If we eliminate it entirely, not only would this bill collapse, because it will be interminably impeded in the House of Lords, it will probably lead to the Rwandan government withdrawing, and it is conceivable that the courts themselves may entertain for the first time a complex challenge about the right of this Parliament to do away with fundamental constitutional principles such as access to a court. This House and its supremacy does not necessarily mean that it does not operate within a complex system of constitutional institutions, each of which it has its own place as a component part in that system. No, I cannot give way. I simply do not have time. I simply do not have time. Constitutional principles compete in creative tension. Parliamentary sovereignty is the most important of them, but there are others that are fundamental, and one of them is access to a court in extreme cases. That is what this bill preserves. And I say to my right honourable friends, I understand the frustration and the deep and intense dissatisfaction with the current situation. I share it. I think there are tightenings that we can do, particularly on Rule 39. But on the preservation of the right to go to court in an extreme case, I say that is part of the British Constitution that our fathers and our party has supported and fought for generations. And it would be wrong for us to compromise with it.
Order. I'm sorry to have to interrupt. Order. I'm sorry to have to interrupt the honourable gentleman, but he is fully aware we have to stick to the time limits. After Sir George Howarth, order, who I'm going to call next. I'm afraid, given the number of honourable members that wish to participate in this debate, we'd have to reduce the time limit to 6 minutes. George Howarth.
Thank you, Mr. Deputy Speaker. The government's failure to arrive at a workable solution to the problem of asylum seekers is not just about how they have tried to deal with refugees, as many have already demonstrated, but its failure to create the capacity in our country to maintain reliable services to such an extent that many British people find themselves unable to gain access to basic needs and services to which they are entitled, and also about the stewardship of the economy. Additionally, it's rooted in the government's careless conduct of our relationships with other countries, particularly in Europe.
So crucially, in dealing with this sensitive issue, it is, in my view, important to be clear about the principles any approach should be based on. The problem is, however, that the government too often confuses slogans with policy, and in doing so, it fails to take account of the principles on which a realistic policy should be based. Its cynical obsession with creating dividing lines is a barrier to building the sort of consensus my right honourable friend, the member for Normanton, Pontefract and Castleford, referred to. Now let me, for the purpose of clarity, say at the outset that our country's capacity to admit migrants is finite. It follows that we need a much more structured method of determining how many people can be accommodated, which takes into account the capacity of our public services and our economy. I'll later say a few words about the space that exists in our economy to fill the gaps that we find in various industries and sectors. But one of the principles would be to match would-be immigrants with sectors in which there are not sufficient people to be able to plug those gaps. And many do have those skills. Yeah.
Very grateful too for giving way. And very briefly, would you agree with me, when we're talking about people who are claiming asylum in the United Kingdom, it would make an eminent sense to ensure that they have the right to work whilst they're waiting for a decision, not least because it would allow them to be integrated better into our community when they do get a decision, but also it would reduce the cost to the taxpayer and allow those people to support themselves whilst they're here.
Well, gentleman, for the point he makes, and later in my speech I'll address that very point if I have enough time. So now perhaps I can say a word about the capacity of those services. In England, the NHS waiting list for hospital treatment rose to a record of nearly 7.8 million in September, up from approximately 2.3 million over the past 2 years. Ambulance response times have also risen, with the average response to a call going up to 1 hour 30 minutes in December 2022, which compares to the target of 18 minutes. Or take housing. The UK is experiencing an acute housing crisis, with house building consistently failing to keep pace with demand. The National Federation of Housing Associations say that there are 8.5 million people in England who are in housing need, 42 million of which are in need of a social rented home in England. And in England in 2022, people were having to spend over 8 times their annual salary to purchase a home. In terms of school capacities, in 2020-21, 17% of primary schools were at over capacity, and in secondary schools the figure was 23%. Mr. Deputy Speaker, we didn't get to this position by accident. It's the result of 13 years of careless neglect and the obsessive pursuit of shrinking the state. Now I'll turn to the capacity of our economy and the ongoing skills shortages we're faced with. GDP is at zero growth, and low GDP growth is forecast to continue into 2024 and possibly beyond. The Office of Budget Responsibility's latest economic and fiscal outlook stated that living standards are forecast to be 3.5% lower by 2024-25 than at pre-pandemic levels, which is the largest reduction in real living standards since records began in the 1950s. The skills shortages I've referred to do not only affect our overall economic performance, they are having a negative effect on our provision of public services such as health, housing, and important sectors such as food supply and the care and hospitality sectors. As I've already said, many of the refugees here already do have those skills, and with a constructive approach from the government, would be able to plug the gaps in those sectors and consequently help grow the economy. Before I conclude, Mr Deputy Speaker, I'll say a few words about how our poor relationship with Europe and the wider world makes it more difficult for us to cooperate with other countries, whether bilaterally or through collective international efforts, to deal with the deeply damaging consequences of war and conflict, part of which is the growing displacement of people from their homeland, which results in mass migration. Bluntly, we are not trusted as a reliable and constructive partner, and our international influence is diminished to the extent that other countries simply don't take us seriously. As I said at the outset, the government has tried to turn a slogan, "Stop the boats," into a policy, and consequently has failed to offer a solution to this problem. Many on the benches opposite know that this is the case, but are splintered into factions, either wanting to go further, as we've already heard, or regardless of our international obligations, or they're aware that another, more effective approach is needed. Sadly, this bill and their conduct illustrate that the Conservative Party is not a competent or coherent party fit to govern, but rather one riven by warring factions. Frankly, it's now time for them to make way for a national leadership and party which will deal with our mounting problems calmly and competently.
After a good deal of hesitation, I shall support this bill tonight, but it's a hesitation that has been real, because for me it goes as close to the wind as one can constitutionally do. I listened with great care to the very eloquent speech by my right honourable and learned friend, the member for West Torridge and West Devon. I agree entirely with his very careful analysis of the bill. I'd say just this too. It is a novel and unusual approach. We are dealing with an unusual and pressing situation, and therefore I think straining the sinews of what is acceptable can just be justified. But equally, the idea that legislation is the sole or even the principal solution to this is, I think, wrong. Ultimately, what is required is an operational solution. And what is surprising is that some previous occupants of the Home Office did not think about that rather more. I know others did, and it's a pity that they were not acted upon more. But ultimately, it will be operational measures that make the real difference. If this can make a difference, and provided there remain the safeguards that my right honourable learned friend has referred to, I can, with hesitation, live with it. I'm indebted to the analysis provided by the Society of Conservative Lawyers in a paper, and I declare my interest as chair of their executive committee, a paper written by Lord Mansfield, King's Counsel, and Harry Gillow, both experienced in international law. If you want opinions in these things, it's best to go to people with experience in the international law field rather than other fields. They conclude, as I do, that although there are areas which certainly need to be examined with care, the bill falls upon the right side of the line. Deeming provisions are not unprecedented, as has been put out, has already been set out. I am concerned, and I hope the Minister will take on board and explore as we go forward, the particular situation raised by my right honourable and learned friend, the member for Kenilworth, about how deeming provisions interact with international law obligations. Because you can deem in domestic law, but you can't legislate to oust your international law obligations. That said, I think there is force, and I refer to the very useful analysis in the Society of Conservative Lawyers pamphlet, that in reality, if the UK were to breach international law conventions, not only would that be constitutionally wrong, it would also collapse the scheme. Because Rwanda has made it clear that it would not be party to the scheme, and I don't buy for 1 second the rather patronising attitude that says the Rwandans have been put up to say that. I think they're utterly genuine in their belief. And it's also important to remember that there are other countries subject to the jurisdiction of the European Convention on Human Rights who are reported as potentially exploring arrangements with Rwanda. If Rwanda were to be party to a scheme in which the United Kingdom broke international law, Rwanda would inevitably forfeit any opportunity it had to engage with other ECHR countries, and they certainly would withdraw. So people have to be careful what they wish for. If they go too far, they will actually drive the Rwandans out of the scheme and will collapse the whole policy. First point. The other point that I think is important is to bear in mind it's absolutely critical that individual rights of challenge are preserved, as my right honourable and learned friend has said. I'm a conservative because I'm a constitutionalist. And I'm a constitutionalist because I believe in the checks and balances. And frankly, the day the Conservative Party thinks that ends justify the means and ignore principles of comity and think that any one single policy objective overrides the importance of the checks and balances of our Constitution, it ceased to be a Conservative Party in the sense that most people would recognise it. Maintaining that balance is essential. I think ministers have, with great endeavour, managed just to do that. But it doesn't mean that I don't like much of the wording of the bill. When I look, Mr Deputy Speaker, at, for example, some parts of Clause 1, I look in particular at Clause 1.4, it's recognised that Parliament of the United Kingdom is sovereign and the validity of an Act of Parliament is unaffected by international law. That's a GCSE law statement of the blindingly obvious, if I might respectfully say so. It might best be described as otiose and nugatory. It adds nothing to the bill. It's performative. Well, whichever way round one likes. Pointless might be another way of putting at it. So I wonder what that adds. There's another passage in relation, I think it's Clause 2, subsection 5, in relation to the rule, the approach to interim measures under Rule 35 of the Strasbourg Court's rules. It says that it's for ministers to decide. But again, that states exactly what is the position in law anyway. You've only got to look at the textbook to say, as I did in my intervention, that it's for the governments that decide on Rule 35 issues because they're directed to the governments, not to the courts. A bit patronising to tell the courts what is well within their competence to know and decide upon. So, with those sort of reservations, I will support the bill tonight. But I just say this. If it were to change and any of the safeguards that have been left in to be removed, then my support would go. Because some people would then have pushed it over the line into the unacceptable and, in my judgment, the unconservative, and then I would not support it. I don't believe that's the government intention, so I'll help them to get the bill through tonight. But they must be wary of some who do not have the best of objectives towards the government's policy, who might take it in the wrong direction. Let's not get there.
Thank you, Mr Deputy Speaker. It's a delight to follow the honourable gentleman who made one of the best speeches so far today against the bill. Unfortunately, he doesn't follow through with his logic, but I'm sure that by the end of this process he will follow through with his logic, because this bill, he knows perfectly well, is not really acceptable. And in his heart of heart, he would like to vote against it tonight, I'm sure. There are 5 reasons to vote against this bill. First of all, it won't work. The idea that someone who is not deterred by a dangerous journey in a dinghy across the most crowded sea lane in the world will be deterred by this flimsy piece of nonsense is just laughable. Second, it will lead to protracted and expensive chaos because it sails, as he says, so close to the wind legally that it will inevitably lead to legal challenges. And ironically enough, since the ouster clauses mean challenges cannot be adjudicated in the British courts, they will go to the European Court of Human Rights. So the government is actually replacing a UK court with a European court and simultaneously declaring on the face of the bill that it is not satisfied that the bill will withstand a legal challenge based on compatibility with the European Convention on Human Rights. That is a recipe for chaos and for expense. Thirdly, the bill seeks to reverse, by statute law, a finding of fact by the highest court in the land, the Supreme Court. It therefore creates a legal fiction. Its title, The Safety of Rwanda Asylum and Immigration Bill, gives the game away. According to the bill, Rwanda is safe, even if it isn't safe, simply because the government, through the bill, says it's safe. But declaring somewhere safe doesn't make it, of itself, safe. You can no more change reality by law or legal dictate than you can by mere imagination. As Bolingbroke says in Richard II, you cannot cloy the hungry edge of appetite by bare imagination of a feast. And you cannot make Rwanda safe just by saying it. So Clause 2's declaration that every decision-maker must conclusively treat the Republic of Rwanda as a safe country is utterly fatuous. If Rwanda is, either now or in the future, in fact safe, the provision deeming it safe is, or will at that point, be OTOs or redundant. But if Rwanda is not now or in the future safe, that provision is self-evidently wrong in fact, and therefore wrong in principle. So Clause 2 is either unnecessary or wrong, or both simultaneously. Fourthly, the bill establishes in UK law a completely new doctrine of the separation of powers, as the ouster clauses, which prevent judges and tribunals from supervising the conduct of ministers in operating the policy they have laid out in statute, put ministers above the law. It is not the sovereignty of Parliament that the bill asserts, it's the sovereignty of ministers. But fundamental to the rule of law is the idea that the Crown, or its modern proxy, the executive, cannot act arbitrarily, even if it uses its majority in Parliament to declare that it can. That would be the worst form of Henry VIII Act, equivalent to Henry VIII's proclamation by the Crown Act 1539, which deemed that all the King's proclamations, even though they were not approved by Parliament, and I quote, shall be observed as though they were made by an Act of Parliament. Fifthly, now is not the time to undermine human rights and a rules-based order. The UK relies on foreign courts and tribunals being effective. We watch events in Ukraine and declare that the butchery in Bucha or in Mariupol is a war crime. Who do we want to adjudicate that? An international court. We rightly lecture China about human rights abuses in Xinjiang province and about abiding by the United Nations Convention on the Law of the Sea. We invoke Magnitsky sanctions against human rights abusers around the world. But how can we expect others to abide by the rule of law and their human rights and other treaty obligations if we abandon them? The member for Torridge and West Devon was right about one thing. He was wrong, incidentally, about 2004, because what we didn't do at that time was put in an ouster clause, meaning that ministers were free to do what they want. Those who think the bill should go further will get no help from this side of the House, in any of the parties on this side of the House, when it comes to committee and report stage. And as we've just heard, if the member for Stone's demands were to be met in amendments at committee and report stage, Rwanda would withdraw, and the member who's just spoken would withdraw his support for the bill. I don't know why anyone would vote for this bill, but voting for it, despite knowing that it's legally offensive, or believing that it is fatally flawed, in the desperate hope that the government will help you amend it, is just delaying the inevitable. Because the most extraordinary irony of all is that the Prime Minister has had to rely on the Rwandan government to tell him and his MPs that Rwanda won't accept any law that breaches international law. Rwanda, which is theoretically, nominally democratic, but is in effect and in actuality an authoritarian one-party state. That's who's keeping us on the straight and narrow legally. Just think about that before you vote for this nonsense.
It's a pleasure to follow the honourable gentleman, and I was very pleased to hear his strong invocation of the fallacy that we live in a separation of powers constitution. We do not. We live in a constitution of checks and balances. We are proud to have an independent judiciary, an independent legal profession underpinning the rule of law, which we are all equal and subject to. We also have a parliament that is supreme. The crown in parliament is in fact the phrase, which is why, like my honourable friend, the member for Bromley and Chislehurst, I take issue with some of the wording in clause 1, but that's by the way. But the principle of comity, Mr Deputy Speaker, is one that we can ill afford to overlook. What do I mean by that? Well, I mean that mutual respect that has to exist between the different arms of the Constitution. This place is sovereign. We derive our sovereignty from the people. But we also have a responsibility to use that in a responsible way. And this is not a new challenge, Mr Deputy Speaker. Previous generations have faced similar dilemmas, because I am not going to stand here and minimise the emergency that we face from illegal migration, or minimise the challenge that the entire West faces from the mass migration of people who might seek a better life, who are either fleeing war-torn countries or are coming for economic reasons. It's an unprecedented challenge for all Western democracies. But challenges like that have been faced in the past. When we were at war, we had to make very difficult decisions in this Parliament to make sure that we struck the right constitutional balance between defending these islands against dictatorship, but not in a way that defended us and protected us out of our very freedoms. Our very liberty itself is at stake. And the way in which we legislate has to be responsible and has to be in line with that respect for our fundamental freedoms. And as my right honourable and learned friend, the member for Tory and West Devon, said, there is a fundamental truth here that we cannot avoid. And that is, if this bill is amended to create an utter, complete ouster from any individual-based challenge, then that goes beyond the parameters of reasonableness and into the sort of legislation that inevitably sets up a fist fight, not with international courts, Mr Deputy Speaker, but with our very own courts themselves. And I'll give way to my honourable friend.
Of course, my right honourable friend is more than aware of the Privacy International case, and he knows as well as I do that in fact in that case there was a dissenting judgment by both Jonathan Sumption and Lord Reid. I think that sort of sums it up. It was very, very finely balanced on the facts of that particular case.
My honourable friend, contrary perhaps to mythology within the Conservative Party, and I agree on many of these key issues. He and I, for example, would have legislated to overturn the Evans decision, the Prince of Wales letters decision, because we felt that their lordships went too far. But that is an example of this House, potentially this Parliament, legislating to correct a legal decision by the courts. Of course we're entitled to do that, and we should do it where the will of Parliament dictates. But there is a difference, I think, between a scenario like that and the one that we are facing at the moment. Because without more evidence and without more work by the government to blithely create a deeming provision in the face of, let's face it, a very strong Supreme Court decision against the government, would have been to invite disaster. And that's why not only the treaty that has been signed between Rwanda and Britain is crucial, but also the policy statement that has been published by the Home Secretary today and laid in this House, which I urge all honourable and right honourable members to read, because there is no doubt that the facts are evolving and that they are changing, and that we should remind ourselves that the Supreme Court, when it made its decision, looked at the law and the facts as of summer of last year, 18 months ago, when we have moved on considerably. Now, of course, deeming provisions are not constitutionally unprecedented. They're unusual, and that is why the government has to be restrained. But without clause 4 in this bill, I am afraid that what the government will do is to set up a massive glass jaw to be smashed by a court in future, and to invite the sort of constitutional conflict that any good Conservative would not want to see. We don't want our courts being drawn into politics. I have spent my career in this place and my political life arguing against the politicisation of the judiciary, and I've been the first to bring forward legislation to oust the court's jurisdiction. We did so in the Judicial Review Reform Bill on the Clark jurisdiction that my right honourable friend finished the job on. Of course, I'm more than happy to be robust about the position of this place and the importance of not having undue and capricious interference with the will of Parliament. I'm the first person to assert the authority of this place. But what I won't do, Mr Deputy Speaker, what I won't be a party to is legislation that in effect invites the courts to come on up if you're hard enough. That is not the approach that we as responsible Conservatives should take. And to echo the point made by my honourable friend, the member for Bromley and Chislehurst, If this bill is to be amended in a way that crosses that line, then I cannot support that. And I will not support that. And if anything, the government should be thinking very carefully about making sure that this bill is engineered to provide as perfect a balance as possible between its obvious right as a government to get its policy objective through, to reflect the huge concerns of our constituents, but at the same time to work within the parameters of our unwritten constitution. Because I say this is a Conservative government today. What if it was a government of another colour that was doing something that we as Conservatives found mortally offensive? What then would we have to rely upon in the defence of the balance of this constitution? What would be left for us to defend against an overmighty socialist government? Not a lot. And that's why today this has to be, yes, about principle, but we mustn't, at the end of all of this, lose sight of the fact that as Conservatives, it is our constitutional duty to maintain that balance. Remember comity, Mr. Deputy Speaker, and we won't go wrong.
Alistair Carmichael.
Thank you very much, Mr. Deputy Speaker. Can I say sincerely it's a genuine pleasure to follow the Right Honourable and learned gentleman who gave a characteristically thoughtful speech for the second reading and, more interestingly even than that, laid down several markers for future stages should we get to that point. It's a most interesting and unusual second reading debate where you have a debate not just on the bill but played out in front of us the sort of tripartite discussion between that side of the government, that side of the government and the Treasury bench. It is a quite remarkable spectacle to observe, albeit not a particularly seemly one. I was struck by the reliance that the Right Honourable Learned Member for Bromley and Chislehurst placed on the references that the Right Honourable Learned Member for Torwich and West Devon had made to proceedings here in 2004 in relation to the Asylum and Immigration Treatment of Claimants, etc. Bill, later Act. That, of course, as the Right Honourable Learned Gentleman observed, was where this concept of safe countries was introduced. They listed the safe countries as being all EU countries except Croatia, plus Norway, Iceland, and later Switzerland. It was also another piece of legislation that restricted the access of right to appeal for those whose asylum claims had been unsuccessful. There are perhaps lessons to be learned for us all in how that line of legislation has developed ever since. For me, though, the enduring lesson that I take from it, in fact, is that that bill, not that it was brought in by a Labour government, because it was a Labour government that had David Blunkett as the Home Secretary, but actually it was a bill that was opposed with some controversy at the time by the then Conservative opposition. They described it then, and rightly so, as being clumsy and draconian. I think they were absolutely right about that, and we can see many years later exactly where that sort of legislation has taken us. But what is it, I wonder, about the Conservative Party of 2023 that now finds that sort of legislation to be so attractive? Let's not forget, Mr. Deputy Speaker, that what we're dealing with here is the consequence of the refusal of this government to prosecute the case for safe and legal routes. Why is it that we don't find people from Ukraine or Hong Kong trying to cross the channel in small boats? It's because we offer them safe and legal routes. The Rwanda scheme is an unworkable scheme, and we know that because it's never been made to work. The barriers are well rehearsed, but every time they are thwarted, the response of this government is to throw a foot-stamping tantrum. Anyone who ever had any doubt about the depth and scale of Tory self-entitlement can see it laid bare here today. This bill is not about making the system work. It's not about providing an effective deterrent. It is simply about trying to keep a disparate range of forces within their own party together. How many will Rwanda actually take over the 5 years of the agreement? As far as we're concerned, and the only reliable information about this comes from Rwanda themselves, it will be a few hundred. What sort of deterrent effect is that going to have? And everything that we know about this bill, everything we know about the cost of it, actually, comes not from the Home Office, but from the Rwandan government themselves. It is because of the information that they put into the public domain that we learned about the extra £100 million that the government has committed. They were never going to tell us. The problems facing this policy are manifest, and they are not going to be wished away. We should not forget, however, that even were those issues wiped away at a stroke, this bill and this scheme would still represent a moral vacuum where our asylum system should be. It is wrong in the practicalities, but it is also wrong on the principle. It is a liberal value to take personal responsibility to live up to your obligations. Passing on our asylum responsibilities to another country is the opposite of that value. It's a step back from the world. It is a move towards isolationism. It suggests that we have no responsibilities to the wider world. Much like this bill's rewriting of reality to impose a judgment of safety to Rwanda, these plans would reverse decades of the UK leading the way on the international rule of law and rules-based order of which we should be so proud. Many across the House have to ask themselves, having boasted about global Britain, do they now really want to turn us into Fortress Britain? This bill suggests a grim and illiberal mentality that is a far cry from the confidence that our country used to project. And that, Mr Deputy Speaker, is why we should reject it this evening.
Well said. Dame Priti Patel.
Speaker, I have to say, as having been the Home Secretary that negotiated the original Migration and Economic Development Partnership, I find it quite odd to be sitting in this debate today, hearing some of the comments that have been made, in particular people running down the country of Rwanda in the way in which they have been. I just think that is absolutely appalling. And I say that because the partnership with Rwanda was established as a world-leading, innovative way to tackle the challenges caused by mass migration and the displacement of people, Mr Deputy Speaker. It was carefully designed with our friends in the Rwandan government to do one thing that no one in this House has mentioned at all today, which is to raise the international bar when it comes to the treatment of asylum seekers with compassion and support when it comes to their resettlement. And I think it is quite astonishing that so far today, particularly on the part of the benches opposite, while they've been speaking down and talking down the government of Rwanda for the last 20 months, we should actually recognise and welcome the fact that it's a country that already supports and has resettled 130,000 refugees through schemes established with UNHCR and through international conventions. I won't give way, there is no time to give way, and the gentleman knows this. And effectively, these are the types of schemes that we need, the resettlement and working with third countries, to actually deal with this awful, awful, abusive and illegal trade in people smuggling. And it's a stain, I have to say, Mr Deputy Speaker, on this House with some of the awful comments that I've heard thus far about Rwanda and this scheme. We have a moral imperative to raise the bar and effectively look at how we can be better as governments around the world to address these issues. And that is why when I negotiated and agreed the partnership in April 2022, we all knew it would face criticisms and legal challenges, and the government of the day was prepared for this. I said it at the time, and in fact we gave some very clear statements in this House as to the steps that we would take forward. And it was in fact a year ago the High Court found the plans to be lawful. The Court of Appeal ruled against the policy, citing concerns over the issue of refoulement, which are well known. But importantly, as the Supreme Court has since referred to as well, these are issues, and the Supreme Court has emphasised this, that the principles of the policy and the commitment given by the Rwandan government to make the partnership work, they are all fine and they are sound. But there are operational measures, Mr Deputy Speaker, that have to go further, which the government has since outlined through this bill, but actually through statements in this House, which would help to make this viable. Now, we all bear the scars, it's fair to say, and I don't envy the front bench right now. We've all bared the scars, and we heard my right honourable friend, the member for Newark, speak about this, the constant merry-go-round of legal challenges, whether through our own domestic courts or interference elsewhere, and by that I'm referring to Rule 39. I've got experience of dealing with Rule 39. There are organisations, campaigners and lawyers who clearly will do everything possible to frustrate the will of this House and actually the will of a democratically elected government, because that's what we are at the end of the day. We have to rise against these dogmatic beliefs because, quite frankly, there are too many organisations and individuals who are getting in the way and actually effectively letting more claims go to the courts. There are measures that have been passed through this House, including the Nationality and Borders Act, where measures have not been implemented through that Act of Parliament, including the one-stop shop, if I may say so, which actually would save the courts a lot of time and effort by bringing forward the single claims that this House voted through not that long ago, just last year, where repeat claims could not keep on going back to the courts. It's really important, if I may say so, to the front bench and to ministers, that we press upon the government now to go backwards, to go forwards, to bring in these measures that have been passed through Acts of Parliament already. And dare I say it, there may be some in the legislation that's come since. But I would like to ask the Minister, in responding to this debate, how the government is now going to act and prepare for any further challenges through this legislation that may come forward today, actually stands up to the repeat unmeritorious claims that keep coming through the courts, whether it's modern-day slavery. We've had about far too much. Within Nationality and Borders, we put in clauses and measures to deal with that. We've also seen the summary of legal advice the government has received and read much of the other expert opinion highlighting this. So seeking assurances from ministers on the awareness he and colleagues have on the risks of challenge and how these are going to be mitigated, if I may say so, through the way this bill passes through the House in the conventional way is going to be absolutely crucial. We cannot have more cases bogged down in the courts, and too many of us have worked through that as well. But also, if I may, we have a major problem on detention in this country and the lack of detention capability and size. There were plans with the new plan for immigration to introduce Greek-style reception centres. I would absolutely press upon the Minister, the Home Office, to work with the Prime Minister and the Treasury now to bring forward these sites, because otherwise we're going to see more Bibi stock homes, more Wethersfield sites, which quite frankly are not the answer to the solution. These Greek-style reception centres will help with the fast-tracking of processing claims and the fast-tracking of removal of individuals that have no right to be in this country. And I would absolutely press the Minister in particular and the Home Secretary to now have an integrated approach so that we can deal with this national issue. The public voted for change. We want to deliver that change for them.
Eagle. Thank you, Mr Deputy Speaker. Speaking as a lawyer, I must say I found there are still one or two of us left. I must say I found reading this bill I felt quite queasy reading this legislation. It's not the kind of thing that I would expect this Parliament to be considering, and I detected the same level of queasiness in some of the other lawyers who've spoken from the government benches, the former Justice Secretary, the current chair of the Justice Select Committee also apparently found it a queasy experience reading the legislation. I agree with the former Tory law officer, Lord Garnier, who used to be in this House, who called this bill political nonsense and legal nonsense. It designates Rwanda as a safe country, but by doing so, it's seeking to reverse a conclusion of the Supreme Court on the facts. Now, it's perfectly reasonable if the Supreme Court strikes down a policy to legislate, but one normally legislates to change a policy, not to try and purport to change the facts or say that the facts which have not changed are other than what the court found them to be. That was the first thing that made me feel queasy. It goes on to try and prohibit any legal challenges that may come forward to argue that Rwanda, having been deemed safe in this way, is in fact unsafe. It says that every decision maker considering this must conclusively treat the Republic of Rwanda as a safe country, notwithstanding any evidence that might come forward to the contrary. And given that the evidence that has already come forward and has been dealt with by the Supreme Court in that judgment led them to say unanimously that it was not safe, it's quite worrying, I think, that we simply seem to think we can legislate to change the facts. It allows a very narrow range of claims, and this comes to the heart of the argument between those on the government benches who wish to beef it up even further to exclude any kind of legal change, and those in perhaps the One Nation side of the Conservative Party that are trying to put a line in the sand to say they won't accept any further amendments. It does allow a very narrow range of claims, but based only on compelling evidence relating specifically to the person's individual circumstances. And even those sorts of claims are excluded in some circumstances, those that relate to refoulement. So excluding courts by Act of Parliament from considering relevant evidence, excluding them from taking accounts of judgments and laws, including domestic legislation, and fettering their judgment as the bill seeks to do, giving ministers power to ignore injunctions taken together, it's tantamount to undermining the rule of law. It's certainly not respecting the rule of law, as I would expect parliamentarians in this place to do, and certainly as I would expect the government of the day to seek to do if it were to wish to uphold our international reputation. I think it beggars belief that the government's response to its loss in the Supreme Court of its policy is to ask this House to legislate to just declare that it's all fine anyway and let's carry on. And even, as others have pointed out, if we were to start sending asylum seekers to Rwanda as a result of this bill passing into law, it's designed for a few hundred people at most, less than 1% of the people arriving in the UK. And the Permanent Secretary at the Home Office has been very clear when he said there's no evidence it's going to work as a deterrent, whereas most of what we hear from members opposite is that that is the very purpose of the legislation, that it's supposed to be a deterrent. So there we have it. It's actually a shibboleth, a Tory shibboleth, an article of faith it's become for some of the elements of the Tory party, the five families, I think they've called themselves somewhat menacingly. And as we see this Tory psychodrama unfolding yet again today, in order to try and decide the fate of the latest unelected Tory Prime Minister to be threatened with defenestration by some of the more right-wing elements of the five families. The country deserves better, and as my right honourable friend from the Labour front bench set out in her excellent speech, time and again they're going for gimmicks and infighting over basic competence and good administration. It's 4 years since the Tories promised to end boat crossings in 6 months. Almost a year after the current PM promised again to stop the boats, 30,000 more people have arrived. Hotel use is going up, not down, as the Home Secretary claimed. It's at 56,000 at the moment, 10,000 more than when the Prime Minister promised to end hotel use. Criminal gangs are not being deterred. Convictions for people smugglers have dropped by 36% since 2010, and the criminal gangs are making far more money now than they ever were. The backlog of undetermined cases remains at 165,000, despite the PM's promise to abolish the backlog of initial asylum claims by the end of this year. It's folly to continue with this farcical failed joke of a policy when what's really needed is competent, good administration. Why not put the money being wasted on this policy into dealing with the actual problem? If the party opposite and the government were to actually try and do that rather more successfully than they've managed in the last 13 years, they might get some credit from this side of the House and from the nation, but there's precious little evidence that there's going to be any of that.
Mr. Deputy Speaker. We all know our constituents want action on this. We all know, if we do surveys and read our emails, that this is one of the most important issues that faces our constituents. But it's not new. that the political parties have been debating this. It's not new that the political parties have been making promises on this. The Honourable Lady concluded by bemoaning lack of action and changes in a year and 4 years. When she delved seriously back, she went 14 years. Let's go back a bit further. In 1997, such was the issue of asylum and migration that it merited a mere 2 paragraphs in the Conservative Party General Election Manifesto and the same in the Labour Party Manifesto. In 2001, my party was saying, with Labour newly in office, the problem here is worse than anywhere else in Europe because of Labour's mismanagement. The government has presided over massive delays in processing applications and admits that thousands of those whose cases are rejected simply disappear. Sorry, this is us on Labour, and never leave. We will ensure, this is us in 2001, we will ensure that those claims are rejected and quickly deported by a new removals agency. Conservatives will restore common sense to Britain's asylum processes. By 2005, Labour are promising a points-based system. We will establish a points-based system, and they're saying we will ensure that only skilled workers are allowed to settle long-term in the UK with English language tests for everyone who wants to stay permanently and end chain migration. By 2010, Labour are telling the country and seeking a mandate for a promise that people need to know that immigration is controlled and the rules are firm and fair. And they're promising an Australian-style points-based system. By 2010, we might, if we listen carefully, hear the echoes from down the corridor from the other place. We are promising we will take steps to take net migration back to the levels of the 1990s, tens of thousands a year, not hundreds of thousands. By 2015, Labour are talking about how broken promises erode trust. And there were echoes in what the Shadow Home Secretary said, where they said they would recruit 1,000 new border staff and they would speed up the process. Mr. Deputy Speaker, both political parties have made promises to the British people at election times, and both political parties have then told the British public that it's the other party's fault that it hasn't been addressed. And when we look back, between 1964 and 1997, the UK's net migration figures were never lower than minus 87,000 or higher than plus 58,000. Now it's regarded as a modest year, a low figure, if those figures are in the several hundreds of thousands of net migration. All the time, in the meantime, we see over 8 million people, according to the ONS in this country, who are economically inactive. Mr. Deputy Speaker, I will support the government today because I think the government deserve credit for attempting to try and deliver their promises to the British people on the boats. And I think we should unite in this House for once to actually seek to deliver on the promises that we all have successively made to them. And surely if we look at other countries where those promises have been broken, we have seen others, unsavoury, dangerous people who have stepped into that void. And I fear, Mr. Deputy Speaker, if we do not once and for all say what we're going to do and do it and deliver for the British people, we could see such a fate ourselves in this country. In my own constituency of Bournemouth West, we have some 4 hotels that are occupied by people who are waiting for their asylum application to be determined. And I'm very clear that that is grossly unfair on them to be trapped in that limbo. And yes, we should do everything we can to accelerate it. But if they have no right to be in this country, then it is fair on the British people, the British taxpayers, and equally fair on them that they get that determination and are returned to the country of origin to get on with their lives. We're seeing far too many people coming in here without the necessary checks, who are then doing things in this country that are deeply unwelcome. And I cite the example of the poor young man, Tom Roberts, who was brutally murdered in my own constituency, who said he was 18 when he came here. He was put into a secondary school. It turned out that he was 14. It turned out that he'd murdered 2 other people in the country before he came here. Mr. Deputy Speaker, we owe it to the British people to be clear and direct. I will support the government. I will support the opposition if they become the government, to finally keep faith with the British people, keep faith with those who come here and come here with the right to be here, fulfilling our ancient pledge to offer sanctuary and freedom to those who are persecuted. But we have got to be straight with the British people. If we say we're going to do something, we've got to do it. And we've got to try every means at our disposal to deliver directly for the British people.
Hear, hear.
Thank you very much, Mr. Deputy Speaker, and I'm glad today's debate has provided some therapy for former immigration ministers to come together and to share a little bit of experience about some of the principles that are at the heart of this bill. I served as immigration minister for nearly 2.5 years. In fact, I think I'm the longest serving immigration minister still in this House. And so I know a little bit about what it takes to deliver an immigration system, and I have some sympathy with the comments, some of the comments, not many of the comments, but some of the comments that I've heard from the Treasury benches this afternoon. So I just want to say 3 quick things about deterrence, about international agreements, and about staying true to our values in these debates. Mr. Deputy Speaker, I was the Minister that introduced the UK Border Agency. I brought UK visas in from the Foreign Office into the Home Office. I brought customs out of Treasury to create a £2 billion agency with a simple principle at its absolute core. That border security in the 21st century cannot simply be about defending the border at the shores of our country. In this day and age, one has to operate a triple border. One has to export the border as far away from these shores as possible. You have to have a strong border at the shores, but then you have got to have strong in-country enforcement. And the only way in which you can get that system to work and to work effectively is to fund it. Yes. And so at a time when global migration pressures have grown so sharply, and the Right Honourable Member for Bournemouth West was right to flag this, there are now 184 million people globally who live outside the borders of their birth. There are now 37 million refugees globally. These migration pressures have been growing exponentially since the fall of the Berlin Wall, and guess what? They're going to grow exponentially in the years to come, not least as the ravages of extreme weather drive more and more people in fragile and conflict and violent countries into poverty. People will always go that extra mile to seek a new life abroad. But if we are to have strong borders for this country, then yes, we've got to have a deterrence. But the deterrence is the speed of justice. It is not the prospect of overriding domestic laws and shipping people off to some remote deportation centre. That is why the Home Office officials are right to say that this bill and the objectives of this bill provide, frankly, very little deterrence. Because what this bill does not do is it does not accelerate the process of rendering a decision on a case, and then if somebody has got no basis to be here, removing them very, very rapidly. We knew, Mr. Deputy Speaker, that we had to transform the speed of deportation under the administration that I ran. That is why we moved heaven and earth to ensure that there was somebody removed with no right to be here at the rate of 1 every 8 minutes. That was the kind of pace that was going to be needed to send a very clear message that if you are found to have no right to be here, then you are going to be removed very, very quickly. That is going to be the most effective form of deterrence. And so the House has got to confront the reality that given a choice of how to spend £400 million of taxpayers' money, do you spend it on building a remote processing centre in a faraway place that your own officials tell you is going to have no deterrent effect whatsoever? Or do you actually invest that money in creating a system that takes decisions quickly and removes people quickly if they've got no right to be here? The second point is that the first thing that you learn as an immigration minister is that you can't remove people unless you've got agreements with other countries to take them. This is not a country that just drops people out of the back of aeroplanes if they've got no right to be here. You've got to get them new travel documents, and you've got to have other countries that agree to take them. And frankly, the most important countries with which we need those kind of agreements are our closest neighbours in Europe. And so, can we just confront the reality that if we are about to destroy and wipe out and put into history years, decades worth of human rights agreements with our closest countries, how easy do we really think it is going to be to get return agreements of any type with our closest neighbours in Europe? It is going to get harder and harder and harder, because we will be seen not to be good partners, but to be bad partners. And frankly, that will not help us get in place the kind of returns agreements that we're going to need to keep a border and immigration system working well in the 21st century. The final point, Mr. Deputy Speaker, that I wanted to make was a point about the European Human Rights Act. It is a terrible sight to see the party of Churchill now depart so quickly from one of Churchill's proudest legacies. The European Convention on Human Rights was not an idea that was dreamed up out of thin air. The Council of Europe was not an idea dreamed up out of thin air. These were ideas that were led, promulgated, delivered by Winston Churchill. And that vision of a great charter, his vision of a great charter, to bring peace to a war-divided continent, was based on our experience of protection against torture, or protection against unfair imprisonment, or protection of life. These are ideas that we pioneered in this country, from the Magna Carta, through to the Bill of Rights, through to the European Convention on Human Rights. And the idea that the party opposite will now lead us departing from that tradition, I think, is a very sorry state of affairs. We, in this country, are the pioneers of human rights. It's an anniversary we celebrated with the United Nations at the weekend. It is something that we should hold dear.
David Jones.
Thank you, Mr. Deputy Speaker. I'm sorry I couldn't hear you in all the excitement. Unusually, the aim of this bill is set out in Clause 1, which is, and I quote, to prevent and deter unlawful migration, and in particular migration by unsafe and illegal routes. Now that is an aim which I'm sure not a single honourable member could disagree with. Illegal migration is possibly one of the greatest scourges of our age. It's evil, it's internationally organised, and it's socially and economically damaging to this country. The Rwanda scheme is an inventive and innovative plan. It establishes an effective, or it's aimed to establish an effective deterrent to prevent illegal migrants, to make them think twice about making that perilous crossing across the Channel. And unfortunately, it has foundered on the rocks of the Supreme Court last month, in which the court held that Rwanda could not be considered a safe country because there were substantial grounds to believe that migrants would face the risk of refoulement or being transferred to their country of origin or another third country. The treaty that the government has concluded does provide reassurance in that regard, and it addresses the problem identified by the court by making specific provision that no relocated individual may be removed from Rwanda otherwise than to the United Kingdom. Now, given the dualist nature of our constitution, the treaty needs to be complemented by domestic legislation, and this bill is that legislation. And it's critical that it should function as the government intends, which is to say, to facilitate the removal of illegal migrants to Rwanda without legal impediment. And the question is, does it do so effectively? The bill has been described as the toughest piece of migration legislation ever put forward by a UK government, and there is no doubt that it does toughen the current regime. But it is debatable whether it is sufficiently watertight to amount to a significant deterrent to the boats by facilitating the flights to Rwanda. The bill has been considered by the legal panel of the European Research Group, and I do commend it to honourable members. And the report notes that significant amendments to the bill are required to improve it, but expresses concern that those amendments may well be outside the scope of the bill. One of the most significant problems is that the bill contains no restrictions on legal challenges against removal to Rwanda on any grounds other than that Rwanda is not a safe country. And that clearly reflects the fact that the bill is a direct response to the judgment of the Supreme Court last month. If the bill does successfully block challenges based on arguments that Rwanda is not safe, and the treaty certainly does help in that regard, then it is likely that those advising illegal migrants will focus more on pursuing challenges of another kind. But we should consider Clause 4 of the bill, which specifically provides legal challenges to removal may be made if arguments are put forward that Rwanda is not a safe country for individual migrants based on compelling evidence relating to their personal circumstances. Now, the opportunities for abuse of that provision are obvious. Migrants may well be advised by people smugglers or by unscrupulous lawyers, because there are some, that they should oppose removal to Rwanda on spurious grounds, such as, for example, a non-existent mental health condition, a fear of flying, or whatever. And given that as many as 500 illegal migrants in the height of the summer arrive on these shores every day, 1,200. Well, I stand corrected by someone who knows about it. It's not difficult to envisage a situation where tribunals and courts may be overwhelmed. What I'm saying, Mr. Deputy Speaker, is that I believe that this bill does require amendment. And what I'm inviting my honourable friend, the Minister, to say when he winds up this evening is that the government is open to amendments, and I hear what my honourable friend, the member for Stone, has to say about scope, but that he will also engage with colleagues to see if this bill may be made better. Because at the moment, there are numerous deficiencies that have been identified in the report of the so-called Star Chamber that will, I believe, render this bill inoperable and ineffective. And the last thing we want to do as a House is to expend a lot of time and a lot of agony over putting in place a bill that doesn't result in the flights to Rwanda and the deterrence that we need to illegal migrants. I do hope that my honourable friend will respond positively to this suggestion when he winds up. I know that a lot of colleagues are going to listen very carefully to what he has to say, and I think that they will welcome what may well be regarded as a change of tone on the part of the government.
Thank you, Mr. Deputy Speaker. This bill might be called the Safety of Rwanda Bill, but it's really the Safety of the Future of the Tory Party Bill. It's basically Schrodinger's legislation, all things to all Tories. The ministers might say it doesn't breach international law to make it a dead cat of a bill for some, but it needs to say that it will breach international law to make it work for a dead cat of a Tory party, scrambling to find a reason to provide this. In my contribution, I want to say why I'll be voting against this legislation, to stand up for Britain's proud tradition of human rights, and to urge this place to learn from the mess that was created by the Northern Ireland Protocol Bill, which also repeated these similar challenges. It is extraordinary that the government is presenting us with a piece of legislation that says on its first page it cannot confirm it is compliant with our convention obligations, with the rules of law that we all signed up to support. I think many members on the opposite side have been listening to Oscar Wilde when he said that the study of law was sublime, its practice vulgar. Legislation isn't vulgar, it's imperative to democracy. They should listen more to Winston Churchill, who said the idea of a Charter of Human Rights was for it to be guarded by freedom and sustained by law. But this legislation will not sustain those laws, it will diminish them. We should be proud we were the first nation to ratify the convention that set up the European Court of Human Rights, set up at a time when thousands of people were fleeing persecution, in recognition that the world didn't always get things right. Never remember the children on the Kinder Transport who came to this country and their parents that we left behind. It is unimaginable in our own world to manage these issues on our own. That is exactly why we signed up to international treaties, to share the burden, to make a refugee system manageable, to deal with the fact that 60% of people on those boats are being granted asylum because they have a well-founded fear of persecution. And shipping a few of them off to Rwanda, just 5% of those, is at best an expensive distraction and at worst a deception at least. The only thing this piece of legislation will do is make a bad situation worse. Clause 5/3 provides the court cannot take an interim measure into account even if a minister has not blocked it. The bill also breaks our commitment to observe Rule 39 interim measures. In doing that, we breach our obligations under Article 13 of the ECHR, which require member states to provide effective remedies for the infringement of rights in domestic law. In layman's terms, Parliament is being asked to commit the UK to a process breaching our obligations to protect people from torture. No other country has ever tried to challenge Rule 39 jurisdictions. They may not have complied, but this is a completely new departure for us to be leading. And the damage it will do to our status around the world is untold. It will also damage other treaties that we have signed up to. The Trade and Cooperation Agreement states explicitly if we end judicial cooperation, we undermine the agreement. The Good Friday Agreement states explicitly that denying access to domestic courts for individuals on the basis of the ECR contradicts its own commitments. And I'm sure our colleagues from Northern Ireland have recognised that we cannot override legislation in this way. And that means there will be countless legal challenges. We've already heard about the millions of pounds we've spent on a scheme where not a single refugee has been sent to Rwanda for processing. We've already spent £2 million on legal fees fighting this process. That's on top of the extra £150 million we've already pledged to spend on it. No wonder a ministerial direction has been required to uphold this policy. And Parliament can pass any law it likes stating things should happen. We can pass laws saying there shouldn't be smoking on the streets of Paris. It doesn't mean that it will happen. And that's the legal fallacy at the part of this, along with the Permanent Home Secretary saying there is no deterrent effect. I can keep saying I can sing. I could pass legislation to say I could sing. If you came to karaoke with me, you'd realise very quickly otherwise the truth. The cold, hard reality of the law is that this does not change the facts that the Supreme Court identified. And only the people who think it's a deterrent think they can somehow keep saying to the courts, no, 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 Rwanda's safe, like some kind of Vicky Pollard approach to making legislation. It's time the British public woke up to what this government is doing. You cannot amend yourself out of this challenge without one side with Tweedledum and the other side with Tweedledee arguing anymore. This is a mess. It ruins our standing on an international bludgeon. It's more money being wasted. It's more time in this place being wasted when we could go after the traffickers, when we could go after the people exploiting vulnerable people fleeing persecution, when we could speak up for the very values that post-war we stood for in the world about supporting people who are at risk of prosecution. This legislation won't stop the boats. It won't stop the rot, and it won't stop the Tory party tearing itself apart. Britain deserves better, and with this side of the House, it'll get it.
Danny Kruger.
Thank you very much indeed, Mr Deputy Speaker. Let me start by saying how much I support the objectives of the bill, and I pay tribute to the government for the very significant improvements on the status quo that the bill represents. There are, of course, some practical issues which have been well rehearsed on this side of the House with its operations. And as my right honourable friend, Member for Newark, said so well earlier, what really matters is whether it will work. And what working looks like is being able to detain and remove sufficient numbers of migrants quickly enough, illegal migrants, that they decide that the journey across the Channel is not worth it. And that means ensuring that we have the capacity in the system, and I recognise the progress the government has made to improve capacity, but I think, as my right honourable friend says, we have significant concerns about the system getting gummed up with legal claims that are still allowable under the bill. And we're also concerned about the continued operation, potentially, of Rule 39 orders from the Strasbourg court. But, Mr Deputy Speaker, these practical problems, which I think are real and need to be addressed in the further stages of the bill, derive from a fundamental point of principle. And I really do welcome the noises that are made in the bill that would gladden the heart of my honourable friend, Member for Stone. It's rather like Bill Cash bingo in this bill. There's notwithstanding this, and there's supremacy that, and sovereignty the other, and it's all extremely welcome. Nevertheless, these words do not apply in the crucial places. It still rests the right of individual claims on international law, on the case law of the European Court and of the operations of the ECHR in our own country. And let me say quickly, Mr Deputy Speaker, I'm not calling at this stage that we should depart from the ECHR, although I think we could do that. In response to the Honourable Member for Hodge Hill, who just spoke, as if we, leaving the ECHR, would be departing from the honourable and ancient British tradition of liberty. Of course, as he implies by his speech, we would be returning to it if we were to leave the ECHR and rest our liberties on the statutes of Parliament and on the common law of our courts. But nevertheless, if the European Court were to disagree with the actions of the government and they issued a substantive ruling to that effect, then we begin a process of conversation with them about that, and we decide how exactly we might comply, or indeed, if we had to, depart. Let me turn, Mr Deputy Speaker, to the Supreme Court judgment from last month, and I think it is pretty important, very important, that we try and analyse the implications of that ruling. It is true, as my honourable friend member said it makes this point in principle, but except in that one case, it doesn't make it in practice. It ruled against the government on grounds that derive from European and international law, as well as other domestic laws. So the court suggested that, in practice, that international law trumped domestic law. And having done that, it then inserted itself into foreign policy. It presumed its right to judge a foreign government. It said it should decide for itself whether the Rwandan government's undertakings could be relied upon. It essentially gave itself special investigatory powers to make judgments of another country. It described, rather patronisingly, the inadequacy of the Rwandan system, as if that's any business of a British court. And while it totally disregarded the UK government, it said the executive of the UK enjoys no constitutional prerogative in this regard. But it did give what it called particular importance to the opinion of the United Nations agency. Yeah. So it asserts itself into foreign policy. It draws down the authority of international law and international global agencies. Where in its understanding is the role of the UK government? Where is its understanding of the role of this place, Parliament, which sets our laws? And I want to just reflect briefly on what the rule of law means, because the phrase is invoked constantly by critics of this bill and of our Rwanda policy, as if international law trumps domestic law. It is not the case that the rule of law implies some kind of hierarchy of law ascending from, parish council, local bylaws, up to the global law. The rule of law means the supremacy of Parliament and the operation of the common law of case law made by our courts. And my honourable friend, Member for Stone, cited all the distinguished jurists, Hoffman, Bingham, Denning, not Hale, didn't mention, but did mention Reid, the President of the Supreme Court. International law is, of course, important, and I totally recognise its enormous value in keeping the peace in the world and enabling us to deal with other countries, but it applies to the international plane. And let me touch briefly on human rights law, which has been mentioned as well. There's an assumption that the Human Rights Act has some kind of superior status in our law, and I recognise that is often seen to be the case, but that is problematic. The rights and liberties of individuals, of citizens and of foreign nationals, whether they're legally or illegally here, those rights and liberties are properly protected by statute and case law. And let me finish by saying, Mr Deputy Speaker, I regret we've got an unsatisfactory bill. I can't undertake to support it tonight. I'd hope the government would agree to pull the bill and allow us to work with them and with colleagues across the House to produce a better bill, one that respects parliamentary sovereignty and also satisfies the very legitimate concerns of colleagues about vulnerable individuals. I think we could do better on safe and legal routes, for instance. We should be working together with other countries to design a system that respects the sovereignty of Parliament and the legitimate rule of independent nations.
Thank you very much, Mr Deputy Speaker. This year is the 75th anniversary of the Universal Declaration of Human Rights. What an irony and what a shameful indictment of ministers that our government is marking it by putting in front of Parliament a bill to wave aside our human rights obligations and the judgment of the highest domestic court in this land. This insulting and dangerous legislation attacks both human rights and our democratic structures. In doing so, it both demeans and disrespects the role the UK has played in helping to shape the international rules-based order, including its contribution to the drafting and early ratification of the European Convention on Human Rights in the aftermath of the horrors of World War II. On its very cover, this shameful bill has a statement that the government cannot say it complies with the UK's obligations under the ECHR, a terrible admission of this government's willingness to violate the principle that human rights are universal and belong to all of us by virtue of our humanity. Now, as others have noted, this bill overturns an authoritative, unanimous Supreme Court judgment based on extensive evidence and made just 3 weeks ago. Our highest domestic court ruled that by sending refugees to Rwanda, the UK could breach its obligations under the ECHR and other international laws such as the Refugee Convention, the UN Convention Against Torture, the UN International Covenant on Civil and Political Rights, as well as domestic law. In seeking to oust the jurisdiction of our domestic courts by forbidding them from making assessment of fact and disapplying the Human Rights Act, this bill is constitutionally exceptional and provocative. It explicitly disapplies multiple sections of that landmark act, including basic minimum standards that protect us all, leaving barely any room for judicial scrutiny. Courts would be barred from considering if removing an individual to Rwanda could result in removal to a country where they would face torture, inhuman or degrading treatment. What kind of government would want the courts to ignore that and undermine the separation of powers that are fundamental to UK democracy? Mr. Deputy Speaker, this ugly bill also attacks interim measures, a vital human rights tool under international law, issued on exceptional basis in extreme circumstances where individuals face real risk of serious and irreversible harm. The bill both enables UK ministers to unilaterally decide whether the UK should comply with interim measures and also prohibits courts in the UK from having regard to them when considering any case relating to a removal decision to Rwanda. And to try and justify this cynical and sinister attack on the highest court in the UK, the Prime Minister has started saying Parliament is sovereign. Well, obviously Parliament can pass whatever laws it wants, but we have courts so that everyone, including this government, must act with respect to the laws Parliament has passed. This bill, as others have said, simply will not work. Its so-called deterrent is not a deterrent to someone fleeing torture or persecution who has already put their lives at risk by taking to one of the busiest shipping lanes in dangerous inflatable boats. But this law actually was even nothing to do with that in any case. It is a performative piece of cruelty of a dying administration and a grotesque waste of money that is neither practical nor strategic. But most important of all, the outsourcing of our human rights obligations to a third country is downright immoral. And to immorality, we can also add absurdity, Mr. Deputy Speaker. Seeking to legislate by assertion that Rwanda is safe is as ridiculous as it is dangerous. You can't sign a quick treaty one week and then legislate the next to make a country safe when the highest court in the land has said just the opposite. It is the facts on the ground that matter. It feels bizarre to have to say it, but apparently it is necessary to, and that is that legislation to say Parliament believes something to be true does not make it so. Fixing the facts on which the law is to be applied is the kind of thinking that dangerous conspiracies are based on. As Tom Hickman, KC, has said in a paper for the Institute of Government, and I quote, "If the government considers that the treaty has eliminated the real risk of refoulement, then it should seek to persuade the courts of that, not Parliament. It should not need saying that when you sign a treaty, you should stick to it. The UK government now has the embarrassment of being schooled by the Rwandan government, who, despite its own poor human rights record, is now sending out warning shots that even they will pull out of this shoddy deal if the UK government breaches international law to implement it." Mr. Deputy Speaker, I will be voting against this bill tonight because there's no tweak or amendment that can improve something that is rotten to its core. The bill before us today is a doomed and draconian attempt to reassert the Prime Minister's fragile claim to a non-existent authority, but it has serious consequences and sets an extremely dangerous precedent. These are deeply dangerous times in this country, and they are made more dangerous by this government. We've already seen the suppression of the rights to strike, the right to protest and other democratic principles and standards being seriously eroded. Now we have this flagrant attack on human rights, on our courts, and on the separation of powers in this country. Mr. Deputy Speaker, I call upon this government to abandon its cruel, immoral and unworkable Rwanda plan and to re-establish the UK's good standing as a member of the ECHR and international community.
Well said. Simon Felt.
Speaker, I'll start by saying very simply that I'm not a massive fan of this policy. I don't suspect that's a great surprise to the former Home Secretary or indeed the former Immigration Minister. But nonetheless, I do think it is crucially important. We need a deterrence policy. Whether we have a workable one or not is what sits at the heart of this debate. As a member of the Home Affairs Committee, we've heard the message time and time again, whether it's from law enforcement, from officials on the front line, from ministers, from our friends and neighbours in Europe, that deterrence has to work hand in hand with a fair asylum system. The idea that the solution to this is simply opening up more safe and legal routes is for the birds. We need them, of course, but we also need a hard deterrence to prevent abuse of our asylum system. When this policy was first announced, French officials said to us on the committee that there was a spike in asylum claims in France because people feared what would happen to them if they made that irregular boat journey to France and ended up in another country. When the planes failed to take off, the spike in claims levelled off. We've been to the beaches in Calais, we've spoken to asylum seekers in the camps near the coast, and as a committee we've spoken to our compatriots in Europe. It is very clear that countries across Europe, indeed across the globe, are casting around for a solution that we all face, for a challenge that we all face, Millions of people are on the move due to the effects of climate change and war, and we are not on our own here. And I gently suggest to friends and colleagues across this chamber who think that this is the government tilting at a particularly British windmill, that we are not. Versions of this scheme are being worked up across Europe, across the world. We need a rational asylum system, one that extends to help beyond schemes to Hong Kong residents, to people from Ukraine, Afghanistan and Syria, the schemes that we should be rightly proud of. We need one that extends to people who need genuine help. We need to erode our asylum backlog, and I give full credit to my right honourable friend for the work he put in doing just that. We need to place more work into inculcating citizenship for those who come here. We also need a sensible discussion on legal migration, being proud of the people who want to come and live and work here, set up their families here, and only tapering off numbers once we've geared the system enough to grow our own, not least to support agriculture, tourism, fisheries and social care, and avoiding cliff edges. But I go back to the main point. We do also need a deterrent. One that stands up and says to the criminal gangs and the people traffickers that their trade will not work. That they can try and put people on boats across the channel, but those boats will be intercepted and that their journey will not end in Britain. Doing that will break the trade. Doing that will make the boats unviable. And it's a goal that we share across this chamber. The key issue that the Supreme Court raised was whether Rwanda was considered to be a safe country in processing asylum claims, and whether individuals sent there were at risk of refoulement. The court argued that they're at risk. The measures in the new treaty, including independent monitoring and the new appeals body with a Commonwealth National Co-President, should put these concerns to bed. The belt and braces approach that the government is taking is proportionate and consistent with the rule of law, going so far as it can, but no further within the bounds of our international treaty obligations. Not my words, but Lord Wolfson's words. Mr. Deputy Speaker, I may dislike this policy and indeed the reality of where we find ourselves, but voting for this measure is the best route to stopping the boats, to saving lives, and to crushing the business model of the criminal gangs who are exploiting some of the most vulnerable people in the world. I will be supporting this bill tonight.
Thank you very much. Tommy Shepherd.
Thank you, Mr. Deputy Speaker. I have been in this House on many occasions now when we have discussed migration, and it saddens me that every time we do so, the narrative from this side of the House is invariably negative and pejorative. Immigration is always couched as a problem to be dealt with rather than an opportunity to be embraced. And I long for the day when we can have a positive discussion about the fact that almost everywhere in history where people have moved from one country to another, it has been to the benefit of the country to which they go. And we can also have a positive discussion about fulfilling our international and humanitarian obligations to people seeking sanctuary in this world, particularly since the 200 years of imperial history of this country it gives us a very great responsibility to many of those problems.
Well said.
And it saddens me, some of the remarks, he's not in his place, but the member for New York, I think, will come to regret some of the things he said when he talks about immigration being this great scourge and tries to suggest that any alternative to what he is suggesting will result in a tenfold increase in boats coming across the Channel. This is an attempt to weaponise and politicise a very sensitive subject for political gain, and it is, I think, very distressing indeed. If there is a problem with migration policy in this country, then it is a problem that is made by this Conservative government. Let me give 3 examples. The first would be the backlog, which rose to a shocking level of almost 100,000 people waiting to have their applications determined. That was a simple management failure of not deploying enough resources to do the job that was in front of them. Incontrovertible, in my view, that statement, because the evidence is there that when they did employ more people and more caseworkers, the numbers turned and began to come down. And today they have 2,500 caseworkers working on these cases and processing these claims. The money that they have already spent in this expensive Rwanda gimmick would pay for 3 times that number of caseworkers. Imagine what could be done with that capacity in dealing with this problem. The second thing is the hotels. I agree. Everybody agrees that this is completely unsatisfactory, that people who claim asylum in this country and want to make their case should be locked away for months on end in hotel accommodation that is not fit for their needs. It is a problem for the communities in which those hotels are located. It's also a problem for the people who are forced to be in that substandard and inadequate accommodation while their claims are processed. But it's a choice by the government to treat these people as guilty until proven innocent and to detain them in this way. An alternative way of doing it would be to look at a claim, and if a determination is made that it cannot be assessed within a number of days, then a temporary permit is granted to that applicant to allow them to remain in the country and to work whilst they are here. Now, what would happen? What would happen if that were the case? Well, what would happen is, first of all, the hotel bill would disappear, but more than that, people would seek the support of their families and friends and communities already in this country and of funded voluntary organisations at a much lesser cost to the taxpayer than is currently the case. And more than that, they would start doing work and paying tax in this country. And it's been suggested to me that if you did that, of course, people would just fall through the system because you wouldn't be able to control them. Well, I put it to the Home Office. There are 90,000 records you have already lost. So if people are allowed to work, I rather fear that the HMRC system might be rather better at us knowing where they are than the current regime which is there. And then the boats. People talk about disrupting the business plan. The business plan of the traffickers who use the boats was gifted to them by this government because you closed down the legal routes to come to this country, opening up these business opportunities. And the best way to get rid of them, would be to make sure that there is a system in place where anyone who wishes to apply for asylum in this country can do so, and their application is determined if efficaciously and swiftly a judgment is made, and it is either denied or they are accepted. And yet we talk about this as if everyone coming here in these boats was illegal and undeserving. Even on the latest figures, 3/4 of those applicants have been granted asylum because they have a legitimate claim. And Mr. Deputy Speaker, on the Rwanda policy itself, I've referred to it as a gimmick, but let me just, in the seconds remaining, let me just deal with this point about deterrence. We know that the Rwanda scheme is going to make an infinitesimal contribution to this problem. We talk about maybe 100, maybe 200 places being available in Rwanda that people can be deported to. In the crossings over the Channel in recent years, 300 people have died in making that journey. Will someone please tell me, if people are prepared to make this very dangerous journey, in spite of the risk of death, why would they stop making it because of the much lesser risk of being deported to Rwanda? The truth is, these people have a right to come and apply to be here. They have a need to do it, and if we were humanitarian at all, we would respect that.
Natalie Elphicke.
Thank you, Mr Deputy Speaker. As the Member of Parliament for Dover and Deal, the small boats are of particular concern because it is my constituency in which these boats arrive, and Dover is in a very real sense on the front line of this crisis. And it is on the shores of the English Channel that I have stood too often in sadness for the many lives that have been lost, unnecessary lives lost, because each and every person was safe already in France. In a very real sense, if we stop the boats, we save lives. And we don't just save lives, we cut crime and we put a stop to the criminal gangs who smuggle people. And that brings me to the key question that's before the House today. Will this bill stop the boats? What we know is that it is clear from the recent Supreme Court's judgment that they do not think that Rwanda is acceptable. And I fear that this bill in its current form will not change that position, not least because the Supreme Court was so emphatic in the tone of their decision. And it certainly won't in the next few months, as my right honourable friend, the member for Newark, so clearly and passionately expressed. Now, we have made substantial progress this year in reducing the number of small boat arrivals, and I thank him for the work that he and this government have done on that. Because it is the case that it's diplomacy that can sometimes succeed when all else fails. And that was the experience when it came to stopping the lorry smuggling. Under Lord Cameron, extraordinary arrangements were made with France to take joint action to stop the lorries then, just as we need to stop the boats now. Then it was said that no deal could be done, and yet it was. That's why, following the Supreme Court judgment, we must turn to diplomacy once again with a cross-channel agreement to return people to France rather than Rwanda. Indeed, Italy has done a deal with Albania, and there's nothing to stop the UK and France from doing a similar deal. We must look at all options that can work, because it is only when migrants and the people smugglers alike know that they cannot succeed through this cross-channel route that this small boats crisis will finally come to an end. Now, we should not stop there, because we need to modernise asylum as well. Asylum and the Refugee Convention were created in a very different time. It must be recognised that there is now movement of very large numbers of people on journeys that are all too often incredibly dangerous. That needs to be addressed not just by the UK, but by the West as a whole. A reformed international law would seek to keep people displaced by conflict close to their homes so that they can return and rebuild when conflict ends. These changes would help control migration, prevent dangerous journeys, save lives, and keep safe vulnerable people who are impacted by wars and other circumstances in their homelands. This is a case I have been making for a long time, that the government should start international discussions about a new global migration settlement, because the whole House knows that this is not just a concern for our country, but across Europe as a whole. It is vital that we must stop these dangerous journeys, that globally the UK should build on our incredible record of providing places of safety close to conflict zones. That is the way to protect people, to save lives, and to help them rebuild their homelands when conflict ends. It would also cut crime by tackling the global illegal people smuggling criminal networks, ruthless criminal gangs which, according to the National Crime Agency, fuel other serious and organised crimes from their vast profits. Mr Deputy Speaker, I have stood on the White Cliffs of Dover with Prime Minister Boris Johnson and the current Prime Minister. I want to stop the boats. But I am gravely concerned that today's bill in its current form won't do what the government wants. The House might reflect that when the immediately former Home Secretary, the former Immigration Minister, and the member for the constituency most directly affected by this crisis, among many others, all say that this bill may not work, may not deliver what the government is saying that it will, that those concerns ought to be heeded. I sincerely hope that whatever happens in voting today, the government will consider both operational and diplomatic ways forward, as I and others have been making the case for. These could so much more quickly deliver the results in the coming months that we all wish to see.
Thank you, Mr. Deputy Speaker. This is a new low even for this Tory government. This bill is spawned by overpromising on immigration for over many, many years by the Conservatives. It's constantly seeking to hoodwink people into believing that they are actually competent enough to deal with this situation. And on the balance of evidence, the courts have decided that Rwanda is not a safe country for them to send people who are seeking asylum. And the government stamps its feet and brings legislation here so that it can legislate to say that something that is wrong is right. And that is a new low that I've not experienced in all my years that I've been in here. And it's a slippery slope. When government takes that sort of power to itself, where will it stop? And some of the speeches that have been made on their own benches have raised that question. Now, I understand it that there is at least 5 different, I think they're called families over there on the Conservative benches, who all disagree with one another. I think it's 7. They've got their own sort of private version of the gangs of New York going on. But I think we're going to have a general election soon because they're going to run out of backs in which to put their respective knives. But this is the 3rd piece of legislation that we've had in just 2 years. And each time the Conservatives have told us that this is going to stop the boats. We had the Nationality and Borders Act in 2022. We've now got the Illegal Immigration Act, which is, again, we were told, was going to stop the boats. And now we've got this Safety of Rwanda Asylum, which is going to stop the boats. And I have to say, I'm really impressed with Rwanda and the stand that they've taken, because without taking a single refugee or asylum seeker, they've managed to up the ante by 3-fold. They were given 140 million to even get to the table and talk about it. And now we're told it's up to 400 million and still growing. And they haven't taken a single asylum seeker. That's an incredible feat by the government. But not just that. It's only going to be 100 or maybe possibly 200 places per year. 200 places per year. So this is going to cost, what, £2 million per person on current figures? That's an incredible achievement by the Rwandan government. I can't understand why the benches obviously aren't arguing about why the numbers are so low. They're arguing about people being able to take their cases to court, individual cases to court, but they don't seem to be concerned about the fact that this is such a small number that it's hardly likely to be much of a deterrent when so few people will actually be sent in any one year. So, yes, I will.
Gregory Campbell.
Thank the honourable member for giving me. He's waxing eloquent on the issue of Rwandans' excellence at negotiating with the government. Would you agree with me that the Rwandan authorities seem to have hoodwinked the UN as well?
I won't go down that rabbit hole if the honourable member forgives me, but I think that they've done an incredible job. But furthermore, they've had to rein in the Conservatives because they've had to say, we've also got international agreements, we've also got treaties and agreements with other countries that require us to abide by international laws and conventions. And if you, UK government, don't want to abide by them, we certainly do. So they've prevented the Conservatives, saved them from themselves almost, from going too far in terms of breaching international laws and international conventions. And so I've listened with interest to the speeches over there. That gangway has never seemed so wide. It seems to be the equivalent of the Berlin Wall for the left and right of the Conservative Party. But it does seem to me, standing here, listening to the speeches, that are completely irreconcilable in terms of those that want to defend the rule of law and the rights of individuals to seek their rights to be upheld in a court and to have a right to go to that court, and those that want to take that power away. And people have made it quite clear that they're not going to vote for legislation if it doesn't satisfy their requirements. But the two requirements are completely at opposite ends to one another and totally and utterly irreconcilable. So I don't understand, I don't see how the Prime Minister is going to resolve this conundrum. I think he has managed to clearly, from the expression on his face earlier on today, he's clearly managed to cobble together a coalition to get this bill through today, and he's confident about it. Yes, sir.
Thank you very much for giving way. I'm very grateful for his reflections on the Conservative Party. What are his reflections on the Labour Party's policy or absence of one?
Well, you see, so I hear this all the time from the Conservatives. That Labour they don't have a policy. Well, one, it would be nice if one of the policies that has been implemented by this government over the last few years actually worked. That would have been a revelation. That would have been a revelation. But what I would commend, a bit of silence over there. What I would commend the government for is the arrangement it's made with Albania. That's the sort of route we should be going down. They've stood at that dispatch box today, and we brought them the small boats crossings down by a third, and that is largely due to the agreement with Albania. And you can't dispute that. That is a fact. And so by being practical about it and dealing with things at source, you can actually resolve this problem. So dealing with the gangs and investing in dealing with the gangs, why is it so they're all laughing over there? But the fact is that the convictions for people trafficking people across the channel are down by 30%. Perhaps you should take a look at yourselves and understand why this problem is existing. It's because of the sheer incompetence of the government opposite. The net immigration figures, 160,000 people were included in those net immigration figures because you failed to deal with their asylum cases within a year, and the National Office of Statistics included them in the figures. That is just sheer incompetence of this Conservative government. Incompetence in dealing with people's claims, incompetence in dealing with the boats and the illegal operations that are running those boats. It's the fault of the Conservative government from beginning to end, and this Rwanda scheme is doomed to fail, and it's just because of the rhetoric of the Conservative Party that have overpromised brought us to this point where we're having to legislate that black is white and that the Tories can have their own facts.
Jackie Doyle-Price.
Thank you, Mr Deputy Speaker. This Rwanda policy is just one tool in a suite of tools which is designed to deal with stopping the boats and, more importantly, to break the criminal gangs that profit from the hope of people who just want to have a better life. Now, last week, Essex Police secured the conviction of an 11th person following the smuggling of the 39 Vietnamese who perished in my, who were found perished in my constituency. That is on top of 18 people convicted in France as part of the same smuggling operation. 29 people have been convicted of trafficking as a result of that investigation. It proves that we can break those criminal gangs if we target our resource to them. And they're the real villains of this piece. They're the people that we should be focusing on. Now, I'm happy to support this bill tonight. I've never been an enthusiastic supporter of the Rwanda policy, but I recognise that we do need a whole suite of tools with which to stop this trade, and anything which would provide a deterrence is obviously something that's welcome. But I do think we have to be realistic. You know, if someone is prepared to get into a rickety inflatable boat to get across the channel, they're going to take considerable risk. And it will only ever be a small part of this. By far the most important ingredient we have are the returns agreements. I'm glad to see that the government are still putting these front and centre of all its efforts. But that's why I really question how we've got into this ridiculous place this week where these benchers are all falling out with each other over a small element of a bigger policy. It's completely stupid. The only people who benefit are the benchers opposite. For those people who are prepared to give them a victory tonight, well, good luck to you. That's great. But some of us are actually more intent on delivering the outcome, which is stopping the boats and breaking the criminal gangs who profit from other people's misery. So I hope that everybody really reflects on what they're going to do tonight. We should never let the best be the enemy of the good. Politics is the art of the possible. We pass this bill tonight. We are that bit closer to really tackling this problem. We don't, then actually we look a laughing stock because we've marched everyone up to the top of the hill only to back down again. So I just implore my colleagues, you may not feel it totally matches your ideology when you walk into that lobby, but this is actually going one step closer to delivering the outcome that we want, which is to save people's lives and make sure fewer people die crossing that channel.
Sammy Wilson.
Thank you, Mr. Deputy Speaker. Can I first of all say that the objective of this bill is supported by our party and should be supported by all reasonable people across the United Kingdom. The issue of illegal immigration and the impact which it has had on communities across the United Kingdom, whether that's in terms of the pressure it puts on schools, the health service, housing, other public services, crime, and also, of course, the rewards which it gives to criminal gangs, means that there is a duty on this government to address this issue. The question is, does this bill actually do that? And we have heard many speeches here today, some people saying about the inadequacies, some people saying how important it is, and others saying, well, it's only really a political ploy anyway. The truth of the matter is, and I think that we have already seen similar bills being brought to this House, and despite bills of a similar nature being brought, and Rwanda being talked about, we have sent ministers and money but no migrants to Rwanda, because we have not learnt from the flaws in the previous bills. And the flaws that were in the previous bills still exist in this bill. They exist because the government is trying to get this balance between the lawyers who sit in that corner there and lecture us all about comity and responsibility and using powers responsibly. If they were using powers responsibly, the first thing they would do is live up to their manifesto commitment to deal with this problem. And secondly, pay heed to the people who are negatively impacted by illegal immigration. It's fine to talk in grand terms about the legal procedures and give us lectures on comedy and the balance between Parliament and the courts and everything else. That doesn't rank too much with people who can't get their youngsters into a school, or people who can't get the health service support to which they require, or find that wages locally are being driven down, or house rents are being pushed up. And for that reason, I think that the government has got a bill which, while it has a fine aim, it does not meet the requirements of the objectives to reach the objectives which it mentions. The one part which has been missing in all of this debate today is the impact which this bill is likely to have on Northern Ireland. Because Northern Ireland is different. This House voted to leave Northern Ireland under the control of the European Union in the Windsor Framework, the Northern Ireland Protocol, and of course we are under the remit of the European Court of Human Rights as a result of the Belfast Agreement, which the government of course is happy to change when it suits them, but then says it can't change when it doesn't suit them. And the fact of the matter is, this bill does not deal with the issues which need to be dealt with if we are to attack the arguments, the legal arguments, which illegal immigrants use to stay in the United Kingdom. I will give way, yes.
The member in 2016 on a BBC Spotlight, a constituent said to him that they were seeking to get the ethnics out, and the member appears to have said, "You're dead right." Is that why the member is so supportive of this bill?
No. Well, first of all, it was inaccurate. I did not say that. But secondly, this is all about the United Kingdom safeguarding its own borders and dealing with the kind of issues which actually in Belfast are having to be dealt with. Because despite what people may think, and despite what the Minister said in the dispatch box, Northern Ireland is greatly impacted by this. Belfast is the second city of the United Kingdom when it comes to the number of immigrants per head of population being housed, and it's causing all kinds of problems. So if the member wishes to ignore the concerns of her constituents, that's fine. I want to address them. But as it stands at present, the Charter for Fundamental Rights, Article 2.1, applies in Northern Ireland. And that has been used, and it's been recently judged by the High Court, that that is grounds for people who wish to remain in the United Kingdom after entering illegally to bring a case. Now, there have been certain aspects of European law which have been removed in this bill. That is one area which has not been. So we find that, first of all, without the change in the Charter of Fundamental Rights, Northern Ireland will be a gateway. All of the arguments which the government is hoping to disapply will be able to apply in Northern Ireland. The second thing is, of course, the European Court of Human Rights is embedded in the Good Friday Agreement, or the Belfast Agreement. That has not been dealt with. So all of the arguments used under the European Court of Human Rights will be able to apply in Northern Ireland, and the European Court of Justice will be able to make a judgment as to whether or not the requirements of the European Court of Human Rights and the Charter of Fundamental Rights are being applied when people make their case. What is the impact of that going to be? Well, the first thing is this. It is going to make Northern Ireland a magnet for people who may find that the route to stay in the United Kingdom is blocked. But in Northern Ireland, of course it won't be, because we will still be under EU immigration rules, and the European Court of Justice can make a judgment. The second thing is this. If those people decide they don't want to remain in Northern Ireland, then of course with the free movement from Northern Ireland to the rest of the United Kingdom, and indeed with the common travel area, they can move into the rest of the United Kingdom. The implication, of course, is if that becomes a large number of people, are we then going to have people barriers between Northern Ireland and the rest of the United Kingdom? These are issues which I believe either have not been even considered by the Minister or have been willfully neglected, and for that reason we cannot give support to this bill.
Sir Edward Lane.
As usual, the Honourable Member for East Antrim talks a lot of good sense. Yes. Now, Mr Deputy Speaker, I'm uniquely badly affected in my constituency because of our inability to control illegal migration. The government wants to put 2,000 illegal migrants into RAF Scampton, which we simply can't cope with locally in terms of our social services, and would probably atrophy £300 million worth of investment. So my constituents are not really focused on whether we have Rwanda or not Rwanda. They just want the boats to be stopped, or at least to be severely mitigated. And we've heard many criticisms and good knockabout stuff from the opposition, but the only solution that anybody in the world has come up with to stop illegal migration is either with pushback, which I agree in the Channel is uniquely difficult, or offshoring, and nothing works. And therefore, we have to do something. The world is in such a perilous and parlous state that there is no end to the misery and the number of people who want to come here. I hear that we should speed up asylum applications, all very well, but the more you speed them up, the more people will come. I hear that we should do more on the beaches of France I understand that. I don't understand why the French can't do more, but that's not going to stop them. The only thing that will work is what the government is trying to do. And it's so unfair. This morning, I mentioned the case of Mara Shabazz, a girl who was raped and abducted in Pakistan, still waiting to get here, a genuine asylum seeker. So many genuine asylum seekers can't get here because illegal migrants are abusing the system. There's nothing wrong with them individually. They're all nice young men. They just want to get a job. But if somebody comes and breaks into your house and decides to steal your stuff, the police turn up and they remove them and arrest them. But we are in an absurd situation where people are entering this country illegally, jumping the queue, putting their lives at risk, run by criminal gangs, and we are doing nothing about it. The public are just appalled. They can't understand what's going on. They don't understand why we're putting them in comfortable hotels or in comfortable former airmen's rooms. They don't know what's going on. They're paying for all this, and they want it to stop. Now, the Conservative Party, I hear of all these different groups. You know, a house divided is a house that's going to be destroyed. We have to work together. There's no other solution. And I hear all the different voices that are going on. I just will say that the Society of Conservative Lawyers, the Policy Exchange, not left-wing groups think this bill will work. The government thinks it will work. The ERG has some doubts. But we just have to work together to try and get this bill through, get it through Parliament as quickly as possible, get it through the Lords, and try and stop the boats. Now, we can legislate all we want to ignore the ECHR, including Rule 39, interim measures. But even if we did so, we would very soon face a final judgment from the Strasbourg Court, which everyone agrees we would be bound by. That's the legal situation. The only way we can remove the Strasbourg Court is by leaving the ECHR. And that may well happen, but the government doesn't have a mandate to do that at the moment. It can't get it through Parliament. It's a matter, I suspect, for the next manifesto. Meanwhile, this bill probably goes just about as far as we can do. I'm sorry, but that's all we can get through Parliament, and we have to be realistic. Now, as both the Society of Conservative Lawyers and Policy Exchange accept, a bill would not be workable if it did not allow for narrow claims for individual circumstances. Even the Star Chamber of ERG report seems to accept that there should be some possibility of claims in cases of bad faith. The key question is whether our system can process and dismiss these spurious claims quickly enough. Under the arrangements we have in relation to removal to Albania, illegal migrants have even wider avenues for claims, but this has still led to a 90% fall in small boats' arrival from Albania. So I do think the bill is roughly in the right ballpark, but I hope that ahead of the committee stage, the government will consider whether Clause 4 can be tightened further and whether the government can share further evidence of the ability to process and deal with spurious claims. It's a question of will. In 1939, you know, when we were facing a sort of world war and a crisis, we overnight exported. Well, I give away very quickly, yes.
Very grateful to the Honourable Gentleman for giving way. What does he think of the reciprocal arrangement for the Rwandan government to send asylum seekers to this country?
Of course, none of us like any of this, but we have to get it through the courts. We have to get it through Parliament. We have to be realistic. The Supreme Court has opined that there is a risk, I would say a vanishingly small risk, that failed asylum seekers might be sent back to Iraq or Syria, and therefore, in order to get it through Parliament, in order to get it past the Supreme Court, the government had to make this concession. We don't like it, but that's the real world. Politics is about reality, and therefore, this bill must go through. It must be dealt with as quickly as possible. And the onus on the government is now to ensure that we can speed up these cases. It would be ludicrous if many hundreds of people, illegal migrants, having come here illegally, were allowed to delay these matters for up to a year by going to a tribunal, by going to the High Court, by going to the Court of Appeal, by going to the Supreme Court. The whole thing will be bogged up, and we will look completely ridiculous as a government. The government, in order to survive and have a hope of winning this general election, has to sort this problem out. They have to deal with the problem of legal migration. We cannot have a situation where 700,000 people are pouring into this country every year. We have to pay care staff proper salaries so we can get more of our own people working. Deal with illegal migration. Deal with legal migration. And also, by the way, build some more houses for our own people. If we start working together as a party, if we stop making personal attacks on each other, if we stop questioning our good faith, then this party has a chance. Because what have they got to offer? No solutions at all. No solutions. If they get into power, they will never sort out this problem. The only hope is for this government and this party.
Kevin Jones.
Speaker. There was a time not long ago that the USP of the Conservative Party was very predictable and consistent support for the rule of law, in favour of international treaties and organisations, and competency in the conduct of government. Alas, Mr Deputy Speaker, that has all changed if we hear the rhetoric from the benches opposite today, as we see a party which is increasingly going down a number of populist rabbit holes, fuelled, as we heard, by the member for Newark, who used the scaremongering and irresponsible rhetoric, which clearly is designed for his leadership bid after the election, rather than any statement of fact. We've also got a situation where the Conservative Party now see the courts and judges, not just in this country but abroad, as the enemy. We've got a situation where lawyers are like the pub bore, are seen as the enemy of the people, lefty lawyers and do-gooders. Where have we got to when we have a Conservative Party which now goes down this route? The only person we've heard from the bench opposite this afternoon who defended the rights of the court, an important part of our constitution, was the member for Bromley in Chislehurst. We also have a situation in this bill which was outlined by my honourable right honourable friend, the member for Garston and Halewood, and the member for Rwanda in clause 2, which is not about changing policy, this bill. It's about changing facts. It's about saying that Rwanda will be a safe country, and as long as we accept that and get it through a parliamentary majority through this House, that is a fact. It's a little bit like saying the black cat is white, as long as we get it through Parliament, irrespective of what the evidence tells you that the cat is actually black. And that is very dangerous, Mr Deputy Speaker, because I think this leads to dictatorial parliamentary democracy. And we can have the facade of democracy, and it's damaged not just to our reputation, but I also agree with the right honourable member for Swindon South when he said it's all right the government party today arguing for these, but what happens if the boot is on the other foot and we have another government which put things forward that they won't like? Now, the international treaties which we pride ourselves in were born out of the destruction and ashes of the Second World War. Today, they're being defended on the battlefields of Ukraine. And it saddens me to hear the Honourable Member for Gainsborough and others wishing to just throw away these conventions. Or like the member for Devizes, who wants to pick and mix which bit of the international treaties we should actually abide by. And it is a little ironic, as the member for Rwanda said, is that Rwanda is giving a nation such as of Great Britain a lesson in international law. My honourable friend, the member for Knowsley, said that the government is governing in slogans. Yes, he's right, but those slogans come with a cost. £300 million of taxpayers' money already wasted, possibly another £100 million to go on a system which the Department's Home Permanent Secretary said will not work, and the money having to be signed off by ministerial order rather than by the civil servants. And is this the first try? No, my honourable friend, the member for Feltham, said this is the third bite of the cherry in terms of trying to solve this problem. The member for Bournemouth West said we need to keep the faith and be straight with the public. Well, Mr Deputy Speaker, we do need to be straight with the public. This bill not only won't work, it will also damage the international reputation of this country. It will also end a situation where, expectations are raised, taxpayers' money is wasted, and it needs to be ditched. And that's why we're voting against it tonight. I look at the spectacle of the Conservative Party tearing itself apart with interest, like we all do. But that coalition, which is a Conservative Party, which I may disagree with myself politically, I have respect for some individuals in it. What's happening now is not good, I think, for our democracy. Sadly, the tired old nag, which is this government, will only be put out of its misery when we have a general election.
Dr. Ben Spencer.
Thank you, Mr. Deputy Speaker. Our country finds itself in a very difficult situation, and the government rightly made a commitment to the public that we would both stem illegal immigration and protect our borders, while upholding our moral and legal duty to offer refuge to those fleeing violence or persecution. Our efforts to stop people dying in the Channel, to stop the criminal gangs, to stop the boats, have been opposed at every turn. Opposed by the party opposite, opposed through the legal system, and of course, opposed by the criminal gangs profiting from the dangerous and illegal routes. It is claimed that this is a UK problem alone, that it's our government's problem alone, but it's in fact a problem shared with our neighbours and allies across Europe who face their own, often greater, challenges with illegal immigration. And these challenges are not going away, but instead, with the consequences of climate change and global instability, they are likely to only get worse. Our approach to asylum needs to be fair, both to the asylum seekers themselves and our communities have opened their hearts and homes to those seeking refuge, but it must be through safe and legal routes. We cannot cede control of our borders to criminal gangs. We must tackle illegal immigration. Now, the European Convention on Human Rights is often cited as the barrier preventing control of our borders. And I'm proud of the UK's leading role in promoting human rights across the globe. I want us to continue this and to support the ECHR. But the judgments of the court do appear to have moved away from simply guaranteeing the basic and fundamental rights enshrined in the treaty. Judgments have begun to infringe on democratic decision-making, and there appears no obvious way to hold the courts to account. It's been called judicial activism, but whatever you call it, the answer is not to withdraw from the ECHR or break international law. The answer is to come together again, as we did in 1949, to find the answers to the challenges of the present day. This will take time. Of course it will take time. And the government right now must take steps within its power to control illegal immigration. Now, colleagues may remember my unease over a previous bill which threatened to break international law. And I was unable to support that unamended. And had the same issues arisen here, my sentiment would be the same. But the difference here is that I've been assured that the bill as stands does not break international law. It is by no means perfect, and we could spend a lot of time seeking perfection. But the challenges we face are real and impacting on lives now. And I will therefore give my caveated support to this bill tonight as a near-term measure to tackle illegal immigration. But at the same time, I give my unwavering support to the government to engage with our international partners and work towards a long-term sustainable solution.
Bel Raviro-Adi.
Deputy Speaker, public services are on the verge of collapse. The gap between rich and poor has widened, and we're slipping back into a Victorian area. Food bank usage at a all-time high, and workers haven't had a decent pay rise in 15 years. But we're not here to talk about that today. In fact, we're barely here to talk about those things in any meaningful way. We are here to legislate on the dog-whistle fantasist policies of the party opposite, electioneering when they should be governing, not offering any real solutions to problems, and attempting to divert attention from their own failings as a government, wasting the time of this House and squandering the goodwill of the people of this country. We keep going round and round on this matter. And our Supreme Court has ruled on this. It found Rwanda to be unsafe. This was based on evidence. Legislating the opposite is not going to rid us of the facts. This is not an exercise in parliamentary sovereignty. It's actually an abuse of this parliament's functions. It undermines the rule of law and the constitutional separation of powers. Yes, we are lawmakers and we can make and change the law, but the law cannot be used to change the facts. And another fact is that this treaty with Rwanda, coupled with the bill, actually breaches many of our obligations under international law. And if we were in doubt in any way, the government has helpfully outlined this throughout the entire bill. Clause 3, for example, excludes the applications of key sections of the Human Rights Act. It directly prevents the courts from applying the bill in a way that is compatible with convention rights. It prevents any consideration of previous rulings from the European Court of Human Rights that have found Rwanda unsafe, and it removes human rights obligations from public bodies, including courts. This bill would place an obligation on every single decision maker that has found Rwanda unsafe to simply rule it as safe. It restricts the court's ability to protect people at risk of harm, and it restricts individual legal protections. Does the government fully understand what this means? Do they see how far they have sunk? That they are so fanatic about this flawed policy that they would bar courts from considering the very reasons that Rwanda might be unsafe, stripping people of individual legal protections? From its very outset, Mr Deputy Speaker, this bill is ridiculous. Honourable members opposite would do well to note that there is no more empire. International law is not whatever we say it is. It's comprised of agreements and treaties adopted by members of this House. To dismiss these as the rules of foreign courts is as irresponsible as it is untrue. We signed up to these solemn and binding rules, so this bill actually risks our international reputation and it makes us hypocrites. How dare we condemn other countries that do not uphold international law, and how dare we preach to them when we would undermine the rule of law? But this government doesn't really care for that. It cares more for the squabbles of its own party than our standing as a country. If this government were actually serious about resolving the issues surrounding small boats, they would actually do more to target people traffickers. They would provide safe and legal routes. People do not take these perilous journeys for fun. They are often fleeing some of the worst persecution. They are some of the most vulnerable people in the world, not the party opposite scapegoats. It's already been said today, but those who seek asylum from countries like Ukraine and Hong Kong don't have to come by unconventional means because the government has given them the ability to do so. So the government needs to stop misleading the public with its use of the word illegal, because seeking asylum in this country is not illegal. It's not against any of our laws, domestic or international, and it is the government that has exacerbated the asylum system, not the vulnerable people that are seeking asylum. And we know this because the vast majority of claims are justified. After lengthy delays, 3/4 of applications are accepted, and the longer these processes drag on, the longer refugees and asylum seekers are prevented from rebuilding their lives here in this country, working and contributing to our economy. This government has already spent hundreds of millions of pounds on a policy that is as crap as it is unworkable. And there is nothing... And there is nothing more telling than the fact that the Secretary of State has been unable to make a Section 19 statement. He could not say that this bill was compatible with the Convention on Human Rights. The Home Secretary means to take us all for fools. For the second time this year, he cannot say that his plans for removing asylum seekers to Rwanda will not break international law. The Rwandan government have been very clear. They have said they will not continue with this deal if it does not meet the highest standards of international law. This bill does not do this. This government is wasting our time. This is not going to work. And I'm not even sure it was meant to. Mr Deputy Speaker, I'm sick and tired of being dragged through this House to approve legislation that does nothing to improve the lives of my constituents or uphold the values of our society. This bill should simply not be allowed to go any further. Thank you.
Thank you very much. And I'm sure that when all members rush to read Hansard tomorrow, they will hear the word or read the word crass. Thank you. Thank you. Crass. And I'm sure Hansard have just taken a note of that. David Simmons.
Thank you, Mr Deputy Speaker. May I draw the House's attention to my register of interests. Mr Deputy Speaker, the starting point for the debate that we are having today has been the good work of a series of Conservative education, immigration ministers working closely with their counterparts in France. In particular, it's worth recalling the contribution of our late colleague James Brokenshire, who's worked with the French authorities to increase the security at the ferry terminals, the lorry parks, and in particular around the Channel Tunnel in northern France, has been, whilst enormously successful in reducing the numbers, putting their lives at risk, smuggling themselves to the UK by that route, has been instrumental in driving those gangs to use small boats across the Channel as the means of carrying on their trade. Mr Deputy Speaker, I started out as something of a Rwanda sceptic, but having spent many years in local government and seen the cost challenges that face many of our local authorities supporting refugees and asylum seekers in the UK, it did seem to me a very expensive policy per capita. But having had the opportunity to reflect both on the visits I placed to the jungle in Calais in 2016, before the security measures were put in place, and what I've heard from our agencies, including both the French and the UK agencies operating against the gangs in France, and from some of those migrants themselves waiting to cross the Channel, it seems very clear to me that this is a policy which has, as part of the wider range of measures, great utility in acting as a deterrent. It will not by any means apply to everybody, and we know people will continue to come to the UK, including as they've done to the local authority in which I served, through the routes into Heathrow Airport. But a measure that helps address the particular unique circumstances that we face in the English Channel is absolutely essential. And it seems to me that this Rwanda policy and the bill set out today has enormous utility in addressing the risks that people are putting themselves to and the profits that those criminal gangs have continued to make. And Mr Deputy Speaker, a great deal of the debate has focused around the detail of the legalities of this bill. And it certainly seems to me an enormous improvement in where we've been previously, and reflects the judgment of the Supreme Court in saying the key concern that needs to be satisfied is that anybody who is sent to Rwanda as a result of this policy needs to have sufficient safeguards on their human rights, that we can be confident in particular that they would not be moved on to another country where those human rights would be abused. And that replicates the agreements that we have in respect of deportations to many other countries, and also upholds the standards that we would see from the United Nations, the European Union, from countries like Austria and Germany, which are already exploring with Rwanda and others similar arrangements in order to address their like concerns about the impact of high levels of uncontrolled migration across Europe and elsewhere. And I reflect on the fact that I am receiving a great deal of lobbying from leading figures in my local authorities who are enormously concerned that the cumulative cost of accommodating large numbers of people who've arrived in a fairly short space of time means that we are struggling to ensure that access to housing, access to education, access to other important public services is maintained to the standard that we would wish to. And that in that context, dealing with those who, as a number of members have highlighted, have effectively jumped the queue, rather than those who have played fair, who followed the correct process, who come here because of their connections to the UK, represents an unfair loss of public money for that purpose. And it seems to me also that whilst this bill is not perfect, set alongside the work that's been done by a number of ministers to improve decision making in the Home Office, the arrangements that have been made working with local authorities through things like the National Resettlement Scheme for refugee children, which has led to the fairly seamless now accommodation of more than double the number of unaccompanied asylum seeking children in the UK, that's seen additional local authority areas volunteering to become dispersal areas for asylum seekers and to take part in resettlement schemes compared to where we've been before. And the continued contribution that foreign students, 600,000 of whom we committed to bring to this country in our election manifesto of 2019, the contribution that they continue to make to our economy
which now represents a foreign currency earner larger than our oil and gas industry. So that demonstrates a migration and immigration policy that, in the round, continues to serve the interests of the British people. And I'd just like to finish on this question, Mr. Deputy Speaker. We've heard a great deal of criticism of the policy and challenges back, in particular, to those who aspire to form a government about what their policy would be. A key issue which I've not yet heard addressed, in the point that's made about a new unit with maybe 1,000 staff to act as a returns unit. If a negotiated agreement of this nature, with this legal basis with Rwanda, is not sufficient, then I think it is incumbent on the party opposite to answer which other countries are they seeking to negotiate those agreements with? To what extent have those agreements been reached? Because if returns agreements are the key policy that the Labour Party wishes to have as a point of difference, then it is clear at the moment that that emperor very much has no clothes.
Ms. Savile Roberts.
Let's not beat around the bush here. This bill is in retaliation. It is a crass payback, if you like, to the Supreme Court decision on the 15th of November that the government's Rwanda asylum plan was unlawful. This sets a dangerous precedent. It undermines the democratic contracts of the state while undermining what constitutes the truth. Declaring something to be true doesn't make it fact. Evidently, this bill also undermines the UK's international treaties and conventions, including, of course, the European Convention on Human Rights, with which the Home Secretary has stated that this bill may not comply. Sections 2, 3 and 6 through to 9 of the Human Rights Act 1998 are also disapplied. The UK government then acts hypocritically, requiring the Rwandan government to abide by the standards of international law while disapplying them itself. This bill does reputational damage to the UK at home and abroad. The government may say that others have set a precedent for this bill. This argument is flimsy. The UN Committee on Torture has expressed concerns about Denmark's intentions to move refugees elsewhere, and Israel, of course, abandoned its agreement to send Eritrean and Sudanese asylum seekers to Rwanda and Uganda, having been halted temporarily after legality challenges. This legislation faces a series of hurdles, each likely to bring it down. And it comes, of course, at an unforgivable price. It's reportedly cost $240 million so far, with another $50 million agreed. And then we heard from the Secretary of State that it's another $50 million and then yet another $50 million on top. It is in no way possible to justify this in the state of cost of living crisis which we face. And no matter what the UK government believes, Rwanda has been proven not to be a safe country for those people seeking asylum. The bill fails to address key issues raised by the Supreme Court, including that of human rights issues. Refugees have historically been ill-treated after expressing criticism of the government, with new provisions such as the appeal body untested. 15 Rwandan nationals have been granted protection since 2020, with this bill excluding Rwandan nationals from its scope. How is this compatible with any definition of a safe country? And under this bill, anyone who arrives in the UK without a legitimate visa and has travelled via a safe country would be subject to removal. But what about those people fleeing conflict zones unable to access documents such as passports and visas as embassies close down? What about the many Afghan men and women who were a crucial resource to the UK government, left stranded and in peril? Where are the safe and legal routes? This bill, of course, is an affront to Plaid Cymru's values and Wales's aim of being a true nation of sanctuary. We are proud to be on the side of equality, wanting every single person to have the same opportunities and the same access to justice, resources and services. We want to end recourse to public funds conditions and allow all migrants and people seeking asylum access to the public services they require. How this is found to be contentious by the UK government is beyond belief. Instead, of course, of electioneering and distraction policies, the government should indeed be expanding safe routes to ensure that fewer people decide to take the tortuous journey across the Channel and at the mercy of smugglers. Now, to close, Deputy Speaker, I just wanted to refer to an example, a model Professor Emma Lewis of the Department of Law in Aberystwyth, what he uses when he is teaching public law in that university, in the way that he illustrates the legislative supremacy of the UK Parliament through an imaginary potential act. The name of this imaginary potential act? Its name is the location of Aberystwyth, open brackets, on the moon, close brackets, bill. If an MP were to sponsor this act and the government were to support it, it would become law, and no court in England or Wales could overturn it. But the reality of the location of Aberystwyth would remain utterly unchanged. When we are talking about the potential of this act to change the reality, I think we would do well to learn the lesson of Professor Emma Lewis.
Well said.
Matt Warman.
Deputy Speaker, this bill tackles an issue that is vital to many of our constituents. We all know how important numbers of legal migration and amounts of illegal migration are. I know from my own constituency, a constituency that is generous and kind, but there are real tensions when 5 hotels are used for illegal migration in a town like Skegness. There is no justification for that position, and the residents being put in it are rightly angry. When we get issues such as this wrong, we strain the social fabric of our country, and the government has a duty not just to try and tackle it, but to strain every sinew to try and tackle it. So I welcome, perhaps surprisingly even to myself, I welcome how far this bill goes. I welcome the fact that it is doing something novel. But I am uncomfortable in that position, because what this bill does is to go up to the line of international law. And international law is important, Mr. Deputy Speaker, not because of some sentimental approach about what it means, or even the fact that Britain was involved in writing some of it. It's important for 2 reasons to me. One, because it is the foundation upon which we are able to do the deals with other countries, for instance, Albania, France, Italy, that allow us to tackle illegal migration. Because Rwanda cannot be the only thing that we do. Rwanda has to be, if it is to happen, a part of a meaningful package of measures. And if we go so far in one direction to try and ensure that flights to Rwanda take off, we will knock out other important parts of the deal that we need to do. So we need to be very careful about walking a tightrope, because when I say that I am uncomfortable on that tightrope, I think others are uncomfortable for a very different reason. But that is what successful compromise on all sides looks like. If we try and go further, the risk is not just that we undermine our whole approach to tackling this issue with a multi-pronged approach. It also risks simply undermining Britain's whole standing in the world. So we'll have a policy that won't work and a country that is less than where we started. No one in this House, I think, wants that. And there is, to use the phrase that's been around so much recently, the simple risk that we make the perfect the enemy of the good. This has been called by people with a star chamber. We shouldn't perhaps forget that it was the very first star chamber that started the Civil War in England. So maybe we've had enough of star chambers, but we should be alive to the fact that even the star chamber that has been convened so recently declared this a partial solution. And there's a danger of saying that something is a partial solution and therefore it is no good. For me, a partial solution is better than no solution. And we have to, I think tonight, grasp that nettle that says, yes, much of this is uncomfortable for many across the Conservative Party. But we should be united in our desire to tackle what is an issue that matters to all of our constituents, and we should have no shame in saying that this is a plan that we can get behind, and it contrasts so sharply with the total lack of a plan from the other side of the House. If you want to criticise the Conservative approach, and people I gather do, then it is incumbent on those people to come up with their ideas, and not simply to say we'll employ more people to do it, because the fact is this government has already employed more people to do it. Not simply to say we will try harder. The BBC accused the Labour Party of replacing a bill simply with hope. And I thought that was generous, if I was honest. But there has to be an alternative, a responsible opposition, a responsible aspirational government surely has to come up with those plans, and yet we hear nothing. So the twofold reason to get behind what we have in front of us is that it is an idea that will work in terms of making a difference to this critical problem. But it is also the only idea in town. The reason we have found ourselves in this excruciatingly difficult position is simply because it is an intractable problem. And I think in the absence of better ideas, people need to be careful what they wish for. So I will give way.
I mean, he's standing there, Mr Deputy Speaker, saying that there's no credible options, when we have heard multiple speakers and multiple organisations and lawyers say that there are credible options, create safe routes and stop making people illegal, because no one is illegal. People are human beings and they are coming here for very good reasons, coming from countries that we've happily gone and bombed and interfered in, and now we're not willing to take people in their hour of need.
I simply don't understand a line that says we're not willing to take people in their hour of need. When you look at the Ukraine scheme, you look at the Hong Kong scheme, there is huge evidence of this country and dare I say it, England more than Scotland, housing those people who are in their hour of need. So I think it is right. She is right to say that safe routes are a crucial part of this problem. And I agree with her insofar as it goes, but that shouldn't be a stick to beat people with in pretending that we haven't played a huge part. The role of the UK is one that we should be immensely proud of. But, as I say, I find myself voting for this bill this evening, not with huge enthusiasm, for anything other than the concept of addressing a problem that we have a moral duty to address. And I want to end by saying that the view from a constituency such as mine, which has a long history of a complex relationship with migration, is that when politicians make promises that they don't keep, it fractures not just the social fabric, but also that vital democratic thread that gives us legitimacy when we come here. So we have a duty to tackle the issue, we have a duty to do so in a way that makes a meaningful difference, and I think we have a duty to unite behind a plan, even if we don't think it's perfect, that will make a real difference tonight. Thank you, Mr Deputy.
Thank you very much. Florence Shalami.
Thank you, Mr Deputy Speaker. I was just thinking about, I attended my son's nativity play this morning. He was an angel, 6-year-old. Yeah. And just remembering the story, obviously, of baby Jesus and Mary and Joseph, and the fact of, you know, the young children were playing the knocking noise of trying to find a room, and there was no space and no room, being turned away. And I just think about what's happened to our basic decency as a country. What's happened to our compassion? Where people are fleeing, we just want to close the door on them. And I think about the fact that our public services over the last 13 years under this government have left us with a dysfunctional asylum system. The figures show that at the end of September this year, over 160,000 people were waiting for an initial decision. And we should also remember that 75% of asylum claims are granted on the initial decisions, and half of those appeals against initial appeals were allowed, doubling the amount from in 2010. And we're talking about people fleeing war. We're talking about people fleeing persecution. And they go through so much stress that I hope that none of us in this house would ever want to experience. And these are people who just want to start a new life after leaving their country of origin after such horrific circumstances. But for the vast majority of them, the welcome they get in the UK is one that waits over 6 months and running into a year. And then after that, if they're lucky, they're given just 28 days to navigate the housing system to find a job after breaking inactivity. And Mr. Deputy Speaker, I'm proud to represent Vauxhall, a place where our diversity is celebrated, it's welcomed. People are welcomed, people from all over the country, other communities making our community in Vauxhall stronger. And the current situation facing many people fleeing persecution is unacceptable and inhumane, and it gets worse. During their time waiting for a decision, their life is on hold. They're often stuck in unsuitable accommodation, including one of the hotels in my constituency. I'll give way to that one.
Way. The last time I got off the train in Paris when I was on the Council of Europe, you walk out of the main station, the Gare du Nord in Paris, and there is a row of North African men asleep in sleeping bags outside. When was the last time she saw that at a London station? Never.
I'm not really sure what reference that has, but in terms of the Honourable Lady's statement in terms of what's happening in Paris, we've got a government who is saying that people sleeping in tents shouldn't be housed. We've got a government demonising communities. We've got a government who want to demonise those communities. And I hope we never get to that situation. But the reality is that there are a number of people living in worse conditions, in hotel accommodations, living in a room with 4 of your family members with no cooking facilities, eating really bad processed food is not a way that people should be living. And this is something that her government have failed to deal with. In terms of the government looking at this mess that they've created over the last 13 years, we're all honest, and I think we all need to agree that, yes, we do need to look at urgent action to stop the exploitative gangs that are putting so many vulnerable people into terrifying and perilous boat situations. But sadly, what we've got from the government is yet again a broken plan and no clue in how we're really going to solve and address this problem. And Mr. Deputy Speaker, there are 2 reasons why I can't support this bill today. I think the first is going back to the simple waste of taxpayers' money towards achieving the government's goal. Under this scheme, 300 million of public money has been spent without a single asylum seeker being sent to Rwanda. That's £300 million of public money that's been spent on achieving nothing. That money could be spent in our schools, in our hospitals, or towards properly tackling down on the criminal smuggler gangs that facilitate dangerous crossings at source. But instead, we get a scheme that's failing and risks breaking our international obligations and diminishing our standing in the world. And I think that's why members should think hard about supporting this bill. Think about how much that money could do in all our respective constituencies. The UK government's own guidance on Rwanda says LGBT individuals can experience discrimination and abuse, including from local authorities. Now, Mr. Deputy Speaker, we must be aware of the number of refugees who flee their country of origin because of the persecution on the grounds of political repression and sexuality. My Vauxhall constituency is a proud LGBT-friendly place, and I'll always stand up to protect communities from the global persecution they face. Earlier this year at UK Black Pride, I met with African Rainbow Family, a charity that helps and supports LGBTQI people from African and BME backgrounds. And they spoke about the difficulties they've had and their members have had with navigating a Home Office system. They spoke about the long waits in terms of people waiting for their asylum claims. They spoke about the fact that they feel that continuously they're being persecuted, and that's coming from the top of this government. So we should be really worried and concerned that we are seeing a bill that wishes for us to not respect our international treaties and our obligations, but yet demonising and othering people. That should not be happening in 2023. And we see a bill that has no sign of being effective at its main aim to deter the Channel crossings. This bill pleases no one and does nothing to help solve the problems in our asylum system. Instead, we should be looking at how we can work with our international partners in our community to address some of the humanitarian crises that are the key cause of people fleeing their homes in the first instance. We should look at how we can work with those communities so people don't need to flee their homes in the first instance. We should look at how we can spend money to tackle a serious plan to crack down on the criminal gangs and clear the massive backlog in our asylum system. We've all sat on those MP surgeries raising cases, and I see the right honourable member in the front. He was very helpful when he was immigration minister. Sitting down, raising those cases that have been there before I was elected 4 years ago, cases of people who are still waiting for an answer from the Home Office. That's what we should be doing. So I urge the government to withdraw this bill and look at other ways to help people.
Nick Fletcher.
Thank you, Mr Deputy Speaker. I've said it before and I'll say it again. Doncaster is full. Now, I often get challenged, I often get challenged as a Christian when I say Doncaster is full. But I don't think it's very Christian putting people in boats that are going to, obviously, sadly, sometimes fall. I don't think it's Christian promising people a life in this country when we don't have the services for them. And I don't think it's Christian taking the best people from developing countries because we don't train our own in this country. I don't think it's Christian when my constituents are having to put up with immigration at the levels that they are. Now, we've heard the lawyers in this House speak so eloquently, as they often do, and we hear the left-wing lawyers do the same. But the lawyers in this place, at least they are probably trying to help, at least on this side of the House. Unfortunately, outside, we have left-wing lawyers making six-figure salaries, calling me awful, and people like myself. We have TV pundits on seven-figure salaries, paid by my constituents through TV licences, again calling me awful. Well, I asked these people on these huge salaries, on these seven-figure salaries, I asked them to sell everything that they've got. I asked them to give it all away. Then I asked them to come and get a job in Doncaster, probably on £25,000, £30,000 a year. I asked them to find themselves a partner and then probably go and buy that dream house. Now, they buy that dream house, a three-bedroom semi and mid-terraced. They make the garden nice, the kids play in the garden. They've got a couple next door who've got kids themselves, and everything's rosy. Then all of a sudden, the neighbour decides to move on, he gets a job or he moves somewhere else. And that house turned into an HMO. And then we have 9 people who don't speak English anymore, bed hopping, which is what's happening, and it's no good saying it's not happening, it's happening. And it's happening. And if anyone wants to come and have a look, then please come and have a look. Because, I'm sorry, you're burying your head in your sands, trying to make yourselves look good in front of people to get votes. But this is happening, and it's happening in Doncaster, and it's happening in places throughout this country, and we are turning parts of our community into a ghetto. And this is what is happening. Now, all of a sudden, you're living next door to an HMO, and you've got comings and goings at 2 o'clock in the morning, 3 o'clock in the morning, people outside smoking. The grass doesn't get cut anymore, the windows don't get cleaned anymore, and unfortunately, you feel scared to let your child play out in the garden anymore. Now, there's no gated communities here to make people feel safe, because we're not on seven-figure salaries anymore. You're earning £30,000 now, remember? That's what you're earning. So the only protection that you've got is a lock on a door and a council that might put a public space protection order in, but not enforce it anymore. Now, this is what's happening. You can't sell your house anymore, and if you do, you have to sell it at a discount. Your little child falls over in the street and you have to go to A&E, and you get a 12-hour waiting list. And the reason why the waiting list is so long is because people don't speak English in these places anymore. And this is what is happening. You then go to the schools, and the schools classes are over and oversized. And this is what's happening. Now, you can shout me down, you can say what you want, I really don't care. But this is what's happening. And we have to tackle this illegal immigration and this immigration because it is not fair. Because that couple that I'm talking about are paying their taxes week in, week out. They expect to live on nice streets. They expect to be able to have the services there for them that they pay for week in, week out. And they don't expect to be called racist or xenophobic for saying, we liked it as it was. And if we're going to have immigration, which I don't completely believe is a bad thing to do, it just needs to be controlled immigration, and that's what I was set down here to do. I'm only here because of Brexit. The people of Doncaster had had enough, and they wanted control of their borders. And unless we get control of their borders, Secretary of State, ministers, unless we get control of their borders, we will not be coming back down here. I will not be coming back down here again. And the worst thing that... And you might cheer, but the people of Doncaster are not cheering because it's the first time they've had a Conservative MP to hold the Socialist Labour Council to account, who've been left to get away with murder for the last 60 years. It is absolutely atrocious. And so, I will back this bill. I will back it today. But we've got friends on this side of the House who want this bill stronger. And I'm going to work with them. I'm hopefully going to work with you. Because we must make this work. We have to stop the boats. It's what the Prime Minister has said, and I will back him until we don't. We must stop the boats. Thank you.
Joanna Cherry.
Thank you, Mr Deputy Speaker. I feel like I've been sucked back in time to listen to Enoch Powell's Rivers of Blood speech again. I represent a multicultural constituency in Edinburgh South West with many immigrants, many asylum seekers, many refugees. And I can tell you that my constituents don't support this bill. I was stopped in the street by all sorts of people at the weekend telling me that they hoped I would make a speech against this bill because they find it repugnant. And the member who's just spoken perhaps needs to inform his constituents that the reason they live in the sort of conditions he describes and the reason they have such low wages is not because of immigration, but because of more than 10 years of Tory government. But anyway, Mr Deputy Speaker, what I intend to focus upon is the law, not as a lefty lawyer, but as somebody who tries to look like lawyers are bound to do, look dispassionately at the law. And if you listen to the public debate in the media anyway about this bill, you could be forgiven for thinking that the debate about the legality of the bill was confined to the competing tribes within the Conservative Party. Fortunately, it's not. And there are sources of advice independent of the government and independent of their querulous backbenchers. And it's on them that I want to focus. In particular, the Joint Committee on Human Rights, the chair this morning, published a briefing based on the independent legal advice which has been given to the committee. That's independent legal advice to the committee for the benefit of all members of Parliament and peers. And that's why it's been published. I've also had occasion to consider the briefing published by the Bingham Centre for the Rule of Law. And they're both very important, Mr Deputy Speaker, because the government are trying to position themselves as having stopped short of breaching international law. But what these briefings make clear, what these independent briefings make clear, is that the government haven't stopped short of breaching international law. The bill undermines the principles of the rule of law and the separation of powers, which are supposedly central to the British Constitution, as well as undermining various of our international obligations. And I would commend to honourable members reading the independent legal advice that's been given to the Joint Committee on Human Rights. I'm just going to take a few highlights from it. Requiring the courts to conclude that Rwanda is safe, even though the evidence has been assessed by the UK's highest courts to establish that it is not, is a remarkable thing for a piece of legislation to do. If the government were so confident that Rwanda is suddenly safe and has suddenly become safe in the last month, as I said earlier in my intervention, why pass this bill at all? Another point in the Joint Committee on Human Rights legal analysis. Disapplying the Human Rights Act is very significant. If human rights protections are disapplied when they cause problems for a policy goal, they lose their fundamental and universal quality that characterises them. And this is arguably particularly the case when they are disapplied in respect of a particular group. In this case, my own aside, Mr Deputy Speaker, I'll just remind the House that history shows that withdrawing human rights from a particular group, when a country does that, it's on a particularly slippery slope. The Joint Committee on Human Rights, our independent legal advice, also makes it very clear that But crucially, no matter what the legislation says, it can affect only domestic law, and that was the point of my intervention in the Honourable Member for Stowe much earlier this afternoon. As the Supreme Court explained only a month ago, the United Kingdom is prohibited from allowing refoulement under the Refugee Convention and the ECHR, as well as under the UN Convention Against Torture and the International Covenant on Civil and Political Rights. All of these obligations are obligations to which we have signed up in international law. Passing this bill will not change the fact that we're signed up to those obligations in international law, and it won't change the fact that we are breaching our international legal obligations. So the members on the opposite benches, particularly the lawyers who've convinced themselves that it's okay to go through the lobbies and vote for the second reading of this bill tonight, are simply wrong. And if they look at the independent and legal advice from the JCHR and indeed from the Bingham Centre on the rule of law, they will see that that is the case. Yes, I will give way.
I thank my honourable friends for giving way. Isn't the fundamental part of the problem with this bill is that so many people see it as punishing the exploited and not the exploiter, and that if the government was serious about this issue, that's exactly what they would focus on?
Well, indeed, and you know, it's been suggested by a number of speakers this afternoon that no alternatives have been suggested to this bill, but alternatives have been suggested. Yeah. A serious attempt to break the model of the people smugglers. Proper international cooperation. Unfortunately, because of Brexit and because of the government's attitude towards international law, the United Kingdom's opportunities for international cooperation are becoming few and far between, because people don't trust us any longer and we don't have the same avenues for international cooperation as we used to have. Creating safe and legal routes. That's the way to do it. That's what we used to have. People who are seeking asylum are not seeking asylum illegally, but they come across the channel because they've no other way to seek asylum unless they come to the country. So create legal routes. I will in a moment, but I want to say something about how this bill impinges on Scotland. And I want to make very clear that when members opposite talk about their mandate and their constituents wanting this bill, people in Scotland don't want this bill. It's not the approach that we want in Scotland. And so, therefore, it's particularly egregious that this bill seeks to oust the jurisdiction of the Scottish courts in relation to such fundamental matters as human rights and the basic tenets of our constitution. Now, Mr Deputy Speaker, Scotland's system of civil justice is a devolved matter under the Scotland Act, and therefore it's the preserve of the Scottish Parliament. Yet I don't see any legislative consent motion being sought, despite the fact that the jurisdiction of the Scottish courts is being ousted. Perhaps even more importantly, historically, and it's rather important to those of us who are Scots lawyers, the authority and privileges of the Court of Session, including its inherent supervisory jurisdiction, are protected by Article 19 of the Treaty of Union. And that includes the noble officium of the Court of Session, a power that exists to give remedies where otherwise there would be no other remedy. And that's also arguably threatened by this bill. Now, I know the government's not terribly interested in Scotland, but I do wonder whether the government's applied its mind to whether there should have been a legislative consent motion here, and to whether this legislation is in breach of the Treaty of Union by ousting the jurisdiction of the Scottish courts. And I see the Minister looking at his notes. I'd be particularly interested to hear him answer those points in his sum-up. Thank you.
James Daly.
Much, Mr Deputy Speaker, and I think after some of the contributions I must make reference to my Register of Members' interest as a lawyer, as a solicitor of nearly 20 years. And the one thing that has happened on every day of my working life through those 20 years is that every lawyer I've met disagrees with every other lawyer about the issue that's in front of them. And one of the things that I can guarantee is that your advice tends to be somewhat in line with the instruction from your client and the ends that your client wants. And so some of the legal advice that has been referred to in this chamber and the sources it has come from, people may want to ponder in respect of that. I, in my time in this chamber, have been on the Justice Select Committee for 4 years. I'm on the Home Affairs Select Committee. I went with my honourable friend from Barrow, who's no longer in his place, and I will call my honourable friend from Hull over there, the chair of the Select Committee. We went to Calais on a trip, and we went on the beaches of Calais, and we spoke to people, and we saw what some may call a functioning asylum system or immigration system within France. That is not what I witnessed in the slightest. Calais is effectively a waiting room without any resources put into it, where people are directed as a waiting room to wait for a boat to come into the United Kingdom. Myself, my honourable friend, we saw that essentially the immigrants who are there are housed in tents. They are treated in the most appalling manner by the French authorities, and when the French authorities get fed up with them, they literally burn the tents down, physically attack the people who are there, and throw them onto the next area or field. So the idea that we are some outlier in terms of how we treat immigrants, the immigrants that come into our country, is for the birds. Too often in this chamber, and I think it's a point very well made by a number of my friends, is that we ignore the concerns of our own constituents to pontificate about how moral and how, shall we say, how, our sort of liberal conscience. Of course, yeah.
I thank him for giving way on that. Does he agree with me that that France is supposed to be a safe country, and people do have an option when they arrive in France or any other EU country that they can claim asylum in that first safe country? And when they actually make a decision to come over the channel, they make a decision to be illegal and get involved with criminal gangs. Nobody is forcing them to do that.
I agree with my honourable friend in respect of that, and we've heard some statements here, blanket statements regarding immigration. But one of the curious things that I found when I was speaking to people with colleagues on the beaches was that all the people seeking immigration in this country were all males, were all single, were all of a certain age frame. There were virtually no females at all in any of the situations that we got taken to. And I think that we are escaping from both what our constituents want to do and the reality of what motivates people. People said to me when I was in those camps, we think, I'm paraphrasing here, but the basic point is we think and we are told that the United Kingdom streets are laced with gold, that this is something that you are going to come in here, you're going to be provided with a lot of financial support, whether it's through benefits and other things, and that is what is motivating a vast majority of these people to come into this country. Now, in terms of the comments made by the benches opposite, you would think that nobody in the world is motivated by that to come in here. Yeah. Everyone is fleeing because they are fleeing some type of persecution. Utter nonsense. Utter nonsense. Our constituents expect us as a government, as a parliament, to put in place a suite of measures that is going to address the problem that is happening in the Channel. Yeah. This, as my honourable friend, many honourable friends have said, is one of a number of measures this government has taken. This government should be congratulated for that. Yeah. And as my honourable friend from Barrow said, nobody seems to pick this point up. The French authorities said to us when we were there that a deterrent effect, a deterrent policy, the Rwanda policy, is absolutely necessary. And we saw, and the French authorities saw, when this policy was first announced and it was thought that when people were going and were potentially coming over the Channel, they saw a drop in cases. The spike only came when it became clear that through various legal means that this policy was not going to go forward. So not only do the French authorities think that we need a deterrent, not only are countries such as Germany, the US, Italy, Austria all saying that we need some type of policy and following the United Kingdom's lead, this is what our constituents want. We cannot have a situation where we cannot house people, where people cannot get doctor's appointments, where people can't afford a house. We can't have a situation where we have, and this may be acceptable to honourable members opposite, where we have in our prison system 10,000 foreign national offenders in our prison system. We have to take measures which reflect the will of the people, not the will of middle-class liberal consciences, which are essentially, sometimes I feel like it is more important, I think, for some to moralise than to actually be concerned about what motivates their constituents and what we should be doing in this place. In terms of the objections that I've heard to this bill, I've heard two set out, and the two ones are one in relation to Section 39 injunctions, and I would ask my honourable friend a point in respect to that, because I agree completely with my honourable friend from Devon West and Tory, Can I ask him to comment on the government's own legal advice? Because technically, Section 30, Part 39 injunctions, the government can ignore those. That is what it states. Or my old friend may be able to tell me something different. But I think that's an important part of this bill, and if he could comment on that, I would be very grateful. The second part, and I'm not quite sure because I respect every single contribution that's been made on these benches, is I cannot think that anyone, and I've certainly not read any legal advice that thinks that we should exclude the right of appeal or the right of, in extreme circumstances, the right to challenge whether you are being taken to a foreign country. And there must be circumstances. Even the Star Chamber advice says that there must be at least some form of allowance in respect to that. And so I think that the legal test that the government have been put in place, compelling evidence that somebody must show that there is compelling evidence they will suffer serious and immeasurable harm, is a strong test. I think it is going to address both legally and practically everything that our constituents want us to do. This is a good policy. It's a policy the government have worked hard to refine. It is within the bounds of international law. It is within the bounds of what this government has undertaken to the country, which is to tackle illegal migration and to stop boats crossing the channel.
Yeah. 5-minute limit now. Michael Shanks.
Thank you, Mr Deputy Speaker. I'm grateful to a priest in my constituency who recently brought to my attention the film Man for All Seasons, which I confess I'd never seen. There's a quote in it which I think is very relevant. Some men think the earth is round, others think it flat. It's a matter capable of question, but if it is flat, will the king command make it round? And if it is round, will the king's command flatten it? The proposition we have today seeks us to accept the fact that government can simply define facts as facts, even if they are not so. The attempt to bend our entire legal system to fit the will of government is a high price to pay for some meagre political cover for a party that promised to deal with a genuine issue, and I think those across the House would agree with that it is a genuine issue, and has singularly failed to do so. Now we see, and we've seen it before us in the past 5.5 hours, the Prime Minister appeasing his right flank with promises of amendments later in order to bring some people on side, and others debating the fact that those very amendments would pull them away from supporting the bill. It's a complete mess playing out before us. And what a distance this Tory party has come. Their former leader, now brought back from the wilderness as Lord Cameron, said only a decade ago, "I believe that immigration has brought significant benefits to Britain. This is our island story, open, diverse and welcoming, and I'm immensely proud of it." And from that, we get to the repugnant rhetoric of the member from Don Valley, one of the most appalling speeches I've ever heard, and he's not in his place, but it was a shameful speech. The spectacle of an immigration minister resigning from his post, not in protest at the government's novel policy, but because it doesn't go far enough, and speech after speech on that side of members criticising the bill, but then saying they're going to support it. But perhaps more important than any of the legal challenges is the moral case for why this bill must be blocked. And I take issue with the idea that we shouldn't think of any of the morality of these issues. We talk of planes and boats and targets and backlogs and forget that these are human beings seeking shelter and a better life. Indeed, the Home Office's own statistics show that at least 6 out of 10 of those who made the dangerous Channel crossing will be recognised as refugees in the asylum process. And given that many are fleeing extreme situations to embark on one of the most extreme routes possible, how can this possibly stand as any kind of deterrent?
Will my honourable friend give way on that?
I will. Thank you.
I'm very grateful to my honourable friend for giving way. Would he agree with me that those who support refugees in our country deserve our respect and should be commended by the House for their excellent work supporting refugees and local communities up and down this land?
Well, I completely agree with my honourable friend, and of course immigrants across this country have contributed so much over decades to the country that we enjoy today, and we should give them immense thanks, not least in our public services. Mr Deputy Speaker, instead of thinking of other solutions to deal with the criminal gangs that are causing such misery and death as they smuggle people across the Channel, they've decided to hold firm to a course of action that's already cost us hundreds of millions of pounds and which we've heard throughout the debate tonight will cost us even more. Instead of challenging the criminal gangs at source and building better cooperation with our European neighbours to tackle it, with a government fixated on a plan that the Home Secretary himself doesn't even seem particularly convinced by. And for what? A law that's unlikely to even succeed at the aims that it's put forward. The assumption made in this bill is not that Rwanda is a safe country, but that all decision makers must treat it as such. In other words, they have to put aside any reality that they may know and accept for the purpose of decision making that Rwanda is a safe country. There will be no recourse to appeal on the basis that someone removed to Rwanda may be sent to another country, even if it could be demonstrated that that's a genuine possibility. No recourse to appeal on the basis that a person may not receive fair consideration of their asylum claim, because the government's decided that these things are all safe. These provisions mean that only in exceptional personal circumstances would an individual have a means of legally challenging the decision. This is a deeply unsettling proposition. A government removing one of the key components of constitutional democracy, the right of any citizen to test any law in an independent court. Never could this be more important than on an issue of human rights. And the question of parliamentary sovereignty itself has already been clarified. Lord Hope stated parliamentary sovereignty is no longer, if it ever was, absolute. It's no longer right to say that freedom to legislate admits no qualification whatsoever. The bill leaves open the possibility of individual challenge to the ECHR, and we heard from a number of members today that actually that might indeed be the point at which we're back here a few months from now discussing this very issue again with a government withdrawing us from the ECHR. Mr Deputy Speaker, until a few months ago I was in the classroom teaching pupils, amongst other things, how to identify truth from sources of information. We told young people there is such a thing as objective truth. And yet here I am, in the so-called Mother of Parliaments, faced with a morally reprehensible and legally questionable farce. A charade that even, I suspect, most of the people who will eventually be persuaded to go through the iLobby tonight don't actually endorse. And at the heart of it is the idea that a government can simply state what is true, even if the evidence points the other way. It's for this House tonight to challenge the government's shoddy attempt at doing so, and to do the right thing by voting down this law.
Mayhew.
Mr. Speaker, I'm going to start by looking at the founding principles of this bill. But I think it's worth remembering that it actually tries to do what our constituents want us to do. So that's not a bad start for any bill at second reading. When I knock on doors, which I do week in, week out, I've spoken to hundreds, if not thousands, of my constituents over the last few years. Without question, the single most common issue raised in those conversations is illegal migration. So we, in this place, we owe them an absolute duty to do our very best to deliver on their wishes to produce an effective control to migration and also to illegal migration. And that's what this bill intends to do, to provide an effective deterrent that breaks the business model and will lead to stopping the votes, not by itself. It's not an isolated policy. It's part of a whole suite of policies which this government, to its enormous credit, has introduced over the last years and which is already bearing fruit. We have seen this year crossings by small boats down by a third, I think it's slightly over a third, at a time when they're going up by a third in Europe as a whole and by 80% in the Mediterranean countries. So the schemes which the government has come up with and has already implemented are working. And they include bilateral agreements with countries such as Albania, a dedication of a safe country status, which is not novel to this bill. That's had an immediate deterrent effect. It's not that everyone who's come to this country has then been immediately deported to Albania. That hasn't been the deterrent effect. It's the fact that they know that they will be, but they've stopped coming in the first place. Crossings by Albanians have dropped by 90+%. And that's why Rwanda is so important. It's not that the capacity of Rwanda has to accept every single migrant that currently comes across the channel. It's the deterrent effect to stop them coming in the first place. And we've seen it working. So why not follow the evidence? We've also got the upstream destruction of equipment. Just last week, I understand, there was a Bulgarian seizure of boats and engines and engine parts. preventing the ability to cross over the channel. And there's increased cooperation with France, which I wholeheartedly welcome, which has led to increased coastal patrols and an increased interdiction of attempts to cross the channel, although not all of them. There's been a 70% increase of raids on illegal employment in this country, and there's been an enormous increase, which I very much welcome, in the number of claims handlers to speed the process of assessment, bringing down the backlog from 90,000 to below 20,000 now. So Rwanda, the Rwanda scheme, this bill is important, but it's just one tool of many. So let's be clear what the real dispute is in this chamber today. It's not about the intentions on this side of the House. We are united in wanting an effective policy for Rwanda. Where the real dispute is, every single member on this House, on these benches, we are entirely united on that objective. It's how we get there that we're debating.
Exactly.
What we see on the other side is we want an effective deterrent. They do not want an effective deterrent. Labour and the Liberal Democrats don't. They want to scrap it, even if the Rwanda policy is demonstrated to be working. They have committed to replacing it. We want flights to take off to Rwanda, as do our constituents. They want to prevent it. We want to restore control over our asylum processes. Labour and the Liberal Democrats say the only policy is to hire more staff. Hire another 100,000. Have safe and legal routes. That was raised, and that is important. I accept that. But that does not answer the question of how many people come over in the safe and legal routes. We can have a process which welcomes everyone, but the United Nations tell us there are 108 million people in the world at the moment who have been displaced by violence from their own country. So safe and legal routes is a great cliche, it's a great strap word, but it does not solve the problem of control of our borders. So this bill, Madam Deputy Speaker, it responds to the Supreme Court judgment. It doesn't say that black is white. It doesn't say that the risk of refoulement then was a false decision by the House of Lords. It solves the problem by an international treaty preventing refoulement, and that in the very rare occasions where Rwanda may wish to export to a third country, they come back to the United Kingdom. That is sensible. That's not going against the Supreme Court. It is respecting their judgment and solving the problems which the Supreme Court raised, as they said in their judgment. And I wholeheartedly support this second reading.
Madam Deputy Speaker, there's been some absurd and ridiculous bills presented to this Parliament in the course of the past few centuries that's been in existence. But it would be hard to find a bill that is more absurd and ridiculous than this particular bill. A bill that wills something to be just because it wants it and asks us to ignore reality and experience because it decrees it is just about as absurd and ridiculous as you can get. And it takes some imagination to concoct something as comedically callous as this. And it would take a particularly warped mind to actually think that this type of rendition is a solution to anything far less a sensitive and complex immigration problem. And I have to say, Madam Deputy Speaker, it's been totally dispiriting listening to some of the contributions for honourable gentlemen and ladies from across the bench. The dehumanising language, the talk of invasions and cultural wars, treating people as commodities to be dealt with, as scourges to be legaled away. It has been absolutely appalling. And I'll single out two speeches which I think are absolutely and utterly appalling. And that was a disgraceful speech from the honourable member from Don Valley, followed in quick succession by the former Home Secretary, the member for Newark. And all I'll say, Madam Deputy Speaker, is hasn't Rwanda played an absolute blinder? They must have seen them coming from thousands of miles away, soliciting hundreds of millions of pounds from this government, and apparently they're going to get another £100 million more. But they've done all this without taking one single deportee. Go Rwanda, you have made utter mugs of this chaotic government across the road. And nobody's won from the southern Rwanda, certainly not the wretched people who are going to be subject to this ongoing problem with getting onto these boats at the mercy of all these dreadful people who smuggle people across the channel. This will do nothing to disincentivise them. If they're prepared to risk their life to come across this channel, why are they going to concern themselves with the infinitesimal chance that they might be rendered to Rwanda? It just does not make sense. And it certainly hasn't helped them, has it? I mean, I don't know if they're going to win this vote tonight, and partly it's still in the balance if that's news for honourable colleagues across the bench. I think they might just about have got it, but apparently it's still in the balance. And look at the list of all the different groups that we have. There's the One Nation group, the European Research Group, the New Conservatives, the Common Sense group. I'd love to go to one of their meetings. The Northern Research Group, the No Turning Back group, the Conservative Growth group, a group of factions that would make the People's Front of Judea look like a model of unity and political consensus. And this might be the very bill that would bring down this Conservative government. And what a hill to die on. An obsession with immigration, an obsession with stopping these small boats. And by God, they deserve to be brought down if this is a bill that's going to determine this. But here's a novel idea, Madam Deputy Speaker. Why don't we start to consider immigration as some sort of opportunity and potential boost to our society and community? Why don't we design safe and secure means to harness international talent? It seeks to flee conflict and carnage in their own country. We live in a world where the movement of peoples has never been so far-reaching and so profound. And one thing that the honourable member from New York said is that this is going to be an ongoing feature of the international community. This is going to be something that we'll have to deal with, not just for this decade, but for the rest of the century. Can we not be imaginative about solutions? Can we not look to see if there's benefits to be given by people who are the cream of their countries coming to this nation? Are we all about stopping borders, stopping people coming here, making life as miserable for the poor souls that manage to end up on our shores? I'm just pleased that this is not in my name. It is not in the name of the people of Scotland. And if we ever were in control of our immigration policy, everything that they're proposing and presenting would be the exact opposite of what we would do. Scotland rejects this. My constituents want nothing to do with this. I will proudly and defiantly be voting against this evening, and that will be in the name of the people that I represent. And I know that I will be joined by colleagues. What a disgraceful bill. What an appalling piece of legislation. It deserves to be shoved right in the furthest bin from the furthest corner of this country.
Just to advise colleagues that I will be starting the wind-ups at 6:30. Kevin Foster.
Thank you, Madam Deputy Speaker. It's somewhat comic to get a lecture on unity and financial probity from the Scottish National Party, to say the least. But, you know, well, if we really want something comic. But this bill is one that I do welcome seeing come forward, and in particular the fact that it was obviously myself, the Right Honourable Member for Witham and the Right Honourable Member for Corby, who were sort of the original architects of the Rwanda plan. And a lot of that's because we face the challenge in this country that other countries in Europe do, which is namely that there are countries where even if we turn down someone's asylum claim, we will struggle to return them too. So, for example, there are countries around the world that we would not wish to deal with those governments, or there are countries which, as a point-blank matter of policy, refuse to accept enforced immigration returns. In fact, there's some countries we even struggle to deport criminals back to them due to domestic policy, not necessarily due to concerns about the country, due to the domestic policies they adopt. Because this was touched on in a speech by a member actually opposite. You cannot just drop people off. You need to get the permission to do so. And similarly, if we cannot get a returns agreement with the safe and democratic third country that they have just left, then we need to look at what is an alternative. And that's why then looking to Rwanda came in. Rwanda is a country that is a specialist in refugee resettlement. Hearing some of the comments from opposite, you'd never know that there's 130,000 refugees in Rwanda. You wouldn't know that UNHCR relocates people to Rwanda. And that shows they are specialists in this area. That is one of the reasons we worked with this country. And in terms of looking at the Supreme Court's recent ruling, the Supreme Court's ruling was not based on the idea that Rwanda was inherently unsafe.
It wasn't based on the idea that if someone went to Rwanda, they'd actually be in danger in Rwanda. It was what was the potential for refoulement elsewhere. I expect many of the people citing the Supreme Court judgment probably didn't even bother to listen to it. And that's why it's important to look at what does this bill, and what is this bill based on? What has changed since the Supreme Court judgment that allows Parliament to take a different view to what the Supreme Court justices took, and not just on the fact that, as the member for Tory and West Devon rightly pointed out, Parliament is quite entitled to do that, but it's based on the fact that there is now a treaty that directly addresses those points, and this bill actually ratifies that treaty, makes it part of international law that guarantees against someone who goes to Rwanda, transferred from this country, for Rwanda to meet their protection needs rather than this country. So that means they will not then be transferred further on. That is the absolute core of what has changed since the Supreme Court judgment. It is why Parliament is now quite entitled to take an opinion that Rwanda is a country that is both safe in terms of people being transferred there, based on the assurances we've got that will be upgraded into international law via a treaty, and based on the clear assurances against refoulement to a third country where someone may face persecution. And that's why I do think this bill does need to get a second reading. There are clearly points of detail that we can explore at committee, and particularly the ministers on the front bench, both of which I've got huge respect for, will know my thoughts around making sure, what is going to be, particularly in the clause 4, where is the evidence threshold going to be? Particularly interesting to hear, particularly given his former role as Solicitor General, his experience in front of the courts directly, where he believes the courts may draw the line for interim relief. And one of the reasons why interim relief is always quite important is many cases, a lot of the challenges thrown up at the last minute usually fail in the end. But what they're used for is to frustrate the actual flight. Particularly when I used to deal with things like the Jamaica flights. We could only have so many a year. So you knew if you could get yourself off that flight, it would be some time before there was another one, even if your claim ultimately fell. Now, there is a wider debate to have around the refugee system. There's a debate to have around how the current law and current international practice works. We can see people, we've had examples of people who've lived in the European Union for a number of years with a visa, living there lawfully, and then come to the UK and claim they have a protection need. Well, if you've been living in a safe and democratic European country, what was your real protection need for leaving that country, particularly if you had the lawful right to be there? But those debates are not debates we can settle today. What we have before us is a bill that allows us to take forward part of our plan to tackle the issues of illegal migration. And this is why we need to make sure it gets a second reading this evening.
Thank you, Madam Deputy Speaker. And I have to say, we've heard the sounds of optimism over truth coming on from the opposite side. This idea that this is a deterrent has not yet been proven. Yet it has been cited as though it's actively deterring people from arriving in the boats. And we all know that the boats is a challenge, and it's a real problem because people are dying in the Channel. But let's be clear, this was the government that was the architect of this. This is the second time to legislate on this, and we've had the architects stand up, including the Honourable Member for Torbay just now, proud that they drew this up, but drew it up so badly that they're having to revisit the legislation. So I think it'd be a bit less proud, and frankly, proper policy making, even though I don't agree with this policy, is that you make it work before you announce it. And in fact, there's so many flaws in this that they're struggling along and believe that a headline and a pledge that this will deter people is enough. And that's not good policy making. And we've often been challenged on what we would do differently on this side. Well, the Honourable Member for Birmingham Hodge Hill and I were at that front line dealing with immigration matters in the last Labour government, and it was the Honourable Member for Birmingham Hodge Hill who was the architect of a system that meant that one person every 8 minutes was being returned. And we all know there is an issue where people who do actually, people come to my constituency, they've reached the end of the line, they know it. We talk about voluntary return, and yet it is really difficult to do that when the Home Office doesn't return your documents and you've got all of those problems. So these are people who actively want to leave because they know that's the only option now for them, and they can't do it. I mean, this government has got to look much better at the existing system that it's working. It is 13 years of downgrading the asylum system, the immigration system generally, and now all those extra people have gone into dealing with the backlog of asylum cases, of which there are 20,000 legacy cases still left. And was it the 13th of December the Prime Minister said it would get to zero? Well, he's missed that target, and there's 160,000 of people who've been backing up in the asylum system. Plus, in my constituency, all of those people, including a top surgeon, people coming in on work permits, people on student visas, all behind in the queue because all of the Home Office effort is going into the Prime Minister's pledge to deal with the backlog.
Yeah.
So you're just creating more chaos in the entire system, and that is not working. But my right honourable friend, the member for Kingston upon Hull, touched on the money. And of course, on the Public Accounts Committee, we have been trying to look at the money on this issue. I won't go through the figures because she has already said them, but in a five-year plan, and we have no figures for how much money will go to Rwanda in years 4 and 5. We asked the Permanent Secretary, both myself and the Right Honourable Lady and other members of the Public Accounts Committee yesterday. He would not be forthcoming on that figure, and he only released a figure to us when it was leaked to the International Monetary Fund by the investigations happening about why that was. That is a ridiculous way, and it is not normal parliamentary protocol to release information about major projects, especially when we're voting on them in this House, in the annual report and accounts. Just to give some colleagues who may not follow with the same enthusiasm as members of the Public Accounts Committee, the annual accounts of departments, the accounts for the financial year we're in will be published to Parliament July of next year. 15 months after the £100 million was allocated this year. That is not scrutiny. What we have with other areas, and I look at the Minister to answer on this point, or take it back to the Home Secretary, is other projects. We will get 6 monthly or even more frequent updates to the House, through committees or laid in the House, and that is not uncommon. And yet his Permanent Secretary was saying it's a normal way to do it just through the accounts. We need to see more scrutiny of this issue. If it's a flagship government policy, there is nothing to hide, so let us see those figures, and we, as both our sister committees, will work together on that issue. So it is really important we do that. And we need the tackling the backlog, we need transparency on the numbers. And I would also be grateful if the Minister could be clear if there are any conditions attached to the money going to Rwanda. We got a useful breakdown from the Permanent Secretary and Committee yesterday, which I won't repeat, but it's on the record from the committee meeting yesterday. But is there anything that if the Rwandans spent it on would be out of order? So what it spent on was reasonable things like education, health and so on. But is there anything that the Rwandans cannot spend, the money that's given to them by the UK? It would be very helpful to know that. And also there was an expression of interest in a contract for Manston and Western Jetfoil. This is a £700 million contract for the first 6 years of this. Could extend to be worth 1.16 billion over 10 years. And this is money to improve those reception centres, which definitely need improving. But the facilities are expected to be active, according to that pre-tender document, between 2030 and 2034. So I'm a bit puzzled if there's a lawful £700 million being invested in Manston and Western Jetfoil, welcome though that necessary though that may be, and yet we're being told all afternoon, I've been here for 5.5 hours, we've been told all afternoon that it's already deterring people. So if it's working so well, why is there the same need then to invest that much money in these facilities? It needs the investment, but it seems to me that the government is trying to have it both ways, and I would welcome clarity from the Minister.
Duncan Baker.
Madam Deputy Speaker, I will support this bill this evening because it is a fundamental right that a country must be able to protect its borders. And as a basic, it should know who is entering the country, and even more so if they are trying to do it illegally. And I support the bill because we simply can't rest on our laurels with the current action we have taken, as positive as that already is. We've heard it this afternoon that all across Europe, major European countries have seen illegal migration rising, 80% up in Mediterranean crossings. And yet, thanks to the steps that we have taken in this country, our numbers are down by a third. Now, people quote a third over and over again. But what does that mean? It's approximately 17,000 people down on where it was last year. And that is way down on the forecasts, which were expecting it to potentially double on where the numbers were last year. Yep. But reducing the figure and being happy with 29,000 people this year isn't stopping the problem. Stopping people being put on boats and trying to illegally enter the country requires a multifaceted approach. Return agreements have worked. Putting our border force into French control rooms has worked. And trying to dry up the supply of rubber boats has also worked. But there has to be a deterrent as well. It is simply another piece of the jigsaw, and on top of all of the other measures that we are using. And for those who seem not to be able to understand why we need that deterrent, I pose a simple question. Don't look at the situation today. Look at the tens of thousands that are crossed this year. Look through the lens of where that situation is going with migration around the world. If we don't tackle it today with a strong working deterrent, then we won't see tens of thousands of people trying to cross into the country. We will see hundreds of thousands of people trying to cross into the country. And that is the forecast that we are being shown year after year. The government's official release yesterday was the most startling statistic I've read yet. It estimates that if illegal immigration goes unaddressed, the cost of asylum and accommodation alone could increase to £32 million per day by 2026, equivalent to £11 billion a year. £11 billion a year. Just imagine how that could be used on our public services. So the government is absolutely right to use every power it has at its disposal to prevent and deter unlawful migration. And to the people who have said, we've spent an unbelievable amount of money already, 250 million, should I say, in trying to get this scheme up and running, that figure pales into insignificant amounts when you put it in the context of 11 billion a year, as I've just read out. Our NHS, our housing provision and our welfare state, indeed all of our public services, simply cannot take unsustainable levels of illegal migration. Now, I am not a lawyer, and there are all manner of opinions on whether the scheme will work or not. But my answer to that is don't let the perfect be the enemy of the good. Fair enough, as it's been said already this afternoon, it may not stop every single legal challenge, and that's fair enough. Some of those will be valid, and it doesn't have to. What it does need to be is the deterrent to help and stop and slow down the numbers that are coming. And that is why, when there is plenty of commentary on this bill, there is plenty in this to stop the spurious reasons of not taking people and being sent for asylum in Rwanda. And when I read that the UN and the EU alone have been sending refugees to Rwanda since 2019, I find it extremely difficult to understand that actually people have accused Rwanda of not being a safe country. Sure, we have to tread a fine line to have an operable bill, and one that is fair, and one that international partners will stand alongside. Plenty of times I've been told in this House, things will not happen, things will not work. We were told we wouldn't get the numbers of boats crossings down. We have by a third. Everybody said we would enter a recession. We didn't enter a recession. Everybody said that we wouldn't halve inflation. We have halved inflation. This government has done many, many things in the last year which we were told were simply unachievable, and we have achieved them, and that's why we'll back this bill tonight.
Patrick Grady.
Speaker, last week my honourable friend the member for Glasgow Central compared the Home Secretary to Humpty Dumpty in Alice in Wonderland, who uses words to mean just what he chooses them to mean. I wonder if perhaps the Prime Minister could be compared to the Red Queen who believed 6 impossible things before breakfast, that Brexit has been a success, that Britain is a soft power superpower, that the Scottish Parliament is the most powerful wee devolved assembly in the entire world, that we can reach net zero while abandoning net zero policies, or that this bill is actually going to stop irregular arrivals in the United Kingdom, or sixthly, that his party is actually going to win the next election. But I think even for that side of the House, that is too unbelievable. They don't think this bill is going to work, and they don't think they're going to win the next election. And the bill isn't going to work because it fails under the crushing weight of its own internal contradictions. Rwanda is deemed to be a safe country, desirable even as a place for asylum seekers to be processed and to remain. And the former Home Secretary didn't take my intervention earlier on. I wanted to ask her, if Rwanda is such a desirable place to be deported to, why on earth should it be a deterrent? How is it going to have a deterrent effect if the government saying this is a wonderful, safe and secure place for you to go? Maybe more people will come to the United Kingdom in the hope of being sent to Rwanda. The Republic of Rwanda is to be trusted to fulfil its obligation. I'm very happy to give way.
Speaker for giving way on this, because I think he must recognise that Rwanda has successfully resettled over 130,000 people, and that's through international institutions and norms.
Yes, so Honourable gentleman to keep within the 5 minutes. He's taken an intervention, but So
I think I've just heard the former Home Secretary encouraging more people to come to the United Kingdom so that they can be settled in Rwanda. And the Republic of Rwanda is to be trusted to fulfil its obligations under the Rwanda Treaty because the treaty is binding under customary international law. But the same bill grants the UK government derogations from that corpus of international law and instructs the courts to ignore it. And the bill is supposed to slash costs to the taxpayer of housing asylum seekers in UK hotels, but the government has already paid Rwanda hundreds of millions of pounds without a single flight taking off. And the price for this performative weak bill is a weakening of the courts and judicial system, a weakening of the UK's standing in the world, and indeed a weakening of the entire system of international law. Because if it's okay for the UK government to derogate from its international obligations and commitments when it suits, then how can the UK object to other countries, Russia or China or anywhere else for that matter, when they flaunt the rule of international law? The bill is supposed to be an assertion of parliamentary sovereignty, as if Parliament asserting particular statements simply makes them true. Well, to pick up on the theme from the member for Rutherglen who spoke earlier, perhaps then the Prime Minister should have simply brought forward a flat earth bill to assert that the earth is flat and the Home Office is empowered to simply push people and unwanted asylum seekers off the edge of it and into the cold vastness of space. Now, it might come as a surprise and perhaps even a disappointment to some elements of the Conservative backbenchers, but the earth is not flat. The earth is round, and if you keep pushing people in one direction, eventually they will come back to you. Now, it's important in all of this, Madam Deputy Speaker, to be clear that despite us debating the safety of Rwanda bill, very little of this debate is actually about the safety of Rwanda. In 2018, I had the huge privilege of visiting Rwanda with the CPA. It's a beautiful country, it has huge potential, and the people there have had to live through horrors and overcome unimaginable difficulties. But for wealthy tourists and those who fly in to go on safari and stay in nice hotels, Rwanda is indeed a safe and welcoming country. But for citizens who speak up too loudly with questions about the regime, who perhaps ask why international observers have been unable to report that presidential elections have been free or fair, or perhaps people who belong to the LGBT+ community in that country, or indeed if there are Rwandan citizens who live in London under the protection of the Metropolitan Police because they're being sought by their own country's intelligence services, perhaps they might not find it as safe and welcoming. And whatever the bill might say, the UK Supreme Court has made a finding of fact that asylum seekers sent to Rwanda are at risk of refoulement, and simply saying they're not doesn't change that fact. Really, though, the question of the safety of Rwanda is a distraction. The very principle or idea of forcing people to move to another country, to any other country, against their will, should be enough to oppose the government's policies. People seeking asylum have chosen to come here to the United Kingdom for good reason, perhaps because they have friends or family, or perhaps simply, yes, because they do speak the language. But if someone has chosen to seek asylum here, they should be assessed here, and if their claim is valid, they should be allowed to remain. And if their claim isn't valid, then by definition, it ought to be safe to return them to their country of origin. Perhaps the most remarkable thing, Madam Deputy Speaker, is that this time last week, this bill didn't even exist. In less than 7 days, the Prime Minister has brought himself, and possibly his government and party, to a crisis point entirely of their own making. It's a bill that nobody wants and nobody likes. It's another creaking internal Conservative contradiction. Too extreme for the mainstream of the party, not extreme enough for the Red Wallers, the ERG and the Maastricht rebels who simply can't get enough of the sweet dopamine hit that comes with rebelling against the party and getting invited onto all kinds of podcasts. Some of them have been at it since the 1990s, and they just have to keep getting more extreme in their rebellions to achieve the same hit. Well, Scotland wants none of it, Madam Deputy Speaker. The constituents I hear from in Glasgow North, and the constituents, indeed, who are refugees, want to play a full and active part in our society and economy. If the government wants bills that will change the actual reality of the situation, they can devolve the power over immigration to the Scottish Parliament, or they can give us the chance to choose a better, fairer future that respects human rights and global citizenship by becoming an independent country in a referendum.
Richard Graham.
Madam Deputy Speaker. I would say it's a pleasure to follow the member for Glasgow North who served on the Westminster Foundation with me. But he did rehash quite a lot of what was said on the benches opposite, with various misunderstandings and inaccuracies, and had his moment of fun trying to describe different groups of colleagues on this side. But let me pull him back to something that he will recognise, as I think all colleagues in this House will. A conversation I had with a distinguished, recently retired UN senior official, and previous to that, British ambassador in several countries in Africa. And he not only painted for me, but also described for me factually the statistical possibilities of what is going on in that great continent in the moment. And he described vividly the combination of civil wars, mismanagement, instability, insecurity, climate change challenges and food shortages, which are affecting millions of people in Africa. And of course we know that is also added to the incredible level of insecurity in the Middle East and indeed further east from there as well. So all of this actually amounts, Madam Deputy Speaker, to one of the great challenges for democracy in our time, because we are dealing with a huge issue that is going to get bigger, and we are all going to be stretched in what our answers to those challenges are. It is not just us in the United Kingdom, as we know. There are issues happening in the Netherlands, Hungary, Italy, France, Denmark, France, you name it. All our European neighbours are wrestling with similar challenges. And therefore it is simply not enough for members of the opposition to point at various things that they don't like about this bill without really considering what a constructive alternative might look like. When, for example, the member for Edinburgh East said earlier that immigration should be looked at as an opportunity to be seized, not a problem to be managed, he is right in part, but he would be more convincing if county after county in Scotland were taking more asylum seekers now and putting up their hand to the government of the United Kingdom in order to take more. Because the truth is that it is, of course, also a challenge to be managed. So, as part of a practical response, because we do not outsource immigration to people smugglers, the point of stopping the boats and the point of the Rwanda Safety Bill is to have, in effect, a trailblazing role to play, not just for us, but for other countries. Because on balance, I believe that we will see more of such agreements rather than this being the only one. And while I've always taken the view that none of us can be sure that the Rwanda scheme will work in terms of the numbers of asylum seekers who will transfer to Kigali, keeping an open mind and not assuming, to quote the Labour amendment today, that this won't work to tackle smuggling gangs, won't work to end small boat crossings, won't work to achieve the core purposes of the bill, while only applying to less than 1% of those who claim asylum, is fundamentally wrong. And we can show that in a number of different ways. The first one is, will it actually act as a deterrent? Well, Migration Watch says it will be a powerful deterrent if illegal migrants are swiftly and continually sent to Rwanda. So how many would we be able to send? Well, the Rwanda spokesman himself said only a few days ago that we are ready and willing to take in as many people as the UK is able to send. So for all those people on the other side who talked about 100 or 200 people going, that is not at all the potential of this scheme. And as other people have mentioned, I'm sorry, I can't take any interventions. As other people have mentioned, Rwanda is already hosting 130,000 asylum seekers, and UNHCR itself has 1,700 Libyans there. So clearly the numbers are not the fundamental issue with this proposal.
That's correct.
So in terms of what has been raised by others, we've had a lot of red herring sound bites about can't work, won't work, unprecedented. No, there are precedents. And in fact, the Labour Party know this better than anyone, because the Mother of the House, the Right Honourable Member for Pakenham and Camberwell in 2001, was in a very similar position in not being able to confirm to the EHRC that we were necessarily compliant as a government in a proposal that she was putting forward. We know that the Blair government talked to Tanzania about something similar as part of the Nationalities Act of that time. And in fact, the Nationalities Act of 2022 built on the Asylum and Immigration Act of 2004. So there are some precedents. There are reasons to believe this might work. It is going to be awkward, and it is going to have to be an issue that we and many other governments tackle. But the most important thing, Madam Deputy Speaker, is that we should get behind this bill and see it through safely.
Thank you very much. Thank you, Madam Deputy Speaker. Rwanda is not a safe country. This country is using the bill as a distraction from their failing to sort out the immigration backlog. Millions of pounds of taxpayers' money is being spent on hotels every day. Hundreds of millions have now been spent on this fantasy Rwanda policy without a single person being sent there. Money would be better well spent sorting out the backlog and getting people processed. There are already immigration policies in place, they aren't being enforced. The Home Office is working too slowly, as they have done previously with passports. Processing claims quicker is the best way to free up these hotels. Over the past decade, the backlog of asylum claims has risen 4 times faster than the numbers claiming asylum. This is ultimately a crisis of the government's own making, your benches, and one that has been years in the making. It is a failing system that needs fixing. This country needs a solution to this crisis, not a distraction to it. This bill is claiming Rwanda is a safe country because the bill says that is so. That is not the type of country Britain is. We are not like that. We believe in the rule of law and obligation to international laws and treaties. The Rwanda government, Madam Deputy Speaker, has been involved in many questionable events across Africa, including the kidnapping and beating of dissidents abroad. The Rwanda policy is an attempt by the government to look tough and to distract the country from the sorry state that they've got us in. Even on the off chance the flights to Rwanda take off, they will deal with less than 1% of asylum claims. It is a Tory vanity project. It won't solve any problem. As a country, we are better than this. Labour's plan to tackle the criminal gangs directly with a cross-border police unit and clearing the backlog is the only way to stop the small boats. Vanity projects for headlines are not befitting a serious issue like we've got. The government should go back to the drawing board and we'll be here in a few months and a year, I'll bet. Thank you, Madam Deputy Speaker.
There are sometimes some advantages to being the last speaker, and because the previous speaker was a little shorter, I shall lift the time limit as long as the Honourable Lady sits down at 6:30. Claire Hannon.
It's been a long day, a long debate. Perhaps the government could legislate a few extra hours for us all. It wouldn't be out of place with this pretty mind-bending bill from a government who continue to prioritise prejudice over objective reality. The member for East Antrim proposed to speak for my constituency of South Belfast, which does indeed have a relatively large, and I think the largest per head of population portion of the UK's asylum seekers, with our schools and our churches and our community groups trying valiantly to support people who the Home Office have left in hotels for many, many months at a time. Like me, those constituents have moral and practical objections to this bill, moral objections to the language being used to frame and to justify it, and to the demonisation of those who seek international protection in the UK, who have little or no opportunity to do that before they travel. Equally, they have practical objections to this bill because they know that it won't work. They know that there's no evidence that the deterrent works, a fact confirmed by the Permanent Secretary. Then they know that it relies on simplification by this government that implies that people have never met or spoken to an asylum seeker. The cost of this gimmick is now running into the hundreds of millions of pounds, money which could and should have been used instead to end the chaos of processing in the Home Office, or going after the people traffickers instead of bettering their market by closing off safe routes. No one is saying that the UK can or should take everyone who requires sanctuary for reasons of conflict or prejudice or climate. As everybody in this chamber knows, no matter what they say in their tweets, only a fraction of people try. No one is saying the UK shouldn't take legal steps to deter erroneous claims. The Minister has spoken about fruitful engagement with Albania. Honourable friends on these benches have set out numerous constructive proposals, including swifter processing and justice, and crucially modern and mature engagement with neighbouring countries. Madam Deputy Speaker, it's impossible to view this bill outside of two core dynamics. One is the UK's recent disregard of international law, a rules-based order that they previously and proudly shaped, and the second is the dynamic of overall irrational opposition to migration, including regular migration. People often say that you can't even talk about immigration. You absolutely can talk about immigration, but you have to be prepared to be honest about it and to treat it in more than just Twitter memes. You have to be prepared to talk about how the National Health Service and social care would collapse without it. You have to be honest about the net positive impact on GDP and about the poor political decisions and how we spend those gains that have left public services in the mess they are. You have to be honest about our higher education model and the higher fees that students from these areas and from countries here would face if we didn't have overseas students. You have to be honest about how it is anti-family to tell UK citizens that they can't fall in love with somebody and marry them from another country unless they're in the top 25% of earners. So of course you can talk about immigration. I'm happy to talk about immigration, and I'm happy to tell you that Northern Ireland has an immigration problem, and that problem is young people leaving our region to make their lives elsewhere because they feel stifled and limited by the politics of our region, by intolerance, by prejudice and by refusal to accept difference. And I warn you that Britain risks losing its vibrancy and losing its talent if it further goes down this path, a path that I am glad to say the mainstream of British politics have honourably resisted, mostly until now. Ireland's not immune, north or south, from these currents, as a street disorder in Dublin a few weeks ago shows. But we're a nation of people who have been the source of immigration for many, many centuries. You don't get to be Irish and racist, and I'm proud of the political leadership from across the spectrum against far-right agitation in Dublin in recent weeks. I want to briefly address the applicability of this bill in Northern Ireland. Human rights exist precisely to protect people from the type of politics that are behind this bill. Human rights frameworks exist to stop politicians degrading shared values for their narrow political interest. The protection of rights for everybody in Northern Ireland from all communities under Article 2 of the Windsor Framework has been welcomed across civil society. Even the UK government have called Article 2 uncontroversial. Not for the first time, I say thank goodness for the Good Friday Agreement, which has been a lifeboat for our region and some of the damaging, terrible politics of recent years. That's a large part of why so many people, including in this chamber, have desperately tried to undermine that agreement through Brexit. But thanks to that agreement, which the international community prevented this government from trashing under their previous two Prime Ministers, but it's thanks to that agreement that we do continue to enjoy, in theory, rights and protections that this government is so determined to burn for people in England and Scotland and Wales. But the existence of those rights has enraged the far right in Northern Ireland. A few voices who angrily prowl the internet seeking to suffocate anything or positive or humanitarian that happens in our region, who seem so desperate to strip legal rights away from everybody else. They'd like to legally review themselves, everything that can't run away. They are protesting that this miserable bill might not apply in Northern Ireland due to the Windsor Framework. I regret to say that in practice immigration law has already been applied in Northern Ireland without differentiation, as an upcoming challenge to the Illegal Migration Act will hear. Madam Deputy Speaker, we will oppose this bill and we will oppose other attempts to unite and balance the Conservative Party on the backs of the most vulnerable. The Illegal Migration Bill failed to do that. The Nationalities and Borders Bill failed to do that. This is just red meat for a common sense group with no common sense, a research group that does no research, and a star chamber that has no stars. This bill is for them and for no one else.
Shadow Minister Stephen Kinnock.
Thank you very much indeed, Madam Deputy Speaker. I rise to join the Shadow Home Secretary in moving the reasoned amendment in the name of the Leader of the Opposition. I'd like to start by sending my condolences to the friends and family of the asylum seeker who tragically died whilst on the Bibby Stockholm this morning. I'd also like to thank all those across the House who've sent their condolences to my family and I over the past 10 days. We've been overwhelmed by the flood of tributes and messages which have made us prouder than ever of what my mum was and all that she achieved. So it would be very tempting for me to respond by taking a more conciliatory approach to this debate today. But given the state of the legislation that's before us, and given everything that my mother stood for, I think she'd be absolutely appalled that such a thought might ever cross my mind. So let's get stuck in, shall we? I'd firstly like to start by thanking the House for an excellent debate, with gratitude in particular to my honourable friends on these benches who spoke with such passion and logic and conviction throughout the course of this debate. And of course, I'd like to welcome the latest immigration minister to his post. I note that the performance of his predecessor led the Prime Minister to conclude that the job was too big for one Conservative member alone, so they've cut the position in two. Well, the more the merrier, I say. Welcome one and all. Madam Deputy Speaker, when I began in this post 2 years ago, my first opposite number was fronting the Nationality and Borders Bill, which effectively handed each asylum seeker who crossed the Channel a badge saying, "I am inadmissible for asylum," whilst making no provision for what practically could be done with those unprocessed claimants. And so they duly ended up in taxpayer-funded emergency hotels at a cost of £8 million a day. Next up was my second opposite number, with the illegal migration bill. It was rushed through Parliament, yet not a single one of its core measures on detention and removal have been enacted. The Act is on the shelf, gathering dust. And now we have my third opposite number, who's well and truly taken one for the team by agreeing to introduce this utterly absurd piece of legislation, a bill which his predecessor described as a further betrayal of Tory voters. So the deck chairs have been rearranged, but the Titanic is still steaming towards the iceberg. And perhaps the most remarkable thing about the Rwanda scheme is its origin story. Cast your mind back to April 2022, Madam Deputy Speaker. Boris Johnson was Prime Minister, but he was in the eye of the Partygate storm. So he cooked up a cunning plan to rescue his premiership, which I believe became known as Operation Save Big Dog. And lo, the Rwanda scheme was born. Now, like every other scheme that Mr. Johnson's ever been associated with, it was extortionately expensive and doomed to fail. Yet here we are, 18 months, 2 Prime Ministers, 2 Home Secretaries and 3 Immigration Ministers later, and the benches opposite are still shackled to a policy that was only ever to be designed to be a diversion from a scandal. Now, true to form, the Rwanda scheme is still being deployed as a skin-saving operation, the only difference being that it's the current Prime Minister who is desperately trying to cling to power by burnishing his Faragist credentials to keep the circling vultures at bay. It really is déjà vu all over again. I turn now to the substance of this new Please, Please, Please Make Rwanda Safe bill, which is without doubt the most absurd piece of legislation I've ever seen, because it does nothing at all to make Rwanda safe. It just asserts that Rwanda is safe and that our courts are not allowed to say otherwise. It argues that black is white and white is black, that the grass is blue and the sky is green. Madam Deputy Speaker, in the spirit of this legislation, I'm thinking I might try to introduce a bill which deems that Wales actually won the Rugby World Cup recently. Further still, the Rwandan government is calling the shots. Having extracted 300 million, or today we think we heard 400 million, from the British government, Mr. Kagame is now instructing the Prime Minister not to do anything that might break international law. It really is quite extraordinary. How ironic that some on the benches opposite rail against our international legal obligations, and yet they seem quite content to allow Kigali to dictate the terms of our asylum policies. So much for taking back control. And the upshot of this fiasco is that the Prime Minister has gone for a fudge. The Supreme Court judgment was his opportunity to stop flogging the dead horse that the Rwanda scheme has clearly become, but he has chosen not to take it. And he is not also prepared to go with the full-fat option that some on the benches opposite are urging him to adopt. So inevitably, his semi-skimmed formula satisfies nobody because, as everybody, from this side of the House to even the former Home Secretary have said, it is destined to fail, both legally and in operational terms. the fundamental contradictions at the heart of this bill are also quite astonishing. First, the Home Secretary told us from that dispatch box last week that the bill complies with international law. But the very first page of the bill confirms that he's actually not sure that it does. Second, the bill says that Rwanda is safe for refugees, but then also states that the government might need to offer refuge to asylum seekers from, checks notes, Rwanda. Third, it's meant to be about stopping what the government calls illegal migrants from seeking sanctuary in the UK. But if one of these asylum seekers commits a crime in Rwanda, then that person can be sent back to, checks notes again, the UK. Never mind Operation Save Big Dog, Madam Deputy Speaker, this bill is Operation Dog's Breakfast. But the Rwanda scheme is not only unlawful, it is also unaffordable and unworkable. Firstly, let's give credit where credit is due. The Rwandan government has played a blinder on this one, and they're laughing all the way to the bank. They really did see this Prime Minister coming. I mean, £400 million for absolutely nothing in return, no questions asked, really is a sweet deal. Although never let it be said that the party opposite has failed to get any flights off to Rwanda, because they absolutely have. They have proudly flown not one, not two, but 3 Home Secretaries to Kigali. So I guess you could say that so far it's £130 million per Home Secretary, which I'm sure the British people will see as an excellent use of their taxpayers' money. I will.
I think the honourable member, he will know that I work for his father and my daughter worked for his mother. Does he think that this whole facade is about a form of international development? They don't like international development. This is a way of actually targeting one country and giving 140, 200 million pounds.
Well, I thank my honourable friend and thank you for his kind words as well. He's absolutely right that the vast majority of people fleeing war and persecution end up in neighbouring countries in the region in which their plight is generated. And of course, we need to have an overseas development programme that is focused and is seeking through enlightened self-interest to ensure that we support those countries. Now, we're constantly told by the benches opposite that the Rwanda scheme will act as a deterrent, but that claim simply does not stand up to scrutiny, because Rwanda can take less than 1% of the asylum seekers who cross the channel in small boats. And when you're dealing with people who have already risked life and limb to get as far as northern France, it is inconceivable that they will be deterred by a 1% risk of anything. The Labour Party has therefore been steadfast in our opposition to this madness from the very outset. We on these benches are absolutely committed to stopping the Tory boat's chaos, but we will never vote for a madcap gimmick that is unaffordable, unworkable and unlawful. We have constantly said that the government needs to redirect the money that's being squandered on this nonsense into a cross-border police unit, a new returns unit and a security partnership with Europol that can stop the Tory boat's chaos at source. And we have consistently called for the government to speed up decision-making and remove the 30% of asylum seekers who fail to get leave to remain, swiftly and safely. A small upfront investment in Labour's plan would save the taxpayer an enormous £2 billion. Our reasoned amendment sets out why this bill is a sham and what the government should be doing instead, and I urge all members across all benches to get behind it. And I trust that, in his concluding remarks, the Minister will confirm whether or not the government will be accepting any significant amendments at committee stage for this bill, because the House really deserves that clarity, Madam Deputy Speaker. Madam Deputy Speaker, the Conservative Party is no longer a serious party at all. It's a rabble, an alphabet soup of factions and cabals. The former Home Secretary is constantly on manoeuvres, and the former Immigration Minister is firing broadsides on a daily basis. And we have a Prime Minister who is so desperate to save his own skin that he apparently invited an outfit called the New Conservatives to Number 10 for breakfast this morning. But, Madam Deputy Speaker, the reality is that the Prime Minister wasn't actually at the table at all. He was on the menu, consumed by the warring factions in his party, devoured by his own weakness and lack of judgment. Madam Deputy Speaker, our country simply cannot afford more of this chaos. We're in the midst of a cost of living crisis, and our public services are crumbling. But we have a Conservative Party that is at war with itself and completely incapable of governing. But the good news is that the Prime Minister does have a way out of this mess, Madam Deputy Speaker. He can call a general election. So that voters across this country can kick him and his shambolic administration out of office and finally give our country the leadership that it needs and deserves. Thank you.
Before I call the Minister, can I just say once again how important it is for those who have contributed to a debate to get back in good time to hear the opposition front bench as well as the Minister, and not to be late. Minister Michael Tomlinson.
Madam Deputy Speaker, thank you very much indeed. May I first of all join the honourable gentleman, the member for Aberavon, my right honourable friend, the Home Secretary, and the Shadow Home Secretary, in sending my sincere condolences to the friends and families of the person who died on the Bibby Stockholm. May I also thank the honourable gentleman for his warm welcome to me. Madam Deputy Speaker, it's right to say that I have received from many colleagues on both sides of the House warm messages of congratulations on taking on this role, and I'm sure that at least some of them were genuine and that they meant it. May I also pay tribute to my right honourable friend, the member for Newark. May I pay tribute to for his work in this role, to him personally. May I say, perhaps within the privacy of this chamber, how sorry I was to see him resign, and how I welcomed and respected the work that he has done in this role, and how I look forward to working constructively with him in the future. It is right to say, and I agree with him, that there is a disagreement between us, but it is a good faith disagreement. He was right when he said that, and I agree with him. I agree with his point about the need for legal certainty, and I commit to working with him on that very point. But, Madam Deputy Speaker, may I take the central thrust of this bill and tackle head-on the point that the honourable gentleman has made? Because the point of this bill is to address the concerns that the Supreme Court set out on the 15th of November of last month. It is right to say that I respect the judgment of the Supreme Court. As a former law officer, Madam Deputy Speaker, perhaps you'd expect me to say nothing less. And it is because we respect that judgment that we have looked at it so carefully, that we have responded not just with this bill, which seems to have escaped many honourable and right honourable members opposite, but with a treaty, with an internationally binding treaty that my right honourable friend secured in Kigali last week. This bill was subsequently tabled, and we are debating it here at second reading. And that built, of course, on the Memorandum of Understanding that my right honourable friend, the member for Witham, secured all those years ago. And I will, if I may, come back to her speech. And I was very grateful for her contribution. But perhaps, Madam Deputy Speaker, I can pick up some of the threads of the debate in this way. What we have heard from some of the contributions is what I would phrase as the moral case for stopping the boats, the compassionate case for stopping the boats, the reason why it is a moral imperative that we stop these modern-day slavers, that we smash these criminal gangs who are trying to push vulnerable people across the busiest shipping lane in the world, where people have lost their lives. Those of us on this side of the House are determined to take action. We are determined to smash those gangs, the modern-day slavery of our time. And some have raised the monetary cost. Some have said, well, how much is this costing us? Well, I ask, what about the human cost? What about the human misery? What about the human misery that the slavers are actually driving people to? There is nothing compassionate. There is nothing compassionate about having an open borders policy, and that is what we have heard too much of today and in the past weeks and months. Can I address the point about the strength of the bill and the concern that many on this side of the House have raised, legitimately raised, about concerns about spurious claims that may be made, that some claims may be made about... Of course I'll give way to the Honourable Lady, Honourable Gentleman, specifically on the point of spurious claims. He has an Honourable Lady behind him who may be seeking to intervene in a few moments. To the Honourable Gentleman.
Ever so much, Minister, and I'm grateful for you giving me. Can he tell the House, in his view, how many people will be deported to Rwanda next year?
It will start off in the hundreds and it will scale up to the thousands. Can I say that I enjoyed his speech? Whenever he speaks, I always think he's a smile behind the grimace and behind the stare. I always enjoy speaking, and I always hear him being heckled, enjoy hearing him being heckled from this side of the House as well. Those on this side are anxious about spurious claims being made, about people asserting that they are unwell, that they are not fit to fly, when the contrary is the case. Can we say that those who are crossing in small boats, who actually are making the crossings, not those who are unwell, but those who are fit young men. 84% of those who are making the crossings are male. 77% of those are aged between 18 and 39. So I agree with my honourable and right honourable friends when they say they want to make this work, when they say they want to make it legally tight. That is absolutely right, and I want to join them in that endeavour. How could I refuse, my honourable?
So much. I'm most grateful. I wish to be a little formal about this, but will my right honourable friend seek a ruling from Mr. Speaker that the long title and the scope of the bill will or may be amended to ensure that amendments may be moved and selected, at least by the government, and even by backbenchers, as on previous occasions?
May I say directly to my honourable friend that I will continue to work with him on this. I will come back to his specific points, and I will come back and address, I hope, his very concern, perhaps specifically in response to his neighbour's points during the course of his speech as well. May I pick up my right honourable friend, the member for Witham, who actually spoke powerfully and directly about her contribution to this, as well as my honourable friend, the member for North Norfolk, my honourable friend, the member for Torbay, and others as well. Because she said rightly, she talked about the UNHCR and the EU. Let's debate this. Let's have this point. Because the very day after the UNHCR were advocating in the Supreme Court that Rwanda was not safe, how galling was it to see that the UNHCR itself sent 168 refugees to Rwanda. 168, the very next day, as a part of hundreds of thousands, a scheme that is already up and running, and supported and backed by the EU to the tune of millions of euros. Exactly. And we need to hear more of that, and I'm very grateful to my honourable friend. Let me come to contributions in the short time that I've got left from honourable and right honourable members. The honourable member for Strangford and the right honourable member for East Antrim raised a specific point that I want to address head on. This bill will apply in full in Northern Ireland in the same way that it does in the rest of the United Kingdom. It is explicit, it is on the face of the bill, and will always be the case, reflecting that immigration policy is a UK-wide matter. I want to be particularly clear that nothing in the Windsor Framework or the TCA agreement affects that. Where people have raised concern is around the rights chapter of the Belfast Good Friday Agreement. In addition, I want to be clear that the rights chapter of the Belfast Good Friday Agreement does not affect any clause within this bill in any way. I think I have time to address the specific concern that the honourable member for Strangford raised earlier on in the debate. It is important to be clear the 2005 Procedures Directive is not within the annexes of the Windsor Framework. Yes, of course, I give it.
Madam Deputy Speaker, to the Minister for addressing those points as clearly as he did. He will acknowledge that while he has addressed them in his closing remarks this evening, the Home Office published legal advice yesterday that didn't touch on any of these points. Could I ask the Minister to take steps in the days that come to go further and update that legal guidance, that legal advice, in a way that encompasses the points that he's just raised to assuage the concerns of the House this evening?
Minister.
May I give the honourable gentleman this commitment, that I will continue to work with him on the points that he has raised. And I need to be careful about legal advice as a former law officer. What has been published is a government legal position statement that is different from legal advice, and he will understand the differences in relation to that position. But he has heard what I said, and I was grateful to him for welcoming the points that I made in response to the specific concerns that were raised. May I come back to my honourable friend, the member for Stone, because he mentioned the House of Lords Select Committee, the Constitution Committee. Madam Deputy Speaker, that gave me flashbacks to my grilling by that illustrious committee when I was sitting alongside my right honourable friend, the Attorney General, in my formal role as Solicitor General. And we followed that very report that my honourable friend, the member for Stone, mentioned. May I turn to the Chair of the Select Committee, the Honourable Member for Kingston upon Hull North, the Chair of the Select Committee for the Public Accounts Committee, the Honourable Member for Hackney South and Shoreditch. And the simple point I would say to her is I can't address each and every one of her points here, but I know that she's looking forward to asking me some specific questions tomorrow afternoon when I attend her committee with my honourable friend, the member for Corby. We then had, Madam Deputy Speaker, what I'm going to describe as a former law officer fest. We had the pleasure of hearing from my right honourable and learned friend, the member for Torwich and West Devon. We had the pleasure of listening to my honourable and learned friend, the chairman of the Select Committee. We had the pleasure of listening and hearing from my predecessor, my illustrious predecessor, my right honourable and learned friend, the member for Swindon South. And I'm pleased to say that I am now a former law officer as well. And we therefore have a joint endeavour and a joint interest in making sure that this legislation works. I've mentioned my right honourable friend, the member for Witham, and I've mentioned her important point about Rwanda and the rather patronising tone that is sometimes raised by members opposite when it comes to our international partners who have signed up to an internationally binding legal treaty with this country. Oh, of course I'll give way.
Welcome the Immigration Minister to his post. Is he aware that while he's been speaking, the New Conservatives, the European Research Group, the Northern Research Group, the Conservative Growth Group and the Common Sense Group have all said that they cannot support the bill and are going to abstain tonight? Does he accept that this looks like the Prime Minister's breakfast meeting was a total failure? And does he accept this is just complete civil war in the Conservative Party?
Madam Deputy Speaker, the answer is no, no and no. I am here. I have been in the chamber. May I turn to my right honourable friend and neighbour, the member for Bournemouth West, and may I thank my constituency neighbour for his delivery, for a powerful and compassionate speech, as he always gives. May I turn to my right honourable friend, the member for Clwyd West. He asked me to work with him, he asked me to be open-minded, he asked me to look at ways to make the bill more effective. In contrast to the previous intervention, my answer is yes, yes and yes. He and I have worked together before, and I commit to continuing to work again with him in the rest of the passage of the course of this bill. In the time that I've got, forgive me, I won't. In the time that I've got left, I'm going to refer to my honourable friend, the member for Devizes. I hope he will continue to work with me on this bill. I listened very carefully to what he had to say. I listened with great interest to my honourable friend, the member for Barrow and Furness, who is a member of the Select Committee and spoke with great authority. My honourable friend, the member for Dover, who spoke very clearly about her position and how the impact on her constituency, the direct impact on her constituency, and the imperative of making sure that we stop the boats. My honourable friend, the member for Gainsborough, the speech in my notes, it's described as that he was on fire. That's what my notes say. He was on fire. And those who missed his speech should go and watch it again on playback. My honourable friend was on fire, and I was grateful for his contribution. My honourable friend, the member for Runnymede and Weybridge, who made a powerful, measured and careful speech. And I was grateful for his earlier intervention during the course of the debates as well. My honourable friend, the member for Ruislip, Norwood and Pinner, I thank him for his contribution. I thank him in particular and sincerely for mentioning our late colleague James Brokenshire and for mentioning the work that he did so ably in this area. My honourable friend, the member for Boston and Skegness. Common sense from Boston is what my notes say here, and I thank him for his contribution. My honourable friend from Don Valley, there were attempts to shout him down whilst he was speaking. He stood up, as he often does, and he stood up in this chamber in the face of that barrage. He talks openly about his faith, and I respect him sincerely for the way that he does that and for the way that he conducts his business in this chamber. My honourable friend, the member for Bury North, who has the distinction of serving on not one but two select committees. Not only does he do that, Madam Deputy Speaker, but he does it with distinction and with diligence. I always like listening to his speeches. He had the temerity to suggest that lawyers may from time to time disagree with each other. What an outrageous suggestion he made. I'm only sorry that there weren't more lawyers in the chamber to hear that particular point. My honourable friend, the member for Broughton, made an outstanding speech. The inescapable, the inestimable, the irresistible logic of my honourable friend's speech. More people should have been here to hear what he said. It was absolutely logical, it was compelling. My honourable friend, the member for Torbay, I have turned to him before and I thank him as well for being, as one of my predecessors, for his work in this area, for pointing out what has already happened since the Supreme Court, namely the treaty. My honourable friend, the member for North Norfolk, gave us actual numbers, not just a percentage, but actually turning it into numbers. And my honourable friend, the member for Gloucester, took us on a tour du monde. It is not just our country that is facing these challenges. This is a challenge of our time. This is a global challenge. Madam Deputy Speaker, let me end with this. I have sat through this debate. Out of the 6.5-hour debate, I have sat here for more than 6 hours of it. I have heard every single speech from this side of the House and most speeches from the other side. I have heard every single front bench speech from the Labour Party, and what was missing was a plan. Labour have no plan. Intervention after intervention. Where is the plan? There was chuntering from the Home Secretary from a sedentary position, Madam Deputy Speaker. Where is the plan? Answer came there none. There was a verbal vacuum. There wasn't even a cut and paste solution. There was no plan whatsoever. Contrast that with the clear determination of all of those on this side of the chamber to stop the boats. And Madam Deputy Speaker, I commend this bill to the House.
Order. Order. The original question was that the bill be now read a second time, since when an amendment has been proposed, as on the order paper. The question is that the amendment be made. As many as are of that opinion say aye. Aye. Contrary, no. Division. Clear the lobby. Order. The question is that the amendment be made. As many as are of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Jeff Smith and Colleen Fletcher. Tellers for the noes, Mark Fletcher and Amanda Soloway. Order. Order.
The ayes to the right, 269. The noes to the left, 337.
The ayes to the right, 269. The noes to the left, 337. So the noes have it, the noes have it. Unlock. The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye! The contrary, no. No! Division, clear the lobby. The bill be now read a second time. As many as are of that opinion say aye. Aye. The contrary, no. No. Tellers for the ayes, Mark Fletcher and Amanda Soloway. Tellers for the noes, Colleen Fletcher and Jeff Smith. Order.
The ayes to the right, 313. The noes to the left, 269.
They're cheering a majority of 18.
Order. Order. The ayes to the right, 313. The noes to the left, 269. So the ayes have it. The ayes have it. Unlocked. We now come to the programme motion to be moved formally. The question is, as on the order paper, as many as are of that opinion say aye. Aye. The contrary, no. Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Mark Fletcher and Amanda Soloway. Tellers for the noes, Gavin Newlands and Peter Grant. Order.
The ayes to the right, 332. The noes to the left, 61.
Thank you. The ayes to the right, 332. The noes to the left, 61. So the ayes have it. The ayes have it. Unlock. Order. We now come to the Representation of People Northern Ireland, motion number 3. Minister to move. The question is, as on the order paper, as many as are of that opinion say aye. Aye. The contrary, no.
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 No. Aye. No.
Aye. The division is deferred until tomorrow. We now come to motion number 4 on public service pensions. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 5 on income tax. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 6 on retained EU law reform. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no.
Aye.
The division is deferred until tomorrow. We now come to motion number 7 on energy. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 8 on police. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 9 on agriculture. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to motion number 10 on police. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no.
No.
The division is deferred until tomorrow. We now come to motion number 11 on business of the House. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. Thank you. Petition Martin Day.
Thank you, Madam Deputy Speaker. I rise to present a petition on behalf of the constituents of Linlithgow and East Falkirk in relation to frozen British pensions. There is a considerable amount, I think, that is wrong with pension policy in the UK, from having one of the lowest rates in North West Europe to our abysmal treatment of the WASPy woman, and to the 500,000 British citizens around the world whose pensions have been frozen due to a failure to establish bilateral agreements, such as 127,000 in Canada. Therefore, the petitioners request that the House of Commons urge the Government to engage with the Canadian Government on this issue and finally remedy this injustice and reflect and respect the courtesy for our British citizens and our Commonwealth neighbours. And the petitioners remain, etc.
Hear, hear.
Hear, hear.
Petition Frozen British Pensions.
Petition Scott Benton.
Thank you, Madam Deputy Speaker. I'm delighted to present this petition relating to support for regional airports on behalf of my constituents. The introduction of additional public service obligation routes would transform the outlook for regional aviation in this country, facilitating airports such as Blackpool to grow and supporting local economic development. In the case of Blackpool Airport, the creation of further PSO routes would help to achieve the restoration of commercial passenger flights, which is something the vast majority of my constituents support. The petitioners therefore request that the House of Commons urge the Government to take into account the concerns of the petition and take immediate action to ensure that local airports such as Blackpool are supported.
Petition public service obligation routes.
Petition Munira Wilson.
Thank you very much, Madam Deputy Speaker. I rise to present a petition about Thames Water's Teddington direct river abstraction proposals to draw water out of the River Thames in times of drought and replace it with treated sewage. I sincerely hope the ministers will listen to the over 700 residents who have signed this petition, almost 30,000 people who have signed the Change.org petition, and the many hundreds who responded to the company's consultation on the Water Resources Management Plan, all of whom are deeply concerned about the significant environmental, social and construction impacts. The petitioners therefore request that the House of Commons ask the Government to remove the Teddington Direct River Abstraction Scheme as an option in the Water Resources Management Plan, which is currently under review by DEFRA.
Petition Teddington Direct River Abstraction Project.
I beg to move that this House does now adjourn.
The question is that this House do now adjourn. Hannah Barder.
Thank you very much, Madam Deputy Speaker, and I am incredibly grateful for the opportunity to hold this debate and for the flexibility of the Speaker's office in moving this when I was ill last week. Because this last week was Crohn's and Colitis Awareness Week, an opportunity to break the silence on inflammatory bowel disease and highlight the impact of these terrible conditions on people's lives. And I want to thank particularly Crohn's and Colitis UK, who've given us a huge amount of support, and the Honourable Lady, my honourable friend, I would like to call her, for Chesham and Amersham, who jointly with me recently reconvened the all-party parliamentary group on Crohn's and colitis, and also Alison in my office, who has supported me in writing today's speech. Because over 500,000 people in the UK, 1 in every 123 people, live with Crohn's disease or ulcerative colitis. These are debilitating, lifelong conditions which develop when the immune system attacks the gut, and there is currently, tragically, no cure. Symptoms include urgent and frequent diarrhoea, rectal bleeding, pain, profound fatigue, anemia and inflammation of the joints, skin, liver and eyes. These conditions are widely misunderstood, with its invisible stigmatised symptoms often leading to isolation, a lack of support and poor mental health. That's why this Crohn's and Colitis Awareness Week we wanted to break the silence on inflammatory bowel disease, raising greater awareness of the conditions and helping those many people and many of them our constituents living with them to speak more openly about the impact on their lives. I'd be delighted to give way to the honourable gentleman.
Speaker, I commend the Honourable Lady for Livingston. I actually was looking forward, if it's the right thing to do, looking forward to our adjournment debate last week, and I understand it's good to see her back in health and strength again. Incontinence is a common symptom of Crohn's and colitis, experienced by as many as 3 in 4 people with Crohn's or colitis. Understandably, incontinence, or the fear of experiencing incontinence, can cause anxiety about leaving home, which can seriously affect your work and social life. Does the Honourable Lady agree that more work must be done with the DWP to train PIP assessors on the impacts of Crohn's and colitis to ensure those suffering have the best possible chance of getting the benefits that they're entitled to?
I thank the honourable gentleman for that intervention, and he has read ahead almost my speech, because I will absolutely come on to that, but it's an incredibly important and salient point that he makes, that we need to make sure that PIP assessors and the whole framework can take into consideration those with relapsing and remitting conditions such as Crohn's and colitis. And with permission, Madam Deputy Speaker, I'd like to share some of those experiences with the House, because one of them is my brother. When he was diagnosed with ulcerative colitis just over 9 years ago, he was in his late 20s and a new dad to a premature little girl. Whilst we were cooing and worrying a little about this new bundle of joy, who is now a strapping 9-year-old, my brother was struggling and had been for some time. I think, in truth, he was terrified about how fatal the diagnosis might be. It was not until much later that it dawned on us all just what he'd been through. And when his diagnosis finally came, it was truly devastating. His life and that of our family was, for a period, really turned upside down. An active and fit football lover, a new dad, and an outgoing and often, frankly, a bit too cheeky young man was stopped in his tracks. And as a frontline police officer with big ambitions and talent, my brother had to adjust to a very different life, existence and career path. The pain, the fatigue, the various symptoms that he, like many, experienced suddenly had a name. And aside from the initial period of work, time out of work to recover and adapt, it meant that things like our annual holiday to the West Highlands to go camping was suddenly in jeopardy. A 4-hour drive, where it couldn't be predicted if toilets could be open or available, was suddenly something that was potentially out of reach. My brother, however, being the resourceful problem solver that he is, traded in his car for a pickup truck and popped a portable loo in the back, meaning that while he adjusted to his anxiety and being able to find a toilet when travelling, these things could be managed. I don't believe he ever used it, but it was there just in case. And I think now he would count himself as one of the lucky ones. And that's just the point. For those who suffer from any kind of inflammatory bowel disease, and let me say and acknowledge that there are people with endometriosis, with conditions such as cancer, suffer very similar challenges. Finding a loo that is working and stocked and clean is a perennial problem. So perhaps the Minister might like to meet with me sometime to discuss how we can develop better facilities, maybe even some kind of interactive map in an app of loos that will do. Now, my constituent Stephen Sharp, who I want to pay tribute to, is a brilliant young man excuse me, from Fauldhouse in my constituency. He is a Crohn's sufferer and he has raised thousands of pounds for the charity over the years, including doing a bungee jump. And Stephen has often spoken to me about the joint pain, the fatigue and the unpredictability of the disease and the impact on his life. And he also lives with a stoma. And that's one of the major challenges, the symptoms that can change and be different every single day. Stephen and I recently met the Prime Minister, and I have to say the Prime Minister was incredibly supportive and kind to Stephen. I hope that that kindness will be extended into provisions to make sure that those living with Crohn's and colitis can get the support they need. And my friend Rachel Agnew, who I hope is watching, and I spent time with this summer, also talked to me about the many years of illness she's had from Crohn's disease and a possible misdiagnosis, having had many major operations, and now she has stoma, who can sometimes be cantankerous, but has ultimately saved her life. Rachel recently had to give up a job she loved, and she is now having to navigate the complex nature of the benefits system whilst having a relapsing and remitting disease. Research commissioned by Crohn's and Colitis UK revealed that the scale of Crohn's and colitis has been vastly underestimated, with twice as many people living with the condition as previously thought. And particularly, as we heard in recent debates and briefings, young children being diagnosed earlier and earlier in their lives. And I think we do have to pause and consider why that is happening. What are the environmental impacts? What are the impacts of processed and overly processed food? Because I have no doubt in my mind that they play a part. And we need to fund that research to make sure we get to the bottom of those things. I would be delighted to.
Thank you for giving way. And I thank her for securing today's adjournment debate to raise awareness of Crohn's and colitis. Symptoms like abdominal pain, diarrhoea and fatigue are too often dismissed, Madam Deputy Speaker, especially when they come and go. And a poll by Crohn's and Colitis UK found that over 1 in 10 people would put off speaking to a healthcare professional if they had diarrhoea with blood or mucus and stomach pain, because they'd simply find it too embarrassing to speak to a healthcare professional about their symptoms. So does the Honourable Lady agree with me that a public awareness campaign of lower gastrointestinal symptoms is needed to help people access reliable healthcare, access reliable advice and take control of their health?
Hear, hear. My honourable friend for that intervention. She's absolutely right. Excuse me. We absolutely need to have greater awareness. People need to not have to live with that stigma or not be scared to talk about their poo, frankly, and being able to go to their doctor and discuss that openly and for their doctors to be able to offer the right care. Because only 1 in 4 people are diagnosed before they're 30, thus affecting the most productive years of their life. And Crohn's and colitis are complicated diseases, as we know, that follow a relapsing and remitting disease course. We need, therefore, a benefit system and a social security system that supports people with those kinds of conditions. And is, as my honourable friend has said, absolutely crucial that we can raise awareness. People are waiting far too long for a diagnosis, Madam Deputy Speaker, of Crohn's and colitis. Even before the pandemic, 1 in 4 people waited more than a year to be diagnosed, with nearly half ending up in accident and emergency at least once before their diagnosis. And delays to diagnosis affect people's ability to continue education and work and narrows their treatment options while increasing the risk of being hospitalised. Ultimately, and we do not want anybody to feel a burden to the NHS, but there is a greater burden on the NHS because people are diagnosed much later and aren't able to access that care. Research from Crohn's and Colitis UK has found that only one in two people had ever heard of these conditions, and even fewer could name those symptoms. So to make matters worse, people are not facing up to that, not understanding it and putting it down to other things. So you could say, Madam Deputy Speaker, it's time to talk more crap than we already do. If sufferers struggle to discuss incontinence with their health professionals, it can have a profound impact. But these discussions are vital to ensure those with Crohn's and colitis receive the support and the accommodations they need. And I would like to highlight the work of the SNP-led Scottish Government, who are committed to ensuring those living with Crohn's and colitis are able to access the best possible care and support they have, and to access health services that are safe, effective and put people at the centre of their care. For example, in March this year, the Scottish Government launched an awareness campaign to help increase awareness of Crohn's and colitis symptoms and to signpost reliable information so people feel empowered to seek help from a medical professional when needed. I would be delighted to hear the Minister, when he gets to his feet, say that the UK Government will do the same and that they will work across the UK and indeed internationally with those who are leading the field in research. Bowel conditions are notoriously difficult to diagnose, and so we must remind people that some of those conditions, such as IBS, celiac disease or bowel cancer, can be similar to that of those who suffer with Crohn's and colitis. So it's crucial with those who with Crohn's and colitis have those conversations and that they get a diagnosis as early as possible. Because if left untreated and poorly managed, these conditions can cause serious complications which require emergency medical or surgical intervention. And when we had an all-party group meeting recently, we heard from a sufferer who had had the most horrific experience during COVID. She was taken by ambulance after terrible weight loss, and just hearing that experience, particularly during COVID, brought home to us how awful it can be and how difficult it is for young people, particularly to face up to something that is going to be lifelong and debilitating. And IBD care is often overlooked and under-resourced. The current resource planning is based on outdated data and the number of people living with these conditions, which we know is twice as many as people that was previously estimated. One long-serving IBD clinical nurse specialist recently told us how 18 years ago her service was supporting 250 patients. Madam Deputy Speaker, they are now supporting over 7,000 people living with Crohn's and colitis. That kind of increase is just not realistic for our healthcare staff to deal with. Consequently, there's a significant variation in the quality of care across the UK. No IBD service currently meets the IBD standards, so we need to work together to improve that. But the Scottish Government will continue to improve services with people with conditions through modernising Patient Pathways programme. It has a specific work stream continuing to promote improvements in inflammatory bowel disease care for patients across Scotland and in partnership with the third sector and people with lived experience. And additionally, the Scottish Government is funding gastroenterology specialty groups which leads on research into Crohn's disease and ulcerative colitis, with a focus on a range of areas, including early diagnosis of these conditions. We look forward to seeing the results from IBD UK's benchmarking surveys, which are being undertaken just now, and that's going to have data from over 15,000 patients and 63% of IBD services. I hope the Government will take that into consideration and give that its very close attention. And as we've discussed, Crohn's and colitis does not just affect the gut, it can affect almost every part of the body and every aspect of life, from digestion, eyes to joints and energy. However, many people tell us that the hardest part of living with these conditions is the prejudice and discrimination that comes with living with a hidden disability. Now, the awareness cards that are now available that Crohn's and colitis and other charities are providing do help. But what we also need is not just awareness for people who suffer from Crohn's and colitis, but the public at large. When somebody goes to use a toilet that has a disabled sign on it, just because they don't have what looks like a physical impairment doesn't mean that they don't need to use that toilet. 3 in 4 people will experience bowel incontinence, therefore quick access to a suitable toilet facility is crucial, either to prevent or act should an accident occur. And the anxiety, I'll be very happy to give way.
I thank the Honourable Member for giving way, and she is really making a very powerful contribution in the House tonight. I believe around accessible toilets, I think that is an absolute key part of part that this government can undertake to really help people who have Crohn's and colitis. I know in my own constituency of Upper Bann, we have rolled out a fleet of accessible toilets. Would you agree with me that that's something that should be mirrored right throughout the United Kingdom, and that more focus should even be placed on the radar keys that are available for disabled toilets throughout the United Kingdom?
I thank the Honourable Lady and I congratulate the work that's been done in Upper Bann, and perhaps there is lessons that can be learned and examples that can be taken by all governments across the UK, because incontinence can cause, I know, considerable anxiety. I've talked to my brother often about the thing that is worse now, and when he has a flare-up, it can be really seriously debilitating, but the day-to-day anxiety is something that never goes away and is always with those who suffer. What's more, some Crohn's and colitis sufferers have stoma bags, meaning not only do they need to find a toilet, but one that has enough space for them to change and dispose of equipment comfortably, hygienically and in privacy. And I know there was an excellent event recently in Parliament for International Men's Day that talked about the need for sanitary bins in men's toilets as well, and I think that's incredibly important. You know, men often suffer from incontinence, and they certainly suffer from Crohn's and colitis. So making sure that all toilets have those facilities that are safe and sanitary is absolutely crucial. And I'm not sure whether it would require an act of Parliament, but it strikes me that this would be something that would have support across the House. Because the fear of incontinence or being able to locate a toilet can lead to mental well-being breakdown and lead to social isolation through people choosing simply not to leave their home. We've all been there. We've all had a sickness bug or an upset tummy and either nearly not made it or not made it. Imagine that is your life every single day. So many living with Crohn's and colitis are going to understand, and I hope will hear the calls that come today. But one of the key things that we've heard time and time again is the social security system, because less than 3% of people living with Crohn's and colitis are in receipt of personal independence payment. 4 in 5 are denied the support they need. Words like battling and fighting are often used to describe the experience of those applying for PIP. And I spoke to someone recently who talked about how degrading they felt the system was. And that was somebody who was chronically ill and was often in the situation where they couldn't leave the house, to then be put in the situation that they are scared of going through a system that is supposed to be a safety net is utterly appalling. And I hope that the Minister will hear that and talk more about how the social security system can support people with Crohn's and colitis. Because a system defines the current benefit system defines disability as a permanent and substantial impairment or a person with a long-term health condition which is likely to degenerate. Now, you cannot tell me that some of the examples that I've given, or those who we've taken evidence from, and those who will be watching at home tonight, that their condition is not long-term. There is little recognition of fluctuating health conditions. And fluctuating health conditions aren't just Crohn's and colitis, there are many other conditions. So we have to have a system that is designed to support all of those people. Will my honourable friend give way?
I'd be delighted to.
I'm very grateful to her for giving way. I think she's making a really powerful speech, and I hope that the Minister does hear the point she's making. One of the things that constituents do consistently raise with me in terms of Crohn's and colitis is the impact of benefit assessors' lack of awareness of the impact and the fluctuating nature, as she's describing, of the conditions, and also the need, as they see it, to end informal assessment in the PIP process. Does she share their concerns about these particular points?
Yeah, I absolutely do. I mean, fortuitous that she raises that, because the statistics tell us that only 1 in 2 people score points under the toileting needs and continence descriptor, despite the severity of the system and of the symptoms in everyday life. And the fact that 3 in 4 people with Crohn's and colitis will experience it just shows how profound the issue is. So I would like to highlight, however, that the Scottish Government is reforming flexible disability assessment for fluctuating diseases. That is good news for people in Scotland, but what about people across the rest of the UK? And it is consulting with those with lived experience on the mobility component of their adult disability and payment. Now, that includes researching the impact of moving around, planning and following journeys for those with fluctuating conditions. The adult disability payment differs from the personal independence payment, as it intends to get decisions right first time by trusting what people tell Social Security Scotland. Time and time again, I've heard people who have been through the assessment process for PIP and have been undermined and scared. And I know people that just have not gone, including some constituents who've come to see me. They don't want to go through the process because they're so scared of it. We must move away from that. Treating people with dignity, fairness and respect is absolutely at the heart of delivering adult disability payment. So, Madam Deputy Speaker, what I've highlighted today covers just some of the impact that Crohn's and colitis has on people's lives. It's vitally important that we invest in developing a national primary care diagnostic pathway for lower gastrointestinal conditions, as my honourable friend has suggested, and destigmatising IBD symptoms and creating a benefit system that supports people with all types of disabilities. Just as the Crohn's and colitis campaign said, Madam Deputy Speaker, it's time to cut the crap and give greater awareness to IBD and those who suffer from this terrible life-limiting disease. We have an opportunity to do something really good, to give those who suffer from these terrible diseases an opportunity to take their full role in their communities and do jobs that they may otherwise be unable to do if they don't get that diagnosis and that support as early as possible. So I hope the Minister has heard what we said. I hope he's heard the experiences of our constituents and those close to us, and I look forward to his contribution. Thank you.
Minister Andrew Stevens.
Thank you, Madam Deputy Speaker. And can I start by congratulating the Honourable Member for Livingstone for having secured this debate on this very important issue. She is a tireless campaigner for those living with bowel conditions, in particular Crohn's and colitis, and she's spoken movingly this evening about her own family's experience of the condition. And can I also pay tribute to the Honourable Member for Cheshire and Amersham, the Honourable Member for Strangford, the Honourable Member for Upper Bann and the Honourable Member for East Renfrewshire for their contributions. I will try to address as many of the points that have been made in the time allowed. I think it's very important that we all do everything we can to break the stigma and ensure that sufferers' voices are heard. I think the Honourable Member for Livingstone has already done invaluable work in helping re-establish the APPG for Crohn's and colitis. I'd also like to pay tribute to the charities who support 500,000 people living with inflammatory bowel disease across the UK all year round. Crohn's and Colitis UK, the Crohn's and Childhood Research Association and the Crohn's and Colitis Foundation, to name just a few. On this issue, as with so many others, it is vital that we do everything we can to break down the barriers to those affected from accessing healthcare. As Crohn's and Colitis UK have said, it takes guts to come forward with your story, and I salute their Cut the Crap campaign. I look forward to working with the Honourable Lady as we find solutions to improve the lives of people living with this disease. As she's rightly said, living with Crohn's and colitis can be a daily struggle. Symptoms of the disease can be embarrassing, leading to people feeling isolated and not reaching out for the support they need. I'd like to focus briefly on three things my department and NHS England are doing to help sufferers. Firstly, raising professional awareness, improving diagnosis, and then research. I'd like to begin on the crucial point about raising awareness, because it's key to getting people diagnosed as early as possible. There are two kinds of awareness. First is raising awareness amongst the public, something that the Honourable Member for Cheshire and Amersham talked about before. Stigma is the invisible wall preventing people from seeking the help they need. And campaigners are central to smashing that stigma because of their reach into communities across the country. Campaigners like the Honourable Lady's constituent, Stephen Sharp, who she referenced in her speech, have done so much to raise awareness and break down that invisible wall. Campaigners encourage people to get to their GPs and to ask the right questions. And I'm keen for us to be backing people like Stephen every step of the way. By helping GPs to recognise the symptoms of Crohn's and colitis through NHS England's Getting It Right First Time gastroenterology programme, the programme ensures conditions are diagnosed as quickly as possible through supporting primary care services, driving appropriate referrals and managing inflammatory bowel disease in the community. The programme is estimated to reduce emergency admissions by more than 6,500 a year. And it's been commended by the King's Fund, who are not always in the habit of showering praise on the government. It's also right that doctors should be properly trained to treat the symptoms of Crohn's and colitis as they appear. In the past 5 years, NICE has produced a range of guidance to ensure that the care they provide for Crohn's is based on the best possible evidence. Madam Deputy Speaker, early diagnosis can make a clear difference to people's quality of life. And we're working hard to improve early diagnosis rates through the Getting It Right First Time programme, through measures that include more 6- and 7-day services and extended hours. These measures are reviewed and expanded endoscopy capacity and improved patient flow. NHS England is working closely with frontline clinical experts, patient representatives and leading charities to develop evidence-based tools that improve care. This includes work to ensure the right care scenario is provided on inflammatory bowel disease. This will set out our expectations of high-quality, joined-up care at every point of the patient journey, from diagnosis to treatment. Officials assure me this is being finalised and will be delivered in the coming year. What's more, NHS England's National Bladder and Bowel Health Project is delivering better care for people with inflammatory bowel disease with a focus on developing clinical pathways. Making a diagnosis of Crohn's and colitis can be difficult and frustrating for patients, as the condition can be confused with irritable bowel syndrome. So I'm pleased NICE have recently made fecal calprotectin tests available on the NHS as a non-invasive, inexpensive method for assessing patients before invasive procedures are required. As the Minister responsible for life sciences, I'm also passionate that we can do everything we can to accomplish better patient outcomes through investing more in research. It's key to gaining a better understanding of the causes of inflammatory bowel disease, leading to better diagnosis, treatments and outcomes. Sorry.
Can I thank the Minister? That's a very comprehensive response, and I'm sure all on this side are encouraged by that. However, the Honourable Lady for Livingston and myself did ask specifically about the issue for PIPs, and it's something we're very, very concerned about. I know it's not the Minister's responsibility, but can I just ask us this point? Can the Minister perhaps give us some indication that he would speak to the relevant Minister to make sure that there are movements to help and improve? Thank you so much.
I'm very happy to give the Honourable Member for Strangford that undertaking. As he rightly acknowledges, I am not a DWP Minister. I do not want to tread on their toes, but I think there was clear views expressed tonight which I will be relaying to DWP Ministers, because I think it's very important that we get the benefit system right to support all people living with conditions such as these. If I just return back to the research point, Madam Deputy Speaker, we're investing £1 billion, over £1 billion a year in health research through the National Institute of Health and Care Research. We're funding 60 projects into Crohn's and colitis research, backed by over £33 million in the last 5 years. I appeal to every scientist who may be interested in research in this area to keep applying for grants through the NIHR. I will leave no stone unturned in finding out what more can be done to address the needs of people affected by these conditions. And I look forward to working with the Honourable Lady to create the kind of care that people deserve. Whatever political differences we may have, and I'm sure we will agree, that 500,000 people living with inflammatory bowel disease are entitled to the highest possible standards of care and support. I will continue engaging with her and with NHS England to make sure the Getting It Right First Time programme is delivering results for patients on the ground. I began this speech by talking about the invisible wall preventing people from accessing the healthcare they need. Let's tear down this wall together.
Question is that this House do now adjourn. As many as are of that opinion say aye. Aye. The ayes have it. The ayes have it. Order. Order. Thank you, Further. Thank you.